It's just gone 9 o'clock, so we'll open the hearing to consider the consent application for the 59 lot subdivision at 68 Franklin Road in Bayview. We'll just introduce ourselves to you. My name's Rob Van Voorthausen. I'm an independent hearings commissioner based here in Napier.
Morning everyone, Annette Brosnan, a commissioner and an elected member.
Kia ora everyone, Richard Blakey, also an independent commissioner based in Auckland. Thanks.
And just in terms of health and safety briefing, the toilets are down the back there. Welcome to use those. If there's an emergency such as a fire alarm or an earthquake, we just proceed through the doors and out the doors that you came through, and I think we congregate in the front here. So there's been a schedule circulated which we will just proceed to follow through during the day. And just before we do that though, to everyone who's pre-circulated material, be it legal submissions or evidence, first of all we thank you for that. It's been very helpful. All pre-circulated material has been read by the panel, so there's no need to read out loud to us anything that's been pre-circulated. That'd be a waste of time because we've already read it. But of course, everyone who's presenting today, be they witnesses for the applicant or submitters, are very welcome to speak to any material that's been pre-circulated, or indeed for submitters to speak to their original submissions and highlight key points for us. How about if we just do some introductions, starting with the council's reporting team over here, if you'd like to introduce yourselves to the hearing.
Hi, my name's Nick McCool. I'm the team leader, resource consent here at the City Council.
Thank you.
Morning, my name is Alison Francis. I'm a consultant planner for Napier City Council.
Excellent. So just before I turn to the applicant, from the reporting officers, anything by way of procedural matters for us this morning? No, that's a good answer. No's a good answer. Right, so Mr. Doesberg, is that how I pronounce your name? Doesberg. So just hand it over to you, maybe to introduce yourself and your team to us, and then just proceed to present your case to us.
Thank you. Good morning, tēnā koutou, Mr. Chair.
And sorry, these microphones, they're live the whole time, so just be aware of that. They don't have an on-off button, and you need to get quite close to them.
Quite close?
So, yeah.
Okay, well, good morning.
Excuse me, sir, it's extremely hard to hear from down here.
That's okay, I can speak up. Can you hear me, sir? Okay. Well, good morning, tēnā koutou, Mr. Chair and Commissioners. My name is Mike Doesberg. I am counsel for Jack Brownlee Investments Limited, the applicant in this case. In fact, rather than myself introducing them, I'll just ask the applicant's team that are sitting with me to introduce themselves.
Sure.
Steve Brownlee, the applicant. My name is Johan Ehlers on civils.
Philip Brown, traffic.
Morena Mark, vinyl planner.
So turning to the applicant's case, thank you very much for the indication that the material's been pre-read. What I would like to do is to just briefly touch on the high points of the legal submissions that we pre-circulated, probably for no more than 10 minutes. I'm very happy to answer any questions as we go through or at the end, whatever your preference may be. And then we'll probably hand over and just run through the witnesses, some of which are here, and hopefully, I can't see your screen, but hopefully some more are online, waiting for their turn.
Yeah, and so that's absolutely fine. Very happy for you to hit the high points on your legal submissions. And what we'll do is, with yourself and each speaker, we'll wait till they finish presenting to us and then ask questions. Just I have a personal reluctance to interrupt people as they're speaking. I don't like that approach, so we'll wait till you're finished and then we'll ask questions.
Thank you for that indication. And sorry, just before I begin, was the panel able to, either all panel members or some panel members able to undertake a site visit, just so I know how much to orient you to the...
Yes, my colleague here undertook a site visit yesterday and is familiar with the site.
I am.
Yeah, and I've wandered around there myself as well.
Oh,
it's
excellent.
easy for me because I live here, so I just...
That's very good.
A week or two ago, wandered out and had a look around, so that's fine.
Okay,
Yeah.
thank you for that indication. Beginning at paragraph 1, 68 Franklin Road, the site would make a very poor farm. It has poor soils. It's surrounded on all three of its landward sides by what I would say is essentially urban development, and that that development separates it from other rural land. It really does sit out on its own. The site is, however, in my submission, ideally suited for providing housing for future residents of Bayview. It's a place that people want to live. It enjoys a pleasant coastal character, and it can be fully serviced with water and wastewater servicing, traffic, stormwater, the whole shebang, no problem. And it's in that context, it's no surprise that the site has had a resource consent for subdivision and development in the past. The applicant purchased the site, indeed, with a 61-lot subdivision consent approved. Regrettably, that did lapse, but after COVID-19 passed, the applicant began the process again of seeking the consent with the application that's before you now. A point I want to emphasise is the previous application was not just simply resubmitted in the hopes that it would still be fine. That application dated to 2008. Significant effort has been spent redoing all of the investigations. You will probably have appreciated from the application the significant work that went into the coastal hazards study by Mr. Dahm, but that wasn't the only piece. Infrastructure issues were thoroughly investigated. Engagement was undertaken with Mana Whenua. Ecological issues were considered. Work was spent, or time was spent engaging with Kiwi Rail on boundary treatments, and we will hear from them later today, I think. And all of the other adverse effects on the environment were assessed, considered, and in our submission resolved. One of the ones I do want to speak to in some detail is the landscape and coastal character matters. Boffa Miskell was engaged by the applicant very early on in the process, and they were involved in design from the get-go. This wasn't a situation where a scheme plan was put forward and they said, okay, now write your report, please. They were involved from the beginning. They reviewed the scheme, provided recommendations, and those recommendations were designed to ensure that the proposal was sympathetic to the site. So you will have seen in Ms. Ryder's evidence that includes the restrictions on where buildings can go, the height of some buildings, the materials and colours that buildings are painted, but it also includes the treatment of that coastal edge. So that coastal edge requires a planted regenerated strip of 7 metres, within which there are restrictions on fencing. The idea really is to avoid the privatisation, if you will. Although it's private land, it's to avoid the sense of privatisation that you get in other places down the coast. And if you saw it on your site visit, the Moore Place subdivision to the south is a good example, where there are a relatively modern subdivision, and if you continue down the road a little bit towards the beach, you can actually look over and see the immaculate, very green as well for this time of year, lawns that front onto the beach. And that's the type of treatment you get without control. When you just subdivide and develop freely. That's not what's proposed here. Here it is going to be a regenerated, sympathetic coastal treatment. Those treatments come at a cost, but it's something that the applicant's willing to bear, both to ensure that this is a great development and a place that people want to live and are proud of, but also to provide a legacy, because this is not a developer flown in from Auckland trying to make a buck. Mr. Brownlee is a tried and true Napier man, and he grew up in the Bayview area, and he wants to leave a legacy. In my submission, the result of that work is a carefully considered and well-designed subdivision with negligible adverse effects on the environment. The Section 42A report and submissions, and I'm at paragraph 6, sorry, will have argue that the proposal will have adverse effects, and the principal focuses on landscape, coastal character, ecology, cultural values and stormwater management, and there's also an issue about tsunami risk. In my submission, there's no credible basis for those concerns. The two independent qualified landscape architects that have provided information for this hearing are in agreement that the adverse effects on landscape and coastal character are less than minor. In terms of ecological matters, the principal issue is in relation to the avifauna management plan, and we say that it is conservative and effective. And I did see this morning, I'm not sure if you've seen it in your emails, but we've had a response from Mr. Markham just earlier this morning. Ms. Seabright has that and is looking at it, and she may be able to address you on some of it, but because it's come in so late, we may not be able to do it fully in our opening presentation, and we'll try and deal with it in reply. But from my view of it, from my read of it, I think many of the things mentioned in that document have already been addressed in other conditions, particularly around lighting, managing domestic cats and so on. And the other matters do seem to be matters of fine detail that are readily able to be dealt with. So my submission is that ecological matters are thoroughly addressed as well. Turning to cultural effects, the applicants worked very closely with Mana Whenua, had obtained a cultural impact assessment and continued to work with Mana Whenua following that process, and that we're very pleased to say has led to a good relationship and has led to Mana Ahuriri in particular providing the letter of support, endorsing the conditions that have been adopted to address the matters raised in the CIA. Stormwater issues have been carefully and conservatively considered, and Mr. Ehlers can address you on that in detail, particularly around the matters that are relevant to the council and its capacity as a district council and with its functions. There will be a requirement for a regional consent from Hawke's Bay Regional Council, and that consent will be sought and obtained, and there is a condition, not that it's necessary, but there's a condition that requires that to occur. And we say the concerns about treatment and discharge matters are matters for the Regional Council, and one that this council need not concern itself with. Finally, with tsunami risk, that matter has been considered, and the evidence and the submissions from the applicant is that there is a safe tsunami escape path 650 metres from the boundary of the site, and that the proposal manages tsunami risk in the same way or better than other coastal development. A tsunami management plan will be produced and provided as part of it's required by the conditions. And either Mr. Brown, Mr. Ehlers, or even Mr. Dahm can address you on tsunami risk matters if you need that. Turning to policy and planning, policy provisions, there are admittedly some objectives and policies of the operative district plan and proposed district plan that are not fully achieved by the proposal. And that's not surprising, given that this is land that is zoned rural and a residential development is proposed. We say that the land has historically been and continues to be wrongly zoned. And I do note in my submissions there, having received this advice from Mr. Brownlee, that the land is actually rated and valued as residential land, yet it's zoned and is restricted for development as rural land, which is a particularly bitter pill to swallow for the applicant. But we're not here to debate the plan provisions. I'm not here to challenge the zoning. We will do that through the PDP process that will follow. This is not a plan change by stealth. This is a bona fide resource consent application that the applicant is entitled to make. My submission is when the policy and plan provisions are properly considered and applied, it's clear that the proposal confirms with them. And by that I mean looking at the matters that the policy and plan provisions are seeking to engage with and protect, looking beyond just their mere text and actually doing the structured analysis of what are we trying to protect here, what are the issues we're concerned with. We say that all of those issues are addressed. The principal ones that come through the documents are productive soils, rural character, and avoiding reverse sensitivity on rural activities. Those are the rural values that are sought to be protected here, and we say the proposal won't have any impacts on those matters. In terms of policy documents, RPS really drives at the same things, and so my submission is the same. We conform. Higher order documents, we say, well, interestingly, the site is identified by the ODP as being within the urban environment. And quite interestingly, when one looks at the maps in Appendix 5 of the ODP, which identifies Appendix 35, identifies the urban environment and the greenfield growth areas for Napier, I think this is the only piece of land within the Bayview area that is within the urban environment, but is strangely zoned rural. It's very odd. But we are in an urban environment. NPSUD applies, and it drives at creating a well-functioning urban environment, which we say is achieved. In terms of the NZCPS, my submission is that none of the avoid policies are offended quite clearly on the evidence, and the proposal achieves all of the other policies. Coastal hazards have been considered to a 100-year timescale, and enhancement of coastal character is proposed. So in my submission, The proposal passes both gateways as a non-complying activity and warrants granted consent under section 104. I am going to move very quickly through the balance of the submissions, they having been pre-read. And I in fact, yeah, just dealing with some of the key topics. In terms of landscape character, the submission is essentially, as I put it in that summary, it's that the experts that are qualified to comment on that matter have commented on it, and they have reached a conclusion where they are entirely in alignment. And with the greatest respect to Ms. Francis, she's not qualified to challenge that opinion. And my submission is that weight should be given to the opinions of the landscape architects over the evaluative planning witnesses with respect. We've addressed ecology. I won't deal with that further, nor will I deal with cultural matters further. Just on stormwater at paragraph 53, just to expand on something I said in that summary, there is a distinction in relation to stormwater matters between what's managed by a district council and by a regional council, and we say that seemingly the principal concern from the engineering report about kind of treatment philosophy and stormwater treatment and discharge, and some of the conclusions in relation to the policy assessment on the NZCPS stray beyond the district council function into looking at water discharge quality, effects on water quality, and similar matters, and we say that's an error, and that you commissioners can take comfort that the district matters have been fully and thoroughly addressed by Mr. Ehlers, but he's here if you'd like to quiz him on it. Tsunami risk at 54. Look, no doubt tsunami risk is a difficult issue to grapple with. It is an effect, or it is a risk of an effect that is concerning because it is, it has a very high potential consequence. There's no doubt about that. But risk is a factor both of consequence and of likelihood of occurrence, and tsunami risk is also something that has a very low likelihood of occurrence. It has a return period in the order of centuries. It's something we need to plan for, but it's something we're not really helped with planning for by the planning and policy documents beyond the obligation to consider tsunami risk and attempt to avoid or mitigate it. We have done that. The application has done that. It has, and in fact, I should say the 42A report, the coastal hazards peer review agrees with Mr. Darm's assessment and work on that. The engineering response seems to expect and ask for that a tsunami plan is prepared and that there are two methods for egress off the site. And that seems to be the key issue we're grappling with in terms of tsunami risk. We have, the applicant's team has gone back to look at and assess that option, both in terms of whether legally and practically a second exit could be provided from the site. The advice from KiwiRail is that an additional crossing of the rail corridor would not be accepted. Ironically, also for safety, health and safety reasons. And in terms of the benefits of such a second crossing, having an access onto Rogers Road will provide a second escape path, but it's a more circuitous escape path. And so even if it were provided, my submission is people would still use the one that is already proposed. It is the shorter route to the high point, which is off the site, straight up Franklin Road and up the hill. Now, I just turn now to paragraph 69 of the submissions, and I just want to briefly address this concept of contrary to the objectives and policies for the non-compliant gateway test. It strikes me that a feature of the Section 42A report is as it works through the objectives and policies to do its gateway assessment, the conclusion is, does not comply with, is inconsistent with, for policies that aren't fully achieved. So I think it's important that we are mindful of what the test contrary to means. It has been, we do love a non-complying activity because it gets a lot of action in the courts. The Supreme Court in East West Link has recently dealt with the non-compliant gateway, and it's confirmed the test from the earlier Dye case that we're supposed to look at objectives and policies as a whole to avoid decontextualizing them and kind of what it described as the kind of blender approach, where you put them all together and you make the stringent ones less stringent and the the not directive ones more directive, and you just kind of put them in a blender. Overall broad judgment is a no-no. Don't use those words, you get in trouble. What we're talking about, though, is looking at the objectives and policies, giving them a fair appraisal, reading them for what they say, but considering them together as a whole. And the test for contrary to, at paragraph 71C of my submissions, it is a high bar. It used to be described as repugnant to, but that's no longer the language that the courts use, but it's being opposed to in nature or opposite to, different to what the objectives and policies are trying to say. So it does demand a careful and analytical approach to the objectives and policies, fact and context are critical. We can't just, I urge you to be very cautious. If you see the word avoid, just kind of panicking and saying this activity can't happen, that's not what the superior courts are telling us to do anymore. They're asking us to look at what we're trying to avoid and, how the effect is managed and whether it is managed to a level that the issue we're trying to address is not impacted. Yeah, I won't bore you with talking about material harm from Port Otago, but that's the pith of the submission is that context is key, but it's a very high bar, opposite to, to be contrary to. At paragraph 80 onwards, I address what I think is the key policy from the operative district plan that is probably that the proposal sits the least well with, and that's policy 3349. It reads, within the rural zone, avoid residential or rural residential subdivision and development outside of the residential greenfield growth areas identified in Appendix 35. So that's the map I talked about earlier that shows the urban environment for Napier and then has specific greenfield growth areas identified. Sites in the urban area, it's not in a greenfield growth area, that's accepted. The policy is directive. Mr. Vinyl agrees that the proposal is inconsistent with this policy, and I think that's a fair concession for him to make in his planning evidence. However, he emphasises the importance of considering that policy in context and concludes that the proposal is still not contrary to, using that non-compliant gateway test, that policy and the related provisions when read as a whole. And I've set out in paragraphs A through C why I agree with Mr. Vinyl's analysis. The policy seeks to implement Objective 33.4, which is to enable residential and rural development in a manner that avoids, remedies and mitigates adverse effects on the environment and the rural character of the environment. So the purpose of the direction to prevent adverse, that's the purpose of the direction to prevent adverse effects on, rural character, and we say that's done. The ODP is a helpful plan in the sense that it provides principal reasons for its objectives and policies. You actually get a bit more context for what the provisions are trying to achieve. And those reasons explain that the key concerns relate to protecting existing infrastructure, protecting productive land, and a concern about compromising the efficient and cost-effective future development. That's why it's driving development into identified growth areas. And we say again that none of those issues apply to the proposal. And then when you look at method 1, which sits again below the principal reasons, it emphasises the importance of focusing development into areas of low or little productive potential, including at Bayview. Bayview is actually listed as one of the areas where development's meant to go in. And so it's our submission that the proposal does protect the values that Objectives 33.4 and 3349 are directed at. Rural values will not be adversely affected by this proposal. And just on that, if you were to read policy 33.4.9 differently and as a absolute directive that a residential or a rural residential activity could not occur in anywhere other than a greenfield growth area, that is a de facto prohibited activity. And if the plan intended that, when the plan was changed to introduce that policy, this activity would have been made a prohibited activity rather than a non-complying activity. So my submission is reading that as an absolute blanket, avoid residential at all costs. Clearly was not intended, and would be inconsistent with that Superior Court case law that I tried to address earlier, in terms of actually looking at context and what the provision's trying to achieve. I do just want to touch very quickly on the higher order direction, because it is so important these days. At paragraph 99, I dealt with the National Policy Statement for Urban Development, and Ms. Francis reaches a different opinion from Mr. Vinyl on that document. And looking at the reasoning in the report, it seems to be on the basis that the ODP and the PDP have not identified the site as being necessary for housing, and because she considers that a plan change would be a more appropriate process than this application. Respectfully, the NPSUD doesn't set those requirements. It sets objectives and policies that are relevant to planning decisions, and the definition of planning decisions includes decisions on resource consents. The key objective of the NPSUD is to establish well-functioning urban environments, and it also sets policies that guide what that means and how that is to occur. Policy 1 details the factors that contribute to a well-functioning urban environment, and it includes having a variety of homes with good accessibility, which we say the proposal aligns with. Importantly, the NPSUD is enabling of planning decisions. It seeks to have councils forecast their growth demand and plan for it, but it doesn't itself mandate that all development in a district or region must follow that pathway, that it must go future development strategy, zoning development. It doesn't restrict it in that way. It just tries to push councils to actually take those steps. So my submission is that we don't have a problem with the NPSUD, and in fact we achieve a well-functioning urban environment with this proposal. NZCPS at paragraph 103, the conclusion from Ms. Francis is that the proposal is contrary to policy 14, seemingly on the basis that the restoration proposed by the applicant to coastal character could be undertaken without the proposal. 25F, tsunami risk. Objective 6 and policy 6C, seemingly because the proposal breaches the plan standards in the district plans. And then policies 21 through 23 due to a desire for more information about stormwater. In terms of policy 14, respectfully, I don't think it's been properly interpreted and applied. The analysis in the 42A report evaluates whether it achieves, looks at the restoration proposal and asks, is this more than could be achieved if the proposal didn't go ahead? And concludes, well, there would be nothing stopping you from doing this restoration. Otherwise, therefore, we're not going to have regard to it. Not only does that set an impossible standard for any applicant, that you have to prove that you're doing more through a proposal than you could have done without a proposal, it's not what the policy requires. Policy 14 is not directive, it's encouraging, the verb is promote, and subclause C, which sets out the things that which could be imposed in consent conditions where practicable, and are a list of possible approaches. They're not a mandatory list. You don't have to do them for every development. And look, frankly, no landowner, perhaps other than a trust who owns land and has a purpose of enhancing coastal land, no other landowner is out there enhancing their coastal environment just because. It'd be lovely if that was the world we lived in, that people would do that, but that just doesn't happen. the benefit here is that if this proposal goes ahead, there are conditions that will require that this carefully designed, detailed planting plan and the management of privatisation of that coastal edge, that kilometre of unbroken coastal edge, will be enhanced. Without this proposal, it won't be. It will stay as a prickly pear farm and a place that people walk their dogs. I've already addressed tsunami risk, but I just want to emphasise that the NZCPS requires that that risk is considered and avoided and mitigated where it can be. And it actually doesn't seem that there's a technical difference between the coastal hazard experts that the mitigation proposed here is appropriate, which is the tsunami evacuation plan. It's just that, how many access points issue. Objective 6 in policy 6C, those provisions seek to ensure that, Objective 6 is about recognising that the protection of coastal values doesn't prevent development as long as it's undertaken within limits. The limits referred to in my submission don't mean district plan zone development standards. It's talking about the limits that the NZCPS itself sets for us. It's adverse effects on Indigenous biodiversity in policy 11. It's character and landscape values in policies 13 and 15. So saying, look, you don't comply with the zone standards, nothing to do with Objective 6 and Policy 6C of the NZCPS. Finally, policies 21 to 33, 21 and 33 are directed at regional council matters. It's coastal water quality and discharges of contaminants to water. So those are squarely within the realm of the regional council. It's for them to manage. And we will manage those issues with them as part of the regional council consent process. And in terms of 22, that policy is directed at sedimentation and about managing land use to avoid sedimentation. The proposal includes conditions requiring an erosion sediment control plan, and I don't think there's any debate about the conditions on the erosion sediment control plan, except that we think there's one clause that's perhaps inadvertently been copied and pasted from a previous set that the council had done in the conditions they've sent us, and I will identify that for you. With an ESCP that implements best practice measures, that sedimentation issue is solved. So my submission is we're totally consistent with the NZCPS. Conditions. I do have a little set of conditions, if I could hand these up to you. I'm sorry that these weren't pre-circulated earlier. 2, 4, 6, 8, 10. There's 10 copies there. Thank you very much. So what we've done here is although the 42A report referred to an Appendix 7 with conditions, none was provided when it was circulated. So the applicant produced a set of conditions that were attached to Mr. Vinall's evidence. The council circulated to us and uploaded to its website a version with comments and amendments. And unfortunately, you might have seen it, all of the changes weren't tracked. So we've done the exercise of in this package here, tracking for you the council's changes, so you can see the difference. So in that version, the council's additions are in red. Mr. Vinall's worked through and he has put either comments on the council's changes or responding to some queries that I think the council had put into the conditions. Yes, and then some small additions in blue. So that's the pack for you there. I'm not going to take you through that in detail. It's Mr. Vinall's job. But there are just two points I want to address you on. Condition, and sorry, because of this exercise, the cross-referencing's a bit stuffed in the conditions, I'm sorry, but we will fix that and get you an updated pack with corrected cross-referencing and addressing any matters that arise out of this hearing. We're going to try and make that as easy as possible for you. But the council's raised a concern about the enforceability of the condition that seeks to require future owners or their tenants that wish to keep cats and dogs when they're at home, to keep their cats and dogs on their property. For dogs, that's not controversial. We do that with our dogs anyway, and I think the dog control bylaw requires that. It's cats that are tricky. However, my submission is that this is an enforceable condition. The council has discretion as to how it undertakes its enforcement activities. It doesn't have to have a monitoring officer outside waiting to see if someone's cat's going to jump over the fence and then, hitting them with an abatement notice. It can take an approach of education or responding to complaints. The other point is this is becoming an increasingly common condition in areas where there are ecological concerns. And where this condition comes from, it was sought by Mana Ahuriri. It was in the cultural impact assessment, and quite understandably, they are concerned about the impact that cats and dogs can have on wildlife. And the applicant recognises that and has adopted the condition. And we say it's enforceable. We say it can be managed appropriately, even if it's just responding to complaints. And the applicant supports the condition.
Sorry, what condition was that?
I've got it condition 75, but I'll just double check. It might actually be 74 now on page 20. Oh, no, hang on. We might be a lot higher in condition numbers now. It might be 84. Here we go. Okay, condition 84, which runs from page 25 onto page 26.
Mm-hmm.
So it's a consent notice to be registered on the title, requiring that requirement of property owners, it should say or tenants, sorry, that classic typo, to confine pet cats and dogs within the property boundaries. Great. And then the last one for me is financial contributions. And gosh, we do enjoy engaging with financial contribution issues because they are tricky. The applicant has applied the plan, which requires that financial contributions are imposed. Those have been calculated, applying the provisions in the plan, and we put those in as a condition. The version that came back from the council kept financial contributions condition, but it just had the value as, XXX, yellow highlight, value to be determined. The position from the applicant is that the value of FCs to be paid does need to be determined and does need to be put into the consent conditions. And the law requires that financial contributions are calculated in accordance with the methodology in the plan. Mr. Ehlers has done that. There is the financial contributions provisions has a section on rural zone, and those FCs have been calculated and put in there. If the council has a different view about what those financial contributions should be, we're glad to hear what that is and to understand how it's reached that calculation, but we think that's the right figure. So my submission to you is that's a matter that needs to be in there and resolved. It can't be left to a later date to be dealt with. Not only would that be inconsistent with the legal requirements for financial contribution conditions, but it would leave it a decision delegated for the future in a way that we're not allowed to do, unfortunately, sometimes, for consent conditions. That's it from me. I'm sorry I've run a little over my time, but I'm glad to take any questions.
Thank you very much for that. Richard, any questions?
Thank you, and thank you for very helpful submissions. I was it's more of a legal issue, but also a stormwater issue. I take it that you agree with the reporting planner or the council that there's a Section 91 consideration and that you would support the deferment of the regional council stormwater consent.
Yes, and part of that is because normally sometimes it is easy to make resource consent, district resource consent subdivision and regional consent go hand in glove, but in a situation where the stormwater, the subdivision consent may change, the discharge consent may change. The proposal's been embarked on this way, and no issue's been raised in terms of deferring this consent. If this was going to be Section 91, we shouldn't be here in this hearing. That should have happened more than a year ago when it was lodged.
Just, I've raised it with you. It's not necessarily for you to answer, but it's just to give the witnesses time to think about it, but it was really around the extent to which a grant of consent to the current scheme plan and engineering plans that are before us might impact the ability for that regional consent to be approved. And I'm referring there in particular to mitigation measures that are referred to, such as swales and rain gardens. They're not before us or shown in the plans, and it was really just making sure that we understand that there is room within the surveyed road and carriageway widths for that to actually occur. It doesn't look apparent at this stage, but I'm sure we'll get some clarification on that down the track.
Yeah, thank you, and that's very helpful to have that signalled. I'm sure Mr. Ehlers will be thinking about that from now.
And just probably two other key points I wanted to raise. Just the discussion around objectives and policies and the overall weighing up of those as to whether they're contrary or not. My understanding from looking at the East-West decision is that it also refers to Akaroa Trust and the ability, and doesn't seem to override that approach where some objectives and policies may be quite important to the overall judgment, even if there might be 30 such provisions that are relevant, but there are some that are of particular importance. I mean, I think you've dealt with the one that's potentially the most problematic, but my understanding is that Akaroa Trust approach still applies.
That's right. The Supreme Court did speak with praise of the Akaroa Trust approach, and it is quite right. The fair appraisal of the objectives and policies as a whole, and not adopting that kind of blender approach, means that you do need to look at each of them, and there will be some objectives and policies that are more applicable and more helpful and directive in terms of a proposal than others. I mean, for better or for worse, district plans are still full of objectives and policies that just say avoid, remedy and mitigate adverse effects that possibly we could do without. And so, you can see why you wouldn't weigh that up against a policy that says encourage this particular activity or avoid this particular activity. So I agree with you. That's right. You still do need to pay particular attention to the wording.
Okay, thank you. And just on this financial contribution aspect, and it relates to a comment you made at the beginning about the situation as between the zoning being rural and the rating being, as you've explained it, to be on a residential basis. Equally with the financial contributions, it seems that because it's rural, does that imply or confer an advantage, I guess I'd call it, about how that applies, because you're able to rely on a rural financial contribution policy rather than the residential, and one maybe imply a greater cost than the other?
Yeah,
Is there some advantage in it remaining rural from that perspective?
I'd need to defer to Mr. Ehlers to answer that in terms of the detail, but my understanding is that it does not. The financial contributions policy seeks to address adverse effects of development by making a financial contribution towards the off-site related costs. And if it were a pure rural FC, one wouldn't expect to see a contribution for wastewater, water, roading, other matters like that. One might just expect, I'm not even sure, but those components are in there. And for Bayview as well, and again, probably something for Mr. Ehlers, but there is also a separate Local Government Act charge for wastewater connections for Bayview of some $23,000. And so, my submission is no, there's not going to be a free ride here by this applicant. It will make the full contribution it needs to the effects of its development in relation to the council's infrastructure. But again, the detail might need to come from the witness.
All right. The other part to that issue is whether there would be a need in that condition to somehow index those values that you've prescribed to any updates to the council's policy, because you've sought a 10-year lapse date for and I appreciate it, that's probably for the last stage, but whether there's an indexing provision in there that if this wasn't to be implemented for 7 years and there was a new policy, and no doubt the contribution values would have gone up in that time, that is then able to be reflected in what is imposed at the relevant point.
Yes, thank you. I'll ask Mr. Vinall to think about that because the FC provisions do contemplate indexing. Yes, we thank you. That's helpful. We'll come back to you on that.
Okay. Just one other more of an observation that I don't. You've referred to the issue of views.
Yes.
And from my site visit, it seems that just the interesting way in which the land lies and the nature of properties in the area. I don't think this, I know it's been raised in submissions. I think you need to be 2 stories to be able to glimpse the sea. I do have a concern at the comment that views aren't a relevant consideration though, because I think the High Court decision in Enor did make that a possible consideration, albeit in relation to infringements of height standards or something like that.
Yes,
but where a development or a subdivision resulted in development that wasn't otherwise anticipated, it seems to me that the High Court approach would apply. So it's really just an observation. I don't think it's critical here, but it could have been, in my view.
It's a very fair point, and it is one that I did try to address the nuance of in my submission. One doesn't have a right to a view, but there's also an expectation that you would accept your neighbours being able to develop their land in accordance with what the plan enables. And I guess 2 things. First, you're quite right. There aren't a large number of properties that have a view over the site. But secondly, I think that's where, if we're going to go down that track, the permitted baseline is quite important in this case. Yes, this isn't residential zone land. We don't have, a de facto 8-metre building plus, height relation to boundary standards. There's a lot of stuff that's enabled that could completely block views from any neighbouring properties. That includes rural sheds, other similar structures. The site, subject to its soils, could be planted. It is. You're quite right. There is that nuance, but if that, and I don't think the issue arises on the merits, but if it does, you do need to have regard to what is contemplated as being able to occur on that site, and the views could be gone, well and truly.
Okay, thank you.
Thank you very much for your submissions. I just wanted to clarify one point, just on the cultural effects. So your memorandum obviously attaches Mr. Boyd's letter from Mana Ahuriri, and that states it supports the application given the proposed measures you've outlined in response to the CIA.
Yes.
So I have a couple of questions. One, can you clarify that feedback was in response to Mr. Vinall's draft conditions that were pre-circulated?
That feedback was primarily in response to Mr. Vinall identifying all of the matters that would be put into the conditions, which he has done. So it was an earlier document that was sent saying, we're going to put these things in the condition, are you comfortable with that? And they emailed back and said, yes, we did that, received the letter. Mr. Vinall participated in all of the engagement and consultations. He can take you through that in detail if that would help.
Yeah, that would be helpful, thank you, because my follow-on question from that is, have they seen a copy of your proposed final conditions, and do they still support, because there's a number of changes, just flicking through this quickly, that may affect the recommendations from the CIA.
Okay, yeah, and Mr. Vinall can address you on that, but my understanding is that the changes that have been made, we haven't made any to the conditions that were supported in the CIA, and dogs and cats is a good example. I think any reasonable developer doesn't want to restrict the potential purchases of a property, but this is important to Mana Ahuriri, and so that's why we are wanting to hold on to that dogs and cats condition.
Yeah, thank you very much. I read that letter primarily as conditional support on the conditions, so I'd like to get certainty that they've seen.
Thank you.
Thank you.
Just got a couple of questions for you, just relating to the Section 104D test. And you don't need to turn to it, but it comes up at your paras 87 and 88. And it's in terms of Section 104D1B. which is they're not contrary to the objectives and policies of the plan or the relevant proposed plan. My understanding of what that means is it's only the district plan. The plan is the district plan. It's not the higher order statutory instruments. You don't have to worry about those, and you don't have to worry about the regional plan or the RPS. It's only the district plan. Is that your understanding?
Yes, that's right. And I didn't address you orally on it, but in my submissions, I include reference to Environment Court case law that confirms that when we're dealing with a relevant plan in that context, we mean the plan under which consent is sought. So it is the district plan, ODP, PDP.
Yep. Okay. And just in terms of the 104D assessment, if we were to find on the evidence that it passes through the 104D1A gateway, effects on the environment being minor, we then don't even need to worry about the 104.1.
No, just one. Just need one.
104D1B test, do we? We don't even have to go there.
That's right.
We can go straight to a 104 assessment. And of course, in a 104 assessment, they're not contrary to test falls away. It doesn't exist. We just have to have regard to the objectives and policies. Is it still correct that in having regard to objectives and policies, we need to give them genuine thought and consideration, but we don't necessarily need to be slavishly bound by them?
That's quite right. Yes, that's right. But they are, some Environment Court decisions describe that 104 assessment as, when you're having regard to policy and plan provisions, they are one criteria among many. That slavish, as you put it, attention to whether we're contrary to the objectives and policies falls away.
Yeah.
It's a fair appraisal and assessment of all of those relevant matters in 104.
Right. I'm just, it's probably not a matter for you, but at some stage just be interested to know how the tsunami evacuation plan will work in practice. Obviously it would be a document, but the recipients or the people who would have to give effect to it are the residents. So just want to understand how that would work. Would they all be given a copy when they buy their lot, and just some practical detail on that? Would that be Mr.
Yeah, we can address you on that.
Yeah.
But that, I mean, that's essentially it. It'll be produced, and there will be an expectation that it's provided in your, you've purchased a lot, here's your welcome pack, and here's your tsunami evacuation plan.
Yeah.
It'll be probably lodged with the council as well, so the council has it. It could even be noted on the land information memorandum if the council was open to that, and there will be an expectation given to lot owners that they would provide that to any future purchaser or to their tenants.
Right. I just can't remember in terms of timing. Obviously, you've mentioned the previous consent that existed for the site for, I think it was a 61-lot subdivision, which has now lapsed. Did that decision maker have to give regard to the same objectives and policies that we have to give regard to, or has there been a change in the plan since then? I can't remember the timing.
There has been a change in the plan since then. The plan, so many plan changes now, I can't remember which number it is, but the plan was changed. That previous application was a restricted discretionary activity. It's now a non-complying activity. And I think at least that policy 3349 came in since then, because that flowed from a change to the RPS, effectively the Hawke's Bay Regional Council Regional Resource Management Plan. So yes, there have been changes, but in the policy framework. And sorry, I should also say, obviously, New Zealand Coastal Policy Statement has come out since then, NPSUD, some other things.
Yep. And just one for the officers, I'm fascinated by this issue that the property is rated as if it were a residential property, which I find, the word I'll use is interesting. I had other words in mind, but I need to hear from the officers about, is that correct, and why is that so if it is correct? It seems quite a strange position to be taken. So I look forward to hearing from the officers about that. All right, that's the end of our questions for you. Where are we up to in terms of the schedule?
I have run you well over time, but I'm sure we will make it up.
That's fine. That's fine. So look, morning tea scheduled for 10:30. So why don't we proceed with your witnesses and see who we get through by 10:30?
Thank you very much. So in terms of order, I've listed the intended order at paragraph 129. So I'll first invite Mr. Brownlee, who pre-circulated a short statement, and he doesn't intend to talk to it. He's here to answer any questions you might have.
Yes, good morning, Mr. Brownlee. So you're happy if we just go straight to questions?
Yeah, that's fine. Yes.
Okay. Any next question?
No, fine.
Richard?
No, I didn't have any questions. It was very clear. Thank you for providing that.
And Ms Brownlee, you get off very easy. I don't have any questions either. Thank you very much.
Thank you. So next we'd have Ms Ryder present, and hopefully she's on the screen, possibly in front of you.
There we go.
Cheers.
Hi. Hello.
Hello,
Yes,
Ms.
good morning, Ms Ryder. Can you hear us?
Yes, I can hear you fine.
Yes, and we can see and hear you. So thank you for your pre-circulated evidence. Not sure if you were listening from the start, but we've received and read that, plus your original landscape assessment. So that's all good. Don't need to read any of that out to us. But of course, as you know, you're very welcome to highlight key points for us if you wish.
I can, very briefly. Commissioners, the main kind of focus of the assessment has been to look at natural character and landscape character. One of the key points that's raised in my evidence and in the assessment in addressing landscape character is I considered that the site represented more what I called a coastal landscape character, and the rural characteristics of that site were less so, and that's pretty much explained through the assessment as well as the evidence. And in turn, that's informed the conclusions that I've made as part of this exercise or part of this assessment. The recommendations, and that was referred to just earlier by Mr. Dosberg, is the design process that we went through. Effectively, we provided a preliminary assessment and then guided the applicant to change the design, moving more away from what I would call a standard sort of residential subdivision approach found further along the coast to one that's more responsive to the coastal character of the area. And in turn, we recommended mitigation measures or enhancement measures to the coastal environment through native restoration planting and management of the visual compartmentalisation of that coast through treatments such as fencing controls, colour controls, and site domestication controls, i.e. how much of the lot can be domesticated. I've spent a little bit of time in my evidence at paragraphs 43 onwards, just responding to the section 42A report. I don't need to review or go over that. I'm happy to answer any questions in relation to that, but I have introduced the scaling of effects, which has been produced in numerous rounds of evidence through to the Environment Court and High Court, and that includes, and that's drawn directly from Te Tangiata Manu, the Aotearoa landscape guidelines, assessment guidelines that our institute apply, and we've applied this scaling, and also it is referred to and agreed to by Ms. Bain, Ms. Megan McBain. And paragraph 50 provides that analysis of where both the peer reviewer and I have reached our conclusions and where they correlate to the RMA terminology of minor, less than minor, more than minor, and or minor. And ultimately, that's enough for me to summarise, and I'm happy to answer any questions that you have.
Thank you for that. Richard.
Yeah, thank you for your evidence. Very helpful. My main question was really just around the landscape plan that is attached to your application report or initial assessment. And
Yes.
my difficulty with that was just the level of detail provided within it. And I wondered if this was to the normal standard of detail that you'd provide for a coastal or a subdivision generally, but in particular a coastal subdivision, which we've heard is meant to provide a detailed and carefully designed approach in this area. And essentially, I think what we have is a one page, and of course, because the site's so linear, it can be hard to fit all the detail in. And I appreciate that what I'm looking at might be the result of some scaling at the PDF stage from probably what was an A3 document. But looking around the site and going to Muir Place, as Mr. Dusberg referred to, where we see an approach that could be said to be sort of privatise that frontage of those lots. Are you familiar with that
Yes,
subdivision?
yes, I am. Yes.
Interestingly, what it seems to have created is something of an esplanade along there, because the fencing stops at a certain point along those boundaries, and then people take great care with the grass in front of them. But nevertheless, you can see the ownership pattern, but it's not highly defined. And when I look at your landscape plan, it seems, in places, it seems to suggest a running of perhaps Pahutakawa tree or something like that down the site boundaries towards the coastal frontage. I'm not sure about that, but just that's an impression. It's not consistent and doesn't need to be, but it does seem to suggest that approach, so that each lot runs towards its coastal boundary and is demarcated one way or the other, and as I say, in some places with planting. You then have dune planting on the northern third of the development, which has got a different frontage condition. Are you able to just explain for me the concept that you're looking to achieve here? Because what we take from here, if consent was granted, we're then reliant on the conditions and what they require, which is a full schedule of plant species and maintenance and all those usual things that we get.
Correct.
But what is the conceptual approach to how you're dealing with this coastal frontage? And as I say, I think we'll end up with two quite different outcomes between the public space to the north and the individual sites to the south.
Yes, okay. Well, I think your question sort of largely focuses to those individual sites, or the
Yes, that's
properties at the south, sort of lots 19 through to 48. The focus there was to introduce some planting. We wanted to, tree planting, and referring to Pahutakawa and the like, that was placed in a position that didn't appear sort of demarcating every single boundary. So you'll notice that not every boundary is demarcated by tree planting, and it's positioned in a way that we've shown it stepping in and then stepping out. So it has a more naturalized feel to it. The dune planting immediately to the front of it is of the lots, and running up the boundary of the lots, the method of trying to integrate what is a natural coastal edge into a standard, not standard, but sort of call it a linear approach to residential subdivision or lot development that applies across multitudes of development and property ownership in the way in which properties are surveyed and demarcated out. So we've introduced that into the design, so that the boundaries themselves, along with the fencing controls, which you'll see in the same drawing, shows a post and rail running up to the across the first 10 metres of that property, so that the property itself isn't running close-bordered fences all the way down to the coastal edge. And as you know, the Mer Place properties have obviously enabled that esplanade reserve along the front through a grassed sort of edge, versus here there'd be a more demarcated and shown walkway along that coastal edge within the esplanade reserve. So we see that as happening outside of the private properties as can be as it's planned, but the dune planting would continue on into that esplanade reserve all the way through to that frontal dune edge. I think the plan needs to be read in alignment with the recommendations that sit within that assessment report as well. And that also, I think that sits in, I'm just scrolling to that at the moment, but that sits in section 7.1, page 15 of the landscape assessment, where it refers to the preparation of a landscape management plan. So going back to your earlier question around, is this the sort of level of detail that's provided? Typically, yes, you can have a sort of high level, what we call landscape mitigation plan, that's prepared with a series of outcomes. And I'm happy to further articulate those outcomes, i.e. the density of planting, the typology of planting and the like. But we've referred to here saying planting plan including indigenous coastal species, grades, planting densities and quantities. A specification will be prepared, long-term management of that. These are the landscape management plans methods that are used quite commonly. Sometimes they are produced at the time of the application. Sometimes they're produced afterwards. In this instance, we've recommended it as a condition that would be produced and would have to form part of the engineering approval process for the subdivision. So the indications of what the plant species isn't there, but that we could quite happily provide that if that assisted the panel to have further certainty of the typology of planting.
I suspect that what's missing is perhaps, or for a start, what's missing for me is perhaps a copy of the original plan, so at its original resolution, because I simply can't, if I zoom in on it, it just gets worse.
Okay.
So
okay.
there might be
Right.
detail that comes across through that, but then that plan at least needs to be referred to in the conditions, at least as a
Correct.
starting point. Either,
Absolutely.
that's not necessarily for you, but whoever's going to be, perhaps Mr. Vinyl, in terms of
Yep. reference
to it as the starting point. And then we need to know what that looks like if we're going to rely on it as a starting point. And then I think it's all very well to say that the planting plan will include all these things, but there's no standards or minimum densities or anything like that a compliance officer or anyone certifying the plan could fall back on. So I think the detail needs to come through along with, as you say, the conceptual approach, what the strategy is, so that gives the plan some measurability against what your intent was for it. So I think the statement that you referred to earlier, somehow bringing that into the condition, or even as an advice note, would be helpful for the future when someone's trying to measure whether the plan's giving effect to what your intent was.
That's absolutely possible, and I can provide you a high-resolution copy of the landscape plan, and also as a means of, in response, provide you a clear design statement and the detail that's necessary to rely upon that for the production of a landscape management plan.
And I think that plan too, just for the dune frontage, needs to probably acknowledge the reality that people will want their own access direct from their property to the beach. It's hard to imagine that won't happen. And so I think you're probably best to provide for that within the plan rather than being surprised when it gets trampled over after all the good work that's done at the planting stage.
Yeah.
The other part...
Typically...
Sorry?
Oh, sorry, I was going to say typically we would create shared ones between properties so that they're not individualising culmination, so reduce the number.
Yes. And the other part to that is just really the street planting approach. You've shown some specimen trees along the road, and again, might be, I appreciate this would be something finalised at the engineering plan approval stage, but some minimum outcome that you're looking for, I think, should be specified there.
Yes,
And
normally...
That's going to combine with whatever the answer is to the stormwater management within the road reserve, which is a question for a response that we'll hear later, but I think you'll have a role to play in terms of the outcomes for that and how that's incorporated into the conditions as well.
Okay.
For example, those specimen trees that you show, they might be in, I forget the technical term, but in planter pits that serve a stormwater function as well as an amenity function.
Yes, and with the rain gardens. Yeah, that's right. Okay, well, once we've heard from that expert, we can respond in kind. I mean, I haven't particularly relied on the street planting as a landscape mitigation measure. I've more turned to what the city's development code would say. However, if that correlates to provide more certainty for the stormwater outcomes as well, I can certainly do that.
Yes, well, what I'm conscious of there is that you might have drawn those trees in the plan, and if that plan does become a condition 1 type reference, could cause issues when if they can't be provided for some other reason that was engineering related. So
Okay.
just the need for coordination there. I mean, I think the landscape plan, the strategy does have well, no doubt the intent to draw together what will be quite disparate development forms on each site, because people will take their own individual choices to that. And the landscape plan has the opportunity to sort of pull all that together, which I'm sure is what you're aiming at. But it just needs more detail, in my view, at this point. Thank you.
Good morning, Ms. Ryder. Annie H. Brosnan here. Thank you very much for your evidence and the pre-circulated evidence as well. I just, with your expertise, wanted to provide you an opportunity to address us on that overarching issue, the main point of contention being cumulative effects. I know you briefly cover in paragraph 15D and 56 in your conclusions, but I just wanted to give you an opportunity to address us in that, because we do have a difference of view there between reporting officers.
Yes. So the landscape assessment itself also addresses cumulative effects separately within one paragraph, but you would have seen that. The key thing within cumulative effects is actually looking at which point we are adding to or reaching a tipping point within a landscape. So from a landscape perspective, in Te Tangata Manu, our guidance document also refers to that. But this particular site in this particular landscape, so we're not looking at it just in isolation of the site itself, but its context, is that it's not adding to or extending along that coastal edge residential development. It's sitting well contained within and surrounded on all three sides with residential development. It doesn't just sort of eat away or continually sort of provide an indication that there will be continual residential development into the rural landscape. Because this rural zone, as you've heard earlier, is sitting it's surrounded on all sides by settlement, it seems to, what we've looked at it is said, well, is the change in this landscape or that particular, what's the effect of that landscape effect change? And then also, what is has this change reached a tipping point at which that you've ultimately created a comprehensive or cumulative, as the term is, adverse effect that's just unmanageable, unmitigated, you can't mitigate it, and it's at a point at which it's started to detract from the wider coastal environment and in particular, in this instance, the rural landscape. So we've addressed that quite carefully. You've still, when you're looking at those cumulative landscape effects, you still need to come back to have what are the effects of on the landscape character of that particular area, and we've gone through that in quite a reasonable amount of detail.
Thank you very much.
Ms. Ryder, I've just got a high-level question initially, but to give context for the question, do you have your landscape assessment handy, the report?
Yes, I do.
And
Yes.
can you turn to Appendix 3, please, which is the landscape plan that was being discussed earlier, I think.
Yes.
And so just a high-level question. In your expert opinion, if this development was to occur in line with that landscape plan in Appendix 3, in layman's terms, if you can, how would you compare it to the existing environment typified by the existing coastal residential developments, one to the south of Gill Road and two to the north of Franklin Road? Like, what would the overall outcome be here compared to what's already there north and south of the site? Just in lay terms, if you can.
In lay terms, you've got a development that's responding, and this is the intent that we had, to the natural patterns of that coastal edge. So from our sense, the pattern of development is consistent in terms of housing development, placement of dwellings. Obviously, they're driven by the coastal the coastal hazard line is an indicator of where the dwellings themselves can be positioned. But this particular one is looking to try and enhance the coastal edge. It's relatively unmanaged at the moment, and in my view, the enhancement approach with dune planting or coastal gravel dune planting and the like and equally for the northern section, is market change. And I think compared to the development further north along Rogers Road and equally Mur Place to the south.
So in your view, would it result in a superior outcome in terms of landscape character compared to what's already there north and south of the site?
Not to use the word superior, but I would use the word improved, yes. Yep.
Now, just a question, looking at that plan, lots 1 to 18 have a road in front of them and then a reserve area that's planted up with access ways through it. And I understand that's because that's a council reserve, is that correct? Yep.
Correct.
But then the road sort of veers inland and then we have houses. We have a road and then houses in front of the road. A lot of coastal developments that I see around the country don't do that. They carry on with the pattern that we see from lots 1 to 18 where we have houses, then a road, then a reserve. Mount Maunganui, for example, the more recently developed parts of it are an example of that, where there's houses, road, and then a wide coastal reserve.
Yes.
What was the rationale for not doing that here?
That it was in response to linking in with the pattern of development to the south a little bit in terms of housing having some frontage to the coastal edge. Preferably, yes, you could have that development, the coastal reserve running all the way along the front with the road running along the frontage. This creates an opportunity as well for housing to have some coastal frontage. Other than that, there's not a driver. I wasn't overly concerned with the placement of those houses. Obviously, we are controlling the height of the houses in this area, so that's why we've said yes, we can accommodate some houses roadside or coastal edge of the road. However, they have a series of design controls on them so that they're not overly dominant given the positioning of them.
Right.
Mm.
And so just in terms, again, of that landscape plan, my reading of the conditions and the numbers have changed now, but in terms of the condition numbers that were the conditions that were handed out to us this morning, condition 75 to me says that the landscape, the planting that's shown on that landscape plan, the planting will be done by the developer rather than the individual property purchasers. Is that correct?
It's my understanding, yes.
Okay.
I haven't got a copy of what you have in front of you.
Right, okay.
So.
And the condition relating to the landscape management plan, which is now condition 74, I think it was 68, it's got a 68 crossed out next to it, is to be submitted. Should it be submitted for council certification or just submitted?
Normally, you'd have them certified,
Yeah.
yes.
If it's to be submitted for certification, often consents that I'm familiar with will have an advice note detailing the purpose of the certification. Of course, conditions can't bind the third party, namely in this case a council, so the condition can't tell the council what to do, but an advice note could say what the purpose of the certification is. Are you able to develop an advice note for us in that regard?
Yes, I can work in with Mr. Sarau.
Yeah. And now just looking, there's one other condition. It was number 70, it's now number 76, and it relates to the street trees that are to be planted. And not sure if you're familiar with that condition. It talks about having them in tree pits, planted during the planting season, says how big the planter bags have to be, etc., which runs to A through N, which is a very detailed condition, but it doesn't say what sort of trees are going to be planted.
No, and I think that we can provide detail to that as part of that response to the earlier Commissioner's question.
Okay.
Yes.
So what trees did you have in mind? I can't recall.
I had in mind native coastal species trees, i.e. Pohutukawa and the like, so we would be looking to mimic or at least reflect the effort that's been taken for the dune enhancement and native vegetation. So we'll be pushing towards the indigenous species.
Yeah, and I think in terms of the coastal areas within Napier, both north and south of the city, I think the city council itself plants a lot of Pohutukawas, so that would be consistent with the overall citywide approach, I think. So
Yes.
maybe if you could look at that as well, just that condition.
Yes.
But that's all the questions I had. Thank you very much.
Okay.
One more thing, just
Thank you.
Sorry, Ms. Rose, just one other question about the landscape plan. Relates to the road alignment question, but it's the resulting areas of triangular land, which in the scheme plan is shown as part of road to vest in the council, but they're obviously residual bits, if you like, on the outside of the curve, and again, on a bit of coastal frontage next to lot 19. So it's two triangles, one next to lot 18 and one next to 59, and another bit next to 19. And appreciating it there to be vested, but is there an intent to do something with that land as part of the overall land development? That it seems to me to be an opportunity to provide some landscape presence, or is it intended that they might be passive reserve areas or just leftover grass that has to be mown?
Yes, so certainly between lots 18 and 59, I haven't turned our mind to what the purpose of those would be. They're not typically something that we would, they're not outcomes that affect the assessment. However, they could certainly contribute to small pocket park sort of approach for the community there. Equally with the one adjacent to lot 19, just to the north of that, we do see that as a passive space. There is a number of, I guess what you could say, organically made passive spaces, picnic tables and the like already within the site. So the community already starting to access the private property and enjoy its some of the open space areas within that and the views out to the coast. So rather than closing that entire coastal edge up with native planting and end up fighting that battle from a community wanting to have some places together along the coastal edge, we've provided for that in a small sort of pocket park adjacent to lot 19. That can be worked in with council, in the development of what that might include, but we've allowed for that space.
Okay. All right, thank you very much.
Oh, look, Ms. Ryder, I had one I forgot about, sorry. Just looking again at that Appendix 3, do you still have that up in front of you?
Yes, I do.
Yeah. So where does the shared path go? Is that to the left of the coastal planting on that cross-section there?
Yes, yep, yes it is. It's so that sits to the if you look at the plan view, and what we can do is provide an updated section or small and enhanced plan view of the coastal walkway that we've indicated along the coastal front there. So, yeah.
What I'd appreciate receiving, and you don't need to look at it now, but in Jim Darm's evidence, he has a figure 4 where he has a typical cross-section going right from the railway line down the beach and out to sea. So what I'd appreciate is you taking your cross-section that's shown there in that Appendix 3 and then talk to the engineers and Mr. Darm and take into account the proposed earthworks and then superimpose what you've got in your Appendix 3 on a blown-up version of Jim Darm's cross-section, just so we can see how it fits in with what's there now.
Yes,
And
no
then that
trouble.
would give me a better feel for how it relates to the seaward toe of the bank and other matters like that.
Yes.
I think that could be done. That would be helpful. All right, I think that's all we had for you. So, Mr. Dosberg, should we now break for morning tea? Is this a good time?
I think so. The next witness would be Ms. Seabright on ecology, and I expect you might have more than one or two questions, so perhaps we break now and not to interrupt.
Yeah, that's great. So just looking at the schedule. How long do we have? All right, so we'll break for 20 minutes and reconvene at 11:15. So, Mr. Peterson, are you able to hear now?
Not very well.
During the morning tea, you're welcome, with the help from the staff, to bring your chairs 10 feet forward. If all of that row of chairs can come forward so you're closer to us, and that may assist, then you're very welcome to do that.
Thank you.
Okay.
I thought a technician might be able to turn the volume up.
Well, maybe we could do that as well.
Thank you.
All right, we'll adjourn for 20 minutes. Thank you. hearing. If you take your seats, please.
Great. So hopefully soon on the screen we'll have Ms. Seabright, and she provided a summary earlier in this week, which thanks for the indication that has been read. So
Yes.
I'd suggest she just moves straight to questions unless she's got anything she wants to speak to.
Morning, can you hear me okay?
Yes, we can, but we can't. There we are. We can see you too. Can you see and hear us all right?
Yes, I can see and hear you. That's fine, thanks.
Excellent. So council has suggested, because we've pre-read your evidence and your summary, which was circulated, we've read that. He suggested we go straight to questions. Are you content with that, or would you rather summarise key points?
That's fine, thanks.
Okay. Any questions?
No, I'll just. You, yeah, go there.
You want to go first?
Okay.
Yeah.
Right, good morning. I only had a couple of questions, really. In terms of the likeliness of this being a korora habitat, it struck me that, I think you mentioned that the port breakwater is a habitat or a known habitat. I wondered what the attractor would be for this site. I mean, no one can ask the birds themselves, but what would be the attractor to this site when they have that port facility? I know rock walls are often a better environment or perceived as a safer environment for them.
Yeah, that's correct. So Napier Port, there's in the order of about 90 pairs of korora, little blue penguins that nest in the rock revetment there. The site itself here, I have described in my evidence, I do believe it to be quite marginal habitat. It doesn't provide any rock structures. There's no sort of driftwood or other structures really that they could nest under. I think the only habitat it potentially provides is some of that shrubland could maybe be dense enough to support some penguins. I didn't observe any when I was on site, but just based on, some of the submitters have mentioned penguins and based on the finding of one penguin nest box when I was on site, it's potential habitat. I don't think it's super ideal or great quality habitat. As you said, there is a port nearby that has better habitat, but just wanted to be conservative and say it is potential habitat.
Yes, and part of that, what also occurred to me on site is just the distance from the water's edge to that type of vegetation. Is that consistent with other habitat in other areas of the country? It seems quite a long distance.
Yeah, no, you're correct. It is quite far away and it is exposed as well. A lot of other penguin colonies in New Zealand, they're in rocky areas generally, and they're very close to the water. I think that is probably something that may hinder birds coming into the area. And as I mentioned in evidence as well, it is quite a rough sort of coastline. The waves in that are quite strong. And I did wonder if that too could potentially prohibit birds or hinder them a little bit coming to site. But as the submitters have mentioned that there have been some sighting of penguins in the area. So it's not to say that they aren't there. So yeah, just being conservative and saying that they could potentially use the area. Yes.
And just the other question I had for you was just in relation to the avian management plan, the dates that it talks about in terms of avoiding works at 4.1.1. I wondered if those sort of restrictions, which work in one sense in terms of key breeding seasons and so forth, might imply pushing earthworks into winter seasons or winter periods. Is that something that is considered as part of that, part of determining those works-free periods?
Yeah, so I've used the breeding seasons for the key birds of interest to determine, it's a recommendation. It's always best practice to try and avoid doing works during those breeding seasons if you can, but acknowledging that it's not always practicable. As you say, it could be during winter work. So it's always avoidance is the first recommendation, but then put steps in place to manage effects if works do then need to occur during those other periods.
Okay. All right, thank you.
Yeah.
Any questions?
No, comfortable, thank you.
Okay, I've just got a couple of questions arising from paragraph 33 of your evidence.
Yeah.
So just looking at paragraph 33, clause A, avoiding where practical, enabling and construction works during this breeding and molting seasons of these birds, which collectively say there is 1 June through to 31 March, which only leaves April and May for the developer to do any work on the site, which is an extremely short construction period and not very practical. So likely that works will be wanting to be undertaken outside of that period, and is that when the provisions relating to pre-work bird surveys, etc., click in?
That's correct. Yeah.
Okay. Now I'm interested in 33C, and Mr. Markham addresses this as well. Avoiding lighting at the project site at night time. In my experience with this kind of matter relates to the west coast of the South Island and around Punakaiki and the mineral sands mine there, where lighting was one of the key issues in terms of protected species of ocean-going birds down there. What's the intent of avoiding lighting? Is it to avoid grounding of airborne birds? Or what's the purpose of avoiding lighting?
Yeah, that's right. There has been records of some disorientation, and there's been some birds that have been killed or injured as a result of lighting. These are predominantly seabirds, so things like petrels are particularly susceptible.
Yeah.
So the recommendation is, to avoid lighting if possible, directing it downwards. I just note as well that there isn't any intention to light the coastal margin that's going to be revegetated, so that would be a light-free zone. I believe that's in condition 74J.
Yeah.
Maybe different numbering for you now, I'm not certain. And also just noting that some of the exterior lighting on the houses as well is going to be recessed, so it should be pretty light sensitive. With definite controls in place to try and minimise lighting where possible. But I suppose just noting that the site is surrounded by residential areas, so there is lighting in the area. It's not going to necessarily be a new thing. Yes.
Yeah. Yes, just want to explore that a little bit further too. Are the birds, the seabirds that might frequent this site, are they prone to grounding?
No, I'm not concerned about the red-billed gulls or the variable oyster catchers or those species or the penguins necessarily, but it's just a sort of holistic approach. Just because it is a coastal environment, that does make the most sense to manage those potential lighting effects.
Yes, but mitigations need to relate to effects. So if there's no potential effect to mitigate because the seabirds that use this site aren't prone to groundings, what's the concern?
Yeah, I suppose so. The management plan has focused on birds that breed and molt in the site, but I suppose the effect could be slightly widened out to coastal birds wider in the oceanic environment adjacent to the site. It's sort of just taking those birds into consideration, if there's a gannet flying by or whatnot.
Yeah. Are there any records of seabird groundings along the coastline to the north and south of this site that you're aware of?
Not that I'm aware of. I haven't looked into that. I'm not certain.
Right. And the fact that there's development to the north and south of the site with lighting in existence, and if this site was to be subject to lighting controls, what would the overall effect be on seabirds, given that there's already lighting in the immediate area anyway? I mean, I guess where I'm trying to understand, would what you propose actually serve a useful process, or is it just a box tick?
I suppose because there is lighting in the surrounding area, we're only sort of talking about approximately 1 kilometre long stretch that doesn't currently have that sort of lighting. It probably wouldn't have a huge effect, I would say. But I suppose I'd just like to note as well that I've just prepared an avian fauna management plan for the project without an ecological impact assessment to base it upon, because one wasn't required for this assessment. So I haven't looked in detail into those potential effects, but just included what I thought could be a possible effect to address.
Okay. Yeah, just looking, still at paragraph 33, and if we just get my numbering right. I was just interested in how would condition H work in practice?
Sorry, which condition, sorry?
33H, so we have to set a setback distance, and then
Yep.
you have to, and then the condition, what you suggest goes on to relate to noise levels. So
Yes.
you'd need to set up a noise monitoring machine next to the
Yes,
nesting
that's
site,
correct.
and constantly monitor that. And if it got too noisy, then adjust the operation of the machinery or make it move further away. Is that?
Yeah, that's right. So you would do that at the start of particular construction activity. So you would determine what the noise level is of that activity, and then the setback, you would put it back so that the noise level at any active nest would be less than 70 decibels. And that should appropriately, manage effects on potential birds that are nesting, korora specifically. And then you can also implement some noise mitigation measures. You could put in noise barriers or whatever. And then just do monitoring just to make sure, if there's any changes in noise levels, that's appropriately addressed and the setback can be adjusted as required.
Yeah. So does it utilise a a noise modelling approach? Your classic acoustic assessment with noise contours from the source of the noise propagating outwards. Or is it just a trial and error thing where you say, look, we'll set up a noise monitor and we'll measure the noise, and if it's too noisy, we'll just move the machines a little bit further away? Or do you do a noise model to start with? How does it work?
Yeah, it depends. I think for some projects there have been noise models have been produced, but you can also just do it. You have your activity, you measure it, and you just move back and forward as required. So sort of like a one-off noise, for a shorter period of time isn't necessarily a concern. So you could, if you are too close for a short period of time, then you can just adjust it by moving your piece of plant further back. So it can just be done on site when you're there. But you could also model beforehand if required, but that would still need adjustment when you're in the field, just to ground truth with the particular plant that you're using.
And just the last query, on your paragraph 33, clause N, Romans 4.
Yes, yep, I'm there.
Yeah. So if little blue penguin burrows are detected, then the SQEP has to contact the council and discuss and agree measures to undertake to offset the habitat loss and find a suitable location for it. So how's that going to work in practice?
So what the intent there is, so you do a survey in the season in the breeding season, before works are proposed to occur.
Yeah.
Because at the moment we don't really know how many birds we're talking about if they are nesting on site. So we want to determine that by doing a survey, and then the quantum of the offset would then be commensurate to whatever you find on site. And so because I don't know if there are penguins there currently, I'm being conservative and assuming they could be, but I don't know how many, I don't know how big this offset would need to be at this stage. So that's why it would require a discussion with Napier City Council to come up with a plan to determine where this would be, and then what the quantum of the offset mitigation would be, and then the requirements all around that with regards to planting and putting in nest boxes and predator control and all of those sort of measures.
Yeah.
Yes, that's why there's a bit of uncertainty there, but it's because there's current uncertainty.
Yeah, sure, I understand that. I'm just kind of wondering how it would work, though. Where would this offset most likely occur? I mean, there's a penguin sanctuary at the Port of Napier in their breakwater and rock revetment structures. Is that where you're target, or would you look to find a bit of council reserve land and plant it up to make it nice for penguins? Or how would it work in practice?
Yeah, so I think Napier Port, that would be too far away, and that's, as you said, it's already a sanctuary, so I don't know if there would be any room to provide additional habitat within that current sanctuary. But my thoughts are, if it is possible to do it on site within that planted strip in front of lots, or the proposed planted strip between 1 and 18, if it's possible to do it there, but alternatively somewhere close to site, even possibly just across the road, Lekesney Place. I haven't looked into this in detail, but somewhere nearby where there is a coastal area, that would be appropriate for penguins. That would be my thought.
Yeah.
Keeping it nearby, on site if possible, or as close to the site as possible. And in an area where it can be planted, there can be predator control and there's sufficient room to put in nest boxes.
Right. And so that would ideally be on public land?
It depends. I think it would need a conversation with council to see what would be possible, I think.
Yeah, okay.
My preference would probably be a reserved area, but yeah, it would need to just have a bit more look in detail to see what's around and then determine what would be appropriate.
Yeah. So just a high-level question. In terms of your experience and the work you do nationwide, I assume, how would you rate this strip of land in terms of it being an avian habitat? Would you say it's, really, really good, excellent, average, poor, mediocre? What would be a word you'd use to describe this site in terms of avian habitat?
I would describe it as modified. When I went to site, it didn't strike me as providing particularly good habitat. I thought it was marginal quality just because of the disturbance that the site currently is exposed to with regards to informal walking tracks. I saw people with dogs both on and off leash. There's evidence of quad bike tracks. The vegetation is predominantly exotic and a few other factors, but yes, it didn't strike me as particularly good habitat, the site itself, but the foreshore, I would say that is potential habitat for some of those other bird species, so red-billed gull. It is a nice continuous stretch of beach. There's lots of driftwood. Again, it is subject to disturbance from people and dogs. So that probably has more habitat quality, but the site itself, it didn't strike me as being particularly good.
Right. So from your experience, the foreshore is reasonable habitat and the inland vegetated area less so. Little blue penguins, they wouldn't burrow on the foreshore, would they?
No, they
No,
wouldn't. No,
okay.
no,
To
they
be in the
need
scrub.
a sheltered area. Yeah, it needs to be above mean high water springs,
Yeah.
above the high tide line. Yeah, sheltered.
All right, no, that's good. Anything following up?
Thank you through you, the Chair. Just a minor comment that the general conditions that reference this report circulated this morning, I think, has an incorrect date of 4th of November, which should be 20th. Thank you.
Thank you.
And one?
Oh.
Yeah.
I just wondered if you had any, I haven't had it for very long, but did you have any comments in response to Mr. Markham's response to the AMP that was received this morning?
Yeah, good.
Yeah, as you say, I haven't had it for very long. I have had a read through it. Sorry, I'm just trying to find it. Yeah, I haven't fully considered everything yet, but I guess I would note that some of the factors in there are already covered in the consent conditions. And I think some of the other things are relatively minor, and we can just adjust that via an amendment to the avifauna management plan. So, for example, so I've just got it up here now. With regards to lighting, I think we've largely covered that by the fact that there's a condition stating that there'll be no lighting in the coastal margin, so there will be a dark zone for birds. And in the management plan have recommended it pointed downwards, shielded, that sort of thing. With regards to predator control, I have included feral cats in the management plan as one of the species to target. And the predator control is proposed to extend the full length of that coastal buffer. What else did we have? Disturbance was raised in there with controls on domestic cats. And as was highlighted earlier, domestic cats are required to be confined within property boundaries. I think that's already covered in conditions as well. Yeah, that's my comments to date. I probably need a little bit more time to consider the rest of it, but that's a bit of feedback there.
No, I appreciate that, and you haven't had it for long, but we did hear it might be covered in reply, but just wanted to see if there was any expertise on those matters you wanted to bring forward. We have talked about the cat and dog management provisions. Have you seen controls like this anywhere else around the country? I mean, I think it can vary between a full ban to nothing. Here, there's an attempt to manage them through keeping cats within properties. Is that something that's likely to be able to be achieved, in your view?
That's a good question. I mean, I'm not a cat expert in any
Okay,
way.
all right. So
Yeah, I'm not sure that's outside of my area.
I'm relying on your general ecology hat,
Yeah.
but I appreciate that it's not your area, so that's right.
Yeah, sure.
Thank you. Okay.
All right, thank you very much for answering our questions.
Thank you, Commissioners.
Thank you, Commissioners. And another face on the screen, we'll call Mr. Jacob for acoustics next.
Good morning, Commissioners. Can you hear me?
Yes, we can. Can you hear us?
I can indeed. Thank you.
All right, so I'm not sure if you've been listening this morning, but thank you for your pre-circulated evidence and also the reports that preceded it, which we've read. You don't need to read your evidence out loud to us because we've read it, but you're very welcome to highlight key points from it if you would like to, or alternatively, if you're content, we can go straight to questions. That's very much up to you.
I'm happy to go straight to questions if you prefer, or if you'd like me to highlight some main points. There are some I'd like to make, but
Well, if you'd like to highlight some main points, why don't you do that, and then we'll take questions after that.
thank you, Kanda. I appreciate that. The one thing I wanted to mention in the beginning, and that's noted in my summary of evidence in terms of acoustics, is that we have to look at the effects, both subjective and objective, which means the fact something complies does not necessarily always mean that the effects are de facto accepted, and the reverse is true. So you note in my evidence, I've gone through every element of noise received and generated, both in terms of compliance and effects, received and generated. So the couple of points I wanted to raise in terms of the site specifically, the noise received by the site, it's basically the train tracks that are in front of it. And there are a couple of flags that we have usually to raise next to trains, which is, they're basically 3 Cs. One of them is a curve in the track. The other is clay in the road. And the third is contours, specific contours that cause more propagation of vibration in the ground. The site has none of those. The ground is gravelly. The stratigraphy of the ground has gravel. The tracks are straight. And the topography is going to include a gravity wall, which usually dissipates vibration. So it's a typical residential development next to train tracks. KiwiRail are very specific. They have their own guidelines, which, if followed, result in very comfortable living conditions. The noise levels that they require are typical of any residential development where you're absent a train track. And achieving those levels internally is pretty common. Even if it was a single dwelling, the recommendations would stand, the type of walls that we build, the glazing, the mechanical ventilation. So that's achievable very simply. And I note that the conditions 86 to 87 make effect onto that, so that any building in that area is going to protect KiwiRail from reverse sensitivity, which is people moving in and starting complaining about them. And it protects the residents from the amenity of being next to a train track. The other one I want to talk about, which is the noise generated by the site. The site is residential. Again, what we look for in residential developments as flags in terms of noise is if there's a pool, a communal pool, if there's tennis courts, a communal area for barbecues, we usually start requiring noise management plans for that. So you can't have 500 people there. You can only have a certain number at a certain time. This development is simply lots and houses. And these houses and lots have to comply at their neighbors before they comply at the existing dwellings at more than 25 meters. So it becomes a matter of enforcement of compliance and more so between them than to the existing dwellings. So other than that, in terms of noise generated by the site, I note there's a pump proposed next to, a wastewater pump proposed next to lot 18. And each of the lots is going to have its own mechanical services and potentially refrigeration, HVAC. Those are really a matter of design. So when the detailed design comes in, they have to comply. So as long as they're managed and designed properly and located properly and shielded, I see no issue. It's very common and popular, and the distances involved, which again, I note they have to comply between them before they comply at the farther dwellings. In terms, the one thing that was raised in the submissions, which I think the Section 42 area report from Council also noted, was the noise generated by traffic, the increased traffic. And I got into a bit of detail around that. And just at a high level, I'd just like to note that from a compliance point of view, we do not reach the threshold of volume for compliance considerations. The volume total, including existing traffic, would reach 1,500 vehicles a day. The threshold for the national standards to kick in for cumulative noise from traffic is 2,000. Below that, it's an assessment of each individual car. So the compliance part is out of the way. So we started looking at the effects part, and I noted the residents at number 1, Lequesne, were concerned about traffic coming out of the intersection, accelerating and decelerating. So I just wanted to note here, outside of what the evidence says, I took a highly conservative approach of assuming the existing traffic coming down Franklin Road and then up Lequesne is ideal. So whoever's driving is an experienced driver, they start slowing down or braking well before the curve, the 90-degree curve, and then start accelerating well after it, or they take it in a very calm, consistent speed. So we don't have the alarming noise of accelerating, braking. And then to compare that, we used a younger driver at the intersection, accelerating aggressively on a gravel part of the road to see how the noise differences would be. And even at that worst case scenario, basically, of comparing one type of car to another, existing versus introduced type noise, the difference would barely be noticeable in terms of audibility. So if you're sitting inside the house and one car is passing by normally now versus a car accelerating out, you'll say, yeah, it might be just a bit louder. Under normal circumstances, however, you get younger drivers braking quickly, accelerating quickly. That would not be much different to a car exiting or entering the site through the intersection. So I don't think in terms of compliance, it complies by default, but in terms of effects, it's not material, in my opinion. The last one I wanted to mention very quickly, and by the way, I note in terms of the traffic, there is one thing I recommended the team add to the conditions, which is an advice note for council when the road is being designed to look out for irregularities. So that would be the one risk I see if somebody decides to put a speed calming device out in front of the intersection, or put a manhole cover, a stormwater cover, or a drain near the intersection. Eventually cars are going to start bumping into it, and that creates both noise and vibration, and it's completely unpleasant every time somebody goes over it. So I think it was in condition number 49, the advice note for that. And because it's not in design phase, I can't comment on it from a design point of view, but it's a note for council to look out for it, to avoid it. The last one I wanted to note very quickly is the construction noise. Again, there's flags we have for construction, which is whether there's rock in the ground, whether you've got a need for deep piling that needs big 40-ton rigs to come in and auger down to 10 meters. The site has none of that. It's just general excavation, so I don't see major flags. But having said that, it's a large-scale site, and usually contractors' instincts are to bring the biggest possible machines with the loudest possible reversing beepers and put them on the site and run all through it. So my recommendation was to introduce conditions 23 to 25, which explicitly limit the times of works and explicitly require a construction noise and vibration management plan to be submitted at the time for council to review and approve. And one thing I wanted to say is the CNVMP is not the old-fashioned, here's best practice, which is just a template and just go with it. It's designed specifically for the site. And I refer back to my colleague who talked about ecology. It could introduce a level of control on what equipment can be near ecologically sensitive areas. My preference in that case would be, before it happens, not just to monitor it as it happens, to have restrictions preemptively to say, you can't bring in a 6-ton compactor and run it next to that site, which is sensitive. A 6-ton compactor won't make a lot of noise, but it'll shake the ground to the point most animals would think there's an earthquake and get alarmed. So there are things that would be introduced into the CNVMP at time of development. Another example of that would be if a neighbor next door has a high season of guests, or somebody's recuperating from illness or any of that, the CNVMP has to respond to that by increasing the protection. So that's from a CNVMP and a control of construction. In terms of effects, construction it does introduce noise. It's inevitable, but as long as it's controlled, it's usually very tolerable. And in terms of compliance, I see no issue with compliance there. The closest neighbors are 20 to 25 meters away. other than the neighbors at the southern boundary, where I would expect there's going to be some shielding needed at that southern boundary. I just covered the main points I wanted to have and open for questions. Thank you for your patience with me.
Thank you.
Thank you very much, Mr. Jacob, for your evidence. I found it very clear. I just wanted to clarify some terminology that you used in regards to individual vehicle movements, which I think is made in paragraph 68B. You refer to the increase would be just at the threshold of differentiation from the noise levels already occurring. Would you just mind clarifying for me that conclusion?
Absolutely. So noise increases in a logarithmic way. And if any two noises are within 2 decibels of each other, most people cannot differentiate them. They'll tell you that's exactly the same level of loudness as interpreted mentally. Once you get to 3 decibels, some people can say, oh, I think that one is a bit more. You only can say that 2 noises are materially different. So one is materially louder than the other if the difference between them is around the 5 decibels. When you're in the 3 to 4 decibels, it's going to be like really close. If you're watching TV or you're on the phone, you wouldn't even know that there's a difference between them. You really have to focus to say, oh, that one might have sounded a bit louder. So I wouldn't call it a material difference in noise levels.
Great. Thank you for that clarification.
Thank you for your evidence. One of the questions I have for you is just the acoustic fencing along the railway corridor. We can see existing fencing on the other side of the corridor for existing houses. I presume that's what you would have in mind in terms of what would be needed to comply with that condition? It's close bordered, but didn't seem to be entirely airtight, if you know what I mean. I think by their nature, a wooden fence can vary in terms of how permeable it can be. But would that type of fencing achieve that 10 kilogram per square metre outcome that you've proposed?
There's 2 elements to the fence that we need as a mandate. One of them is the 10 kilograms per square meter, and that's to control the materials so we don't get a corrugated iron sitting up there. It doesn't do much. In terms of the construction, it has to have no air gaps. So when you're looking at any point of it, you can't slot a paper either under it or between the panels. A couple of constructions that can achieve that, you need 18 millimeter plywood. You could use panes, timber panes, but they have to overlap, so they can't be side by side, and they have to touch the ground at the bottom or be filled with soil under them, so you don't have any path for the noise to come under or between the panels. Landscape fences do not usually do acoustically well.
So the existing fencing you can see isn't what you're proposing. That wouldn't comply.
No, it would not.
Right. Okay. This issue of noise at the corner of vehicles passing through kind of overlaps with a question I'll have for Mr. Brown, just around the overall treatment of that corner. We've got a diagram from the person that did the safety assessment for the rail corridor crossing. And the submission from the neighbour on that corner talked about the way vehicles drive around there at speed. And these aren't cars coming, obviously, from this site, because that's not developed, but people coming along that road and turning the corner are basically cutting that corner because they're going faster than the carriageway might suggest. Just as part of that whole intersection, if there was curbing introduced to give that corner more definition and restrict the ability to take it at that same speed, would that be something that might have a beneficial effect on noise, traffic noise around that corner?
Absolutely, yes. I've looked at it from multiple angles. From the type of roading it is, the road is a bit gravelly, so you are going to get at that speed a lot of tire interaction noise, and the fact they cut the corner means you're getting a lot of that skipping in the car, so you get a lot of more rattling noises from the engine revving up when they accelerate. If the traffic gets calmed down around that corner, it would reduce it significantly.
Okay, thank you. I'm conscious that effect can't be sheeted directly to this application, but I'm just thinking about that whole intersection broadly, and whether, what sort of treatment could you put in there in terms of, as you say, it's gravelly. Is there a surface that would, obviously an asphalt surface would be quieter, but perhaps not provide skid resistance at the same time, so.
If it's redone, usually what they do, introduce more camber in the road, and that's something for the traffic engineering team to talk about, and then replace it with better asphalt. Sometimes they use concrete, can be quite like an underlay of concrete with a more rough surface, but not gravelly. It's a matter of having less loose materials on top and controlling the speed so you don't get that either skipping or the squealing of tires on the road.
All right, thank you. That was all the questions I had. Thanks.
Ms. Jacob, just one question from you, paragraph 14 regarding the sources of noise. Other applications I've been involved with around the countryside that are adjacent to the coast, quite often surf noise is the predominant noise source and drowns out other noise sources within close proximity to a beach. Is surf noise an issue here in terms of how it affects the receiving environment and all the other noises that might occur resulting from this proposal?
So we usually, Commissioner, we usually look at sound at a high level, and we break it down into two different categories. One of them is sounds that we enjoy and are not disturbing, and another is sounds that are alarming, and that's what we call noise. So in a lot of places we go monitor, you would hear the bird noise and trees rattling in the wind, or cicada noises or surf noise, significantly louder than the adjacent wastewater pump or the machines going on. But we enjoy the sound of surf and bird song, but we don't enjoy the sound of a pump. So in this case, people moving into an area next to surf are aware that it's next to surf and it's something they usually enjoy. It's also has a calming effect at night. From a psychoacoustics point of view, it's white noise. So most people enjoy sleeping with that noise in the background. It's not alarming because it's consistent. What we worry about sometimes is noises that increase and then decrease. I would not consider it a masking noise in that sense, because train noise is, it increases quickly and then decreases again. So if you're sitting down, it wasn't introduced slowly and then decreased. It's alarming. And it can cause, at night, for example, when everything's quiet and a train passes by, it wakes people up. So there are two different categories of consideration, but I would not say the surf would mask the noise from the train. The noise from the train would be dominant when it occurs.
Yeah. All right, thank you very much. No further questions. Thanks for your evidence.
Thank you.
Thank you, Mr. Jacob. We'll now move to Mr. Dahm. And Mr. Dahm hasn't prepared a summary, but I think you have. You've read his evidence, so Mr. Dahm, if there's anything you'd like to highlight, please do so. Otherwise, we can just move to questions.
No, nothing to highlight. I'm quite happy just to move to questioning. Thank you.
Thank you.
Yeah, thank you, Mr. Dahm. Richard.
Thank you for your evidence and your coastal processes assessment, which I found very interesting, and a very detailed analysis of coastal conditions along this area. Question I had around this issue of tsunami risk, and just to understand how that might affect this particular site, and it relates, I guess, to the cross-section, the way in which this site, the way that the beach profile extending into the sea. We all have a picture of tsunami from, I think, records from the Japanese one, which was well recorded, and we imagine this rolling wave moving into the shoreline and creating that devastation. It strikes me that the sea area here is quite deep and then merges to a steep line, such that that tsunami, the wave, the underlying pressure wave, or whatever you call it, that it emits, would not give that same impression, that same wave approaching the land. It would crash on the shore quite markedly. And the reason that I asked that question or posed that that particular characteristic is the idea that the tsunami would necessarily extend up over this land. I wonder how can you explain the likelihood of that? Because the crest of the site seems quite high compared to even high water level. I was at the site yesterday at high tide, and I initially thought it was low tide, but checked and it was high tide. So I can see that it has a good level of height margin, shall I call it. So yeah, are you able to explain the likely characteristic of a tsunami at this point?
Sure, you're right. And I mean, if you look at that cross section in figure 4 of my report, mean high water spring is typically around about RL 11, just under, whereas the ground elevations are RL 17, 18 in terms of the datum we're using. So you're right, that it's much higher. Even if the tsunami occurred at high tide, you're talking about a large event that would be required to overtop this. In fairness, where we are located is a subduction zone, and that's where the largest earthquakes that can occur typically occur. And we know from other sites, Japan, Indonesia, Chile, that obviously very large tsunami can accompany those earthquakes, particularly of magnitudes in excess of about 8.5. Megathrust type earthquakes, which are typically quite shallow with one plate subducting under another. Obviously, to get a wave, you're talking about a locally generated tsunami rather than one that's traveling from Chile or somewhere else. And you're probably still talking a reasonable, probably half an hour warning period, although that will depend on where the rupture occurs and how significant it is. But I think potentially you could get a wave here with a big enough earthquake, with a locally generated tsunami. It probably, the one I'm thinking of is the one that occurred around 1947, just north of Gisborne, where there was a hotel where the water level came up, I think, 10 metres or something similar to that, quite high anyway, and flooded the bar of the floor of a hotel. No one was lost in that. But that was more like a quick rising tide than a wave. So on the New Zealand coast, that's how we typically would think tsunami would occur, is a rapidly rising tide, rather than the waves you associate with places like Hawaii, where you've got deep oceanic waters that arise very quickly around a volcano that shelves deeply from the ocean depths. So, but I wouldn't want to rule out a wave, potential for a wave, but you're certainly, with the height difference you're talking about above mean high water spring, you're talking about a very significant tsunami for a wave to overtop this barrier.
And the half-hour period that you talk about in terms of, I guess, warning or time between events and when that effect might arrive, is that based on the distance of that key subduction zone interface?
I think so, and a lot of it depends obviously on how big the rupture is, where it occurs, exactly on that fault, if it occurred directly offshore or a bit further south or a bit further north. Obviously the rupture and the characteristic of the rupture, you need rupture over a couple hundred kilometres or more to generate quite a big tsunami, but you can get those kinds of ruptures and you can get significant offset, some meters of the seafloor change. So you said certainly as a site that's vulnerable to large tsunami. We don't know, but judging by the setting compared to other sites like Sumatra, like Japan, like Chile, where there have been these earthquakes. There's been a lot of work going to this area in the last 20 years, looking at the potential for megathrust earthquakes, particularly with magnitudes in excess of about 8.5, and looking for evidence of historic tsunami. We haven't seen too much conclusive in terms of certainly the tsunami in those reports, although there have been some suggestions that I think given the setting, we would say the risk is there.
Thank you. Just a question on at 42 of your evidence, you talk about it being useful to map the hazard lines to and with visual interpretation of the risks. Can you just clarify what you're meaning there?
Just so that you see where it lies on the properties, basically, you typically map them. Hazard lines, so you see where they lie in relation to property boundaries. It's useful when you come to locating development and considering the design life of development.
This would be the coastal hazard line that you're referring
Yes,
to?
yes,
So
exactly.
it's demarcated on each site.
Yes,
as
it
in
normally would
physically
be
shown.
demarcated for the subdivision as a whole, I guess, and it's measured from the distances I've given you in my report are measured from the existing seaward tower bank, so it's not hard to map.
Okay. All right, thank you very much. That was all my questions.
Okay.
Thank you very much for your evidence. I just had a question in regards to your conclusions on sea level rise. I see you've had an opportunity to review the most recent information we have here in Hawke's Bay. I just wondered if you wouldn't mind commenting in particular to this site, your conclusion around that.
Yes, I mean, and if you look at, now if I just go in my report down to, I think it's section,
Yeah, I think on
I'll just,
page 46.
second, go to section 5.4.1 of my original report.
Yes.
Yes, okay. And that does have the most recent sea level rise projections, most recent IPCC and national guideline projections. If you go down to table 4, where you see the adjusted sea level rise values that I've used, and if you look at 2130 in table, bottom table in table 4, you'll see that for the SSP 5 bar 8.58 plus, we've used a relative sea level rise of 2.15 metres, so just a very high bar to judge the subdivision by. And the SSP 5 bar 8.5 M is, sorry, 1.6 metres, I should say. But if you were including VLM, it rises to 2.15 metres. And even if you even with the median projection that we've used, it's still talking about 1.2 metres of sea level rise over the next 100 years. So they are very much upper level projections.
Thank you very much. And just clarifying that also, was that overlaid with the vertical land movement?
Yes, the vertical land movement was used for the extreme upper level. For, as I outlined in my report, I'm a little sceptical about the VLM in that particular area for the reasons that I've outlined, but we did use it for the upper level estimates, but they still sit within the setback that we're proposing.
Thank you. Thank you.
So Mr. Dam, thank you very much for your evidence and for the underlying report. Very thorough in my view, and it was refreshing from my perspective to see that the Tonkin and Taylor peer reviewers and you were of one mind, which is always helpful for decision makers like us. Just a couple of matters I want to ask you about from your evidence. Paragraph 14, subclause D. And the question is that at the end of that subclause D, you say the accretion trend is slowly moving northwards and seems likely to lead to shoreline advance seaward in the coming decades. And I understand the rationale for that is set out in your report. But the question is, will that accretion continue if the regional council ceased renourishment at West Shore?
It's a good question, and we didn't take much of that accretion into account as I outlined in my report. It's just one of the factors that may influence future erosion. So I didn't use it in terms of assessment of the setback, but not allowing for that significance anyway. But yes, I think it probably would. We don't know much about that accretion. Obviously, when the earthquake occurred in 1931, as I've shown a schematic in my report, the whole barrier was uplifted, and so was the offshore area, and the beach right along there adjusted. There was an erosional adjustment to that because the profile was out of kilter with the wave climate, which hadn't significantly changed. So there was a period of erosion right along there. So I don't know to what extent that bulk of sediment relates to that post-earthquake adjustment and to what extent it relates to sediment deposited by nourishment. Probably it's a combination of both, but obviously that's a slug of sediment which is moving north. If the nourishment stopped, then you would expect that slug would slowly move along and then eventually would move past over many, many decades or be dissipated. So if the nourishment was not continued, then probably it wouldn't be a long-term effect in terms of, when you look at timescale beyond 100 years, you might say, well, it's a temporary effect if the nourishment wasn't continued.
Right. So just to summarise that, if the renourishment was to cease, it would be many decades, possibly a century before that might have an impact on the accretion at this site. Is that what you're saying?
Yeah, I think that accretion's moving northward very slowly anyway.
Yeah.
It's taken a long time to reach the southern end of the property, and it'll probably take a few decades to move up to over the length, the full length of the property, and it might even decrease as it moves along. Which is why we didn't take the full 20-metre type accretion into account in our calculations. But we do expect that to have some beneficial effect, which will, over the next few decades, how long that will last once it occurs, might depend on factors whether, like you mentioned, whether nourishment continues or not.
And just another question relating to the table underneath your paragraph 22.
Right. Yep.
And just, could you explain why, if in terms of the bank stability column, why the upper, if we look at the climate change scenarios at the bottom of that table, why the upper ones are 0?
Yes.
Why is that? Can you explain why that is the case?
Sure, absolutely. And that same question was raised by TNT in their initial peer review, and it's a fair question. Obviously, we're dealing with an uplifted gravel barrier, and so as sea level rise increases, the height of the barrier above sea level rise will decrease, and so will the height of that bank.
So that's the answer?
Yes, that's right. The bank height decreases as sea level rise increases.
Okay.
It's a minor component, but I put it in there just to reflect the reality of what's going to occur.
Yeah. And paragraph 27, just in relation to overtopping. If overtopping did occur, would it reach the proposed building platforms?
The overtopping one's a complex one, and a number of people have looked at coastal inundation, including TNT, the late Professor Comer, and myself. I approached it, as I outlined in my report, in a slightly different way to Dr. Comer and TNT, in the sense that this was a barrier that is a wave-built feature. So waves historically overtopped it, as I've illustrated with a couple of diagrams from historic photographs in my report. But then it was uplifted by 1.8 to 2 metres. So if the wave climate doesn't change, I would think you would need similar level of sea level rise before overtopping was experienced again. But so Tonkin and Taylor have used lower levels of sea level rise before overtopping would occur using with the empirical methods they've used, which are fair enough, and the modelling. And there's a level of uncertainty around that. But I think we've both agreed that if it ever did occur, it could be very simply mitigated.
And how would it be mitigated?
Basically, bulldozers pushing up gravel, raising the level of the front edge of the barrier. You could probably do it in a couple of days. It's a technique we even use on sand beaches, which are far less robust than these gravel barriers.
Yeah, okay. And finally, one not for you, but one for Mr. Vanel. The paragraph 42, my colleague talked about the mapping of the coastal hazard line. Has that been done? Is that shown on the...
Yes, correct.
Yeah, it has already been done, hasn't it?
It's been included in the revised plans that were sent through.
Thought
Yes.
So. Okay. All right, and you had one more?
Yeah, thank you. Just one more from me. A number of submitters expressed concerns regarding the post-cyclone Gabrielle changes to the coastal environment, and I note you addressed this briefly in your comments in paragraph 28 of the evidence, which I think is based on a visual inspection of the site that you've undertaken recently, and I just wanted to give you an opportunity to comment on your level of confidence in the conclusions in your original report? in that
I've
context?
seen nothing that leads me to think that Cyclone Gabriel materially altered the facts that reflected in my report.
So a very high level of confidence.
Yes, at this stage, I haven't seen all the data that various researchers have come out with. In the end, it may be quite a positive thing, depending on what sort of sediment was delivered from by Gabriel to the coast. We've all worked on the assumption that this particular section of coast received next to no net sediment input, and so it'd be interesting to see if the post-Cyclone Gabriel reports, when they eventually emerge, change that.
Thank you. And I also note, I think you've reviewed those new coastal inundation lines.
Yes, that's right.
Yeah.
Yeah.
Okay. Thank you very much.
All right, thank you very much, Mr. Dam, for your evidence and for answering our questions.
Thank you.
Thank you, Mr. Dam. We move back into the room now, offline. And I was going to suggest that Mr. Brown speak next. He has prepared a summary that he finalised yesterday afternoon, so it hasn't been pre-circulated. It does generally reflect the key points from his evidence. So what I might do is get him to hand that out, and then rather than perhaps read you through every word, speak to the key parts, but then you can be left with it. It does reflect what's in his written evidence.
Thank you, Mr. Chairman. While we're waiting for that to be circulated, I have one minor change I'd like to make to my primary evidence, if we can.
Yep.
It's on page 16, paragraph 83. And in the third line,
Yep.
it reads through the construction management plan, which will include the construction traffic management plan. I'd like you to strike out the words construction management plan, which will include.
Yeah.
So the paragraph will then just address and manage the effects through the construction traffic management plan.
Sure.
This correction is necessary because this evidence was drafted as the conditions were still evolving.
Yeah.
And so a little bit of haste, I got caught out on that one.
No, that's fine. Thank you.
So I'll try and paraphrase my summary. My name's Philip Robert Brown. I've got 40 years of traffic engineering experience. In terms of the road layout, cross sections and vehicular connectivity, I've reviewed those in detail. In fact, I've been involved in the design of a lot of it, and I've concluded that the design is appropriate for the intended use from a traffic engineering perspective. Now, there was a question earlier in the day about the presence or otherwise of swales. They are shown on the plans. There are swales. Johan can talk to that more after me. But basically, the road cross-section has a 6-metre wide carriageway, and on one side is a 2.1 metre wide swale, and then a footpath beyond that.
Yeah.
Those are detailed in the plans. The one I'm looking at in particular is one of the cross-sections, and it's plan reference RC18. And there are one or two other plans around that part of the grouping of plans, the suite of plans. So the swales do feature in it.
Yeah.
I mentioned also that there's no secondary connection from the subdivision to the existing roading network. Now, this is due to KiwiRail's desire to not allow new connections over the tracks when there's an appropriate one already there. Now, this is not KiwiRail being difficult. It's a reality of what KiwiRail's doing at the moment. They are closing unnecessary crossings for safety reasons. And in Auckland, I'm aware, close to my office, they've actually taken out a high-use pedestrian one. And I've been involved working with a major client of mine looking at existing at-grade road crossings. Commissioner Bakey might know this is in Takanini, a street called Taka Street and others, where they're actually bridging over the railway line. So this is nothing new. In terms of the intersection of Franklin Road and Lacane Road, there are very limited opportunities and significant constraints in this area, but I consider that the design of the intersection and its location is not only the most appropriate for the use, but it's also acceptable from a traffic point of view, provided the visibility changes that I've recommended are made. Now, those visibility changes relate to vegetation on the inside of a bend, and I have noted in paragraph 9 that some works have been done recently, maybe as a result of my primary evidence, to improve that visibility, and that has gone a long way to improve it. But yesterday I observed that there could be a little bit more done. There's a scraggy bush there, and I think there might be agapanthus or something, but the bulk of the work's been done, but a little bit more can be done. In terms of traffic generation, my work has been based on detailed surveys of the immediate area. These were done before Cyclone Gabriel, and I consider that's quite relevant because I understand the area is still in recovery mode. The data also gives me the information on how the traffic turns at the State Highway intersection. And in preparation for this hearing yesterday, I looked at the NZTA data, and there's been no significant change in the volumes on the State Highway to suggest that the analysis is out of date. So what I've concluded from my analysis in this distribution of traffic is that the generation is not high from a traffic point of view, and that Franklin Road will be able to accommodate it without any difficulty. Now, I discuss in detail, going off script a little bit here, but I discuss in detail the volumes on Franklin Road. But I'd just like to comment on an observation I made yesterday afternoon. At about 4:30 p.m, there was a teenager I observed riding a mountain bike from the coastal edge all the way down Franklin Road to the State Highway. He did that in a very sensible manner, no problem with that. But at no stage along that entire journey at 4:30 was there a vehicle on the road. And that was at the start of the evening peak period. Later on through 5:30, the volumes increased a little bit, but it was a very, very low volume. In paragraph 14, I put the context of the traffic movements into perspective and state that in the morning and evening peak periods, the highest increase in turning movements at the intersection is equivalent to, on average, one extra vehicle every 2 minutes. Now, that's getting into the academic sort of category if you were to do an analysis, but the analysis has been done. And that analysis shows that what we call the 95th percentile queue length, now that queue length is only exceeded about once in the peak period, so it's effectively one of the longest queues. The queues in the peak directions increased by no more than about one vehicle in length. So it's very, very low impact. And interestingly, no submissions have come from NZTA. I find that very interesting. They're obviously satisfied with the analysis that's been done and the impact on the State Highway intersection. In terms of the impact on the railway crossing, I discussed that in some detail. I considered it from my perspective, but KiwiRail required a much more formal, detailed assessment. I don't have the training nor the qualifications to do that myself.
Mr. Chairman, we can't hear a thing along the back here.
All right.
I'm sort of concerned that
I'm sorry.
the is wasting his time on us.
I'm trying to use the oxygen preciously, but I'll try and speak a bit louder if that's okay.
Just pull your microphone closer physically.
Sure, sorry about that. Is that better? So, KiwiRail's submission required a formal safety assessment to be done, and the applicant engaged Stantec to do that. The person who did that work was actually instrumental in writing the document. And I have a copy of that report, if you'd like it, but it contains material that I just have not seen before and talks about KiwiRail's processes. But the key thing is that nothing substantive or of concern has been raised by that in terms of the subdivision, but it has recommended some works be done to improve signage, markings, and the pavement. Now, I understand the applicant is willing to do the markings and signage because that is clear of the railway corridor, and that's subject to Council and KiwiRail's approval. But I believe that any works within the rail corridor to repair pavement need to be done by KiwiRail's approved contractors who hold the necessary permits to work within the rail corridor. You just can't send out a sealing contractor to do the works. In terms of the submissions, I've reviewed all of those and considered the traffic points that are made. a lot of them mention the loss of the pedestrian access from Rogers Road to the beach. Now, you'd be aware that that crosses KiwiRail land and also the subject site. And KiwiRail is supporting the closure of these crossings, and they'll be talking to that themselves. But I also support the closure of them for safety reasons. And as an aside, I was doing a job in the west coast of the South Island, and I nearly got taken out by a train. So I have first-hand experience at that, so I fully support it. And as I mentioned earlier, the closure of these crossings is consistent with KiwiRail's practices. I also go on to explain that the connectivity is not lost for people on Rogers Road, because there is a connection from the end of Rogers Road through to a spur off Franklin Road with a legalised pedestrian walkway. And I've provided some photos showing where it is and the end of one of those connections. And the applicant's legal counsel has gone through the property records and has confirmed that it has been legally established. Other submissions raise issues associated with the generation of dust and damage to roads. I consider they can all be accommodated through the construction traffic management plan, and that's a standard condition. As I mentioned earlier, NZTA has raised no issues at all, in fact has not submitted anything. And the other traffic matters raised in the submissions, including the congestion, have been addressed in my report. So from my review of the submissions, I have not identified any issues that result in me changing the views and conclusions I have expressed. In terms of the 42A report, there has been mention of the escape route in the event of a tsunami, and I record the fact that there is a more direct and shorter route is available to higher ground from the subdivision via Franklin Road rather than Rogers Road, and that is assuming if KiwiRail approved a connection to Rogers. I provided in my report some screenshots from Google that provided the distance and the travel time to that. Essentially, exit to Franklin Road, travel to the State Highway intersection, and directly opposite that intersection is an access that goes up a hill to an old power site, and I understand it also contains a water storage tank of councils. That is the most direct route to higher ground. But I've also been shown the inundation map from a tsunami. Mr. Ellis would talk to that soon. But the inundation area on the council's GIS system shows it only going halfway up Franklin Road. But I'll get him to talk to that. The 42A report also talks about the road being in private ownership. Now, I've got no fundamental issue with this, but I note that this status could well result in it becoming potentially a gated community. Issues arising regarding public access, and also issues associated with where rubbish bins for recycling bags and so on for the 59 dwellings would be stored at the street frontage if it was to be controlled. So for that reason, I consider that it is better not to be a private road, and its character does not justify it. It's not like a retirement village where access should be controlled. In terms of the proposed conditions, I consider they're all appropriate and complete to cover the traffic engineering matters of the application. And as we just heard from the noise expert, there is an advice note on condition 49 about best practice measures to avoid noise generated from manholes and speed calming devices. I fully support that advice note. So in conclusion, my analysis and assessment has led me to the view that the subdivision is acceptable from a traffic engineering perspective. It's supported by a neutral submission from KiwiRail, the absence of a submission from NZTA, and the findings of the detailed rail crossing assessment. The remaining submissions have not raised any points that have made me reconsider the analysis I've done, the opinions I've expressed, or the conclusions I've reached. And accordingly, I consider that there's no traffic reason why consent cannot be granted, subject to the imposition of conditions of consent that I've discussed. Now, if I may, I'd like just to pick up some of the points that have come forward prior to now. There was the discussion about the intersection and vehicles cutting the corner and treatment of the intersection. My understanding is that the formation of the intersection is going to be curb and channeled, so that has a degree of definition. That is a good thing. I believe vehicles are cutting the corner now because the volumes are low and people are able to, and it's just a lazy way of driving. But the introduction of the intersection and the traffic movements to and from that, I think will result in a greater degree of discipline. But there was mention of perhaps adding camber. I would strongly recommend against that. And the simple reason is you put camber on a road to maintain a higher speed. We do not want higher speeds around this bend. If there was a speed issue, you could consider speed humps, but I don't consider they're going to be necessary. The radius of the bend will slow vehicles anyway, and we've done speed measurements on that. The proximity of the railway crossing also has a slowing effect. But all of these matters were considered when we looked at the design of the intersection. If I could close, the last page, I think it was, of my primary evidence contained a screenshot from the reviewer of the rail crossing, the safety assessment. I think it's quite legible, but if I could get you in your review of material to look at the second to last paragraph, because it talks at length about a new crossing to Rogers Road and the complications that that would create if KiwiRail allowed that connection to occur. Now, KiwiRail's been very clear there will be no connection, but if on the assumption that there was, there are design complications there in terms of stacking length, the design and the angle that it meets the road, it crosses the tracks, visibility and the like. So it's not an easy thing to solve, and I expect it would require the acquisition of at least one property. But it's hypothetical because, to my mind, it cannot occur and it should not occur. Thank you.
Thank you very much for that. I'll see if we have questions.
Thank you, Mr. Brown. Just starting off with that point about the tsunami evacuation arrangements. Sorry, I sound quite echoey. Has it been turned up? Saw that road yesterday and the gate to it is closed. What would be the, presumably that acts as a tsunami evacuation point as of now? What's the arrangement there for that gate to be?
Yeah, look, I don't have an answer for that, but in desperate times, people do desperate things. And I have considered what would happen and what I would do. And I noted that it was padlock shut and that the fencing on either side had some barbed wire. Now, I expect that there would be some way through it, and if a vehicle was there, it could even be used as something to sort of flatten the gate up, create a hole in the fence, or something like that. And I don't see that as an obstacle given the significance of an event. But as you'll hear, the modelling shows that the evacuation wave does not go that far. It stops about halfway down Franklin Road. But irrespective of that, it is a shorter and more direct route to higher ground than any alternative that goes through Rogers Road. There's a greater distance to get to the same point, but if someone doesn't go to that far, they're ending up on low-lying land. So they may not have achieved what they wanted to achieve. And if I may, I was talking to some locals yesterday afternoon, and I just asked them, where would you go in the event of a tsunami? And the two people I spoke to and provided an answer said they go straight down the road and up the hill. And that's what I've said. Yeah.
It just seems to me that that landowner probably needs to be part of whatever tsunami evacuation plan exists in the area. But
yeah, at some point,
I don't know the mechanism for that to happen.
Rules go out because it becomes a survival thing.
Yes. Yeah. I'm interested in, you partly answered the question about the curbing of that corner. And my question relates to that extract that you took from the Stantec analysis for the railway crossing. And it seemed to be the closest we have to a plan of how that whole intersection to the subdivision will work? And sorry, there might be something in your original traffic impact assessment, but I don't recall seeing it.
No, the Stantec work was done after my TIO
Yes.
was prepared.
So is there another plan of what that access is going to look like? Almost, not necessarily an engineering plan approval plan, but something akin to that?
Yes, there is.
Yes.
And it was prepared as a result of the Stantec report becoming available.
Right.
It is, I think, the very last drawing in your bundle, and it's referenced as Plan RC22.
Yeah, okay, no, that's the same one.
It's got the intersection design with railway crossing signs and markings.
Yes, we're looking
RC22.
We're looking at the same thing, that's fine,
Yeah.
thank you. So the question about the curbing is, would the works necessarily extend to that side? I think you just indicated that work could be done. I appreciate that the issue of speed around that corner is not one necessarily of the applicants created by this subdivision. But if that whole corner was being redone to accommodate the intersection for the intersection, if that was work that could be accommodated in that area. So what I'm thinking there is the black line that we see on the subdivision side of the road, which I'll take as a indication of curbing, even though I know it's related to the railway crossing issue.
Yep.
So that corner was built out to effectively slow vehicle speeds around that corner. Is that something that would be done as part of that overall upgrade?
Yes, it would be. The design would have to go through council's detailed design approval process. There could well be, as a result of that review, a need for a safety audit. I doubt it, but there could be. There may well be the requirement for chevron signs. These are the yellow backgrounds with the left or right pointing sort of side-on V-shaped symbols to define the bend. But the people coming into the intersection are locals. They know the area so well. It could well be that as a result of this, that immediate part of the intersection becomes sealed, and that would improve the grip. But if you were to put some sort of safe grip type material on the surface, it could also lead to increased speeds.
Yes.
I'm not suggesting it becomes unsealed to keep the speeds lower, but there will be a package of measures done there. If I was to draw your attention to the details of that design, if you have it in front of you, if you're leaving the subdivision and turning left, you could see the triangle shape for the give way, and then there's a black line right next to it, and then a heavier black line beyond it. The inner one closest to the give way symbol, that's a mountable curb. So that's the curb that the vehicles will be following, the cars. The one that's set further back allows for trucks to be able to track over an appropriate surface rather than mount a curb and go over landscaping or grass berm or something like that. So there's the ability to define that. It may well be that the curb gets painted, but these are design details that get worked through later on. Yep.
Yes, I appreciate that. The question that arises from that diagram is just the nature of the access to what seems to be a public, I don't know if this is legal or not, seems to be a public parking area. It's all gravel at the moment, but you can see it on that bottom corner of the plan.
Yes.
How that would then work.
That would be part of that detailed design. I expect that access would move a little further up the page and would be formed as a more formalised access. At the moment, it's just a very wide open area.
Yes.
And it would be more appropriate as a driveway rather than just a general open space.
So you're saying it could be drawn so that there's two limbs to that access, one to the subdivision and one to that?
The subdivision would be the primary one.
Yes.
Potentially at the tangent point, I'm looking at the vehicle coming out of the subdivision, turning right. There's the curb on the right-hand side. Somewhere at the point where it meets the existing alignment, there could be a driveway formed at that point. It could be that it's decided that access is provided just within the stub road of the subdivision. But that's a fairly minor design detail. It wouldn't come in add 45 degrees to that and to create confusion. You just wouldn't do it. It would be on one or the other.
You mentioned earlier that the road plan or the engineering design does include provision for swales. Could you just clarify? I did look for it. I can't see it on the current engineering plans, but can you point me to? Oh,
Yep. I'm looking at one. It's Plan RC18. And there is another one, RC19 and RC20. They're typical cross sections at 3 different points. In each case, as I said, the 6 metre carriageway, 2.1 metre swale, but within that swale is a gravelled area and a low profile scruffy dome.
Yep. Yes. All right. Okay. I was fixated on the plan view. And
that's fine.
Didn't scroll down far enough. So it seemed to me that stormwater infrastructure was all running the green line through the middle of the road, and hence my question. So that's fine. Thank you.
Johan will be able to expand on that for you.
Yes, that's right. Okay. Just check if I have anything else.
Just while you're thinking about questions, would you like this KiwiRail report? Because we could just leave it with the staff.
Yep.
Just related to that intersection, again, there's an undertaking to trim that tree, which didn't seem to be, in its current form, any particular imposition at the moment, but I guess if there's an envelope requirement to keep the lower limbs at a certain height, albeit that there's a power pole or a light pole that tends to interrupt the view as well.
There's a timber power pole there. That creates a very localised visibility shadow. It really doesn't do anything to restrict the visibility.
Right. Yes.
The crown lifting that has been done has substantially improved it, if you compare what's now to what was shown in my photograph. But there are some, I think they're agapanthus, there's some sort of weedy thing with a flower on it, and a scrappy little tree that's at about fence height that's growing there. The clearance of that will just complete the process. But at the time we did our assessment, it was not looking good. And I'm pleased that that work has been done.
It has been cleared and it's staying as it is currently in the photos that you've got.
Thank you.
Yesterday I did observe a plant that was providing some visibility restriction. It's on the road side of the fence, so I would suggest that's investigated.
All right, thank you. My only other question was just coming back to the tsunami matter, which is, of course, one of those issues, I think as Mr. Duisberg set out in his submissions, those effects, it's a very low probability but high potential effect. And what's in my mind is, and this is around the issue of one access in and out, or out in this case, as opposed to two, and appreciate the difficulties of creating a second, and I also appreciate that that doesn't create a very short route, that's a longer route than the one up Franklin Road. But just thinking about, are you confident that if everyone was departing their 59 lots, essentially all within a few minutes of each other, that they can all get out of that road in the time that we've heard is available?
Absolutely. To put the situation in context, if the daily generation of the subdivision occurred in the 1 hour, the peak hour, that road can still handle it.
Yes.
The intersection can still handle it.
It's the half an hour I'm thinking about.
Yeah, but even in the half hour, it will handle it. But the movements at that time will not be like your typical period. There will be an exodus. I'm not an expert in emergency, in tsunami evacuations, but through the work that I've done, and I did the traffic work for the Commonwealth Games in Auckland, and we looked at mass evacuations and what was needed. I did the traffic work for the first 2 America's Cups in Auckland, and again, what was needed there. So you need clear corridors with very clear defined paths and things like that. The provision of an emergency evacuation plan tied into the material for the subdivision is a good idea. I'm not suggesting a poster next to the back door like you see in motels for fire evacuations. It doesn't have to go that far. But this is the most direct route. If there was an alternative to Rogers, then those movements are then mixing with the evacuation from Rogers also. And from memory, that's a larger catchment. So you want to try and disperse your movements rather than concentrate them.
Yes, and your conclusions made in the context of the other traffic that's coming from, in particular, Laquesne Road as well.
Yeah,
Through that.
there'll be no
Or
issue at all.
everyone trying to reach Franklin Road.
Yes, there'll be no issue at all.
Okay.
Yeah.
Thank you very much.
But there will be a situation where some people feel, hey, we can't drive up the hill, so we're going to leave the car near the juice factory and go straight across the state highway. But in a situation like this, like the end of a major sports event, we assume the pedestrians just take over and the traffic comes second. That's the philosophy for the management of that area, and that's what would happen here.
Thank you.
Thank you very much for your substantive evidence. I was just keeping track. There were a number of points that I think were made in response to questions of my colleagues. So, yeah, Council's traffic engineer notes one escape route is insufficient. We've had legal summary on that, and you've concurred that one route is practical.
Yes.
Your submission that the closure of the non-legalised crossing of the rail corridor, or the crossings of the rail corridors, and the formalisation of an approved crossing, your conclusion is that's a positive effect?
Yes.
The conclusion that you've reached on the effects of 1 Lacane Road is that they're adequately mitigated or addressed through design, curbing, speed and surfacing?
Yes.
And I think
if I could add, as I said earlier, there's another design phase yet to come, and that's when some of these details do get looked at. But you don't do them at this stage of the process.
Thank you.
If I could suggest, if you feel it's necessary, but I think it may not happen, you could have an advice note that requires a safety audit to be undertaken. That provides an extra level of scrutiny. But as I said earlier, I don't consider in this situation it's necessary.
Thank you. And I think my final point was a number of submissions noted landscape effects of the modified built form, and roading was specifically noted. We have had, as one of those components of the new built form, we've had evidence obviously from the landscaping experts on this point, but I just wanted to give you an opportunity to address from a traffic design perspective if you think all the appropriate mitigation measures have been made for built form.
Yep. Within the subdivision, landscaping would either be in the road reserve in the form of street trees in locations where the council has approved it. Within the properties, it has no effect at all. At the intersection, there will certainly be attention paid to what effect any landscaping would have on visibility, because if we're trimming vegetation on one side of the road, we don't want to be creating a problem on the other side of the road. So I'd expect that the intersection on the subdivision side would be clear of any vegetation that would be restrictive.
Yeah. So in summary, you've reviewed the landscape design and...
I haven't reviewed the landscape design, but I consider that the design principles that are normally adopted would be acceptable, and there are mechanisms to ensure that the safety is not compromised anywhere.
Thank you. Through you, Mr. Chair, could I ask you to take a look at that and reply potentially?
I'll certainly do so. Yeah.
Thank you.
Right, Mr. Brown, no further questions of clarification from me, but thank you very much for your evidence.
Thank you.
I suppose we were running significantly behind time, which is partly a result of how many questions we're asking, but that's all right. The hearing's scheduled to finish at just after 2 o'clock, I think, so we have plenty of time this afternoon if we need to run over, so I'm not overly concerned about that at this stage. It does inconvenience submitters who've come in earlier thinking they're going to be appearing now when you won't be appearing until sometime later, and we apologise for that. But it's important that we ask the questions that we feel we need to ask of the applicant's witnesses. So we'll just have to bear with it. These timing issues often arise with hearings. They go faster or slower than is originally anticipated. So it's now 12:15. We have 2 witnesses to come.
We do. And I wonder, to your point, sir, if it would assist you and the submitters that are here and perhaps have other commitments, we could get through Mr. Ehlers, and then Mr. Vinyl we could pause the applicant's case and hear from the submitters, if you and they would like that, and bring Mr. Vinyl in at the end. His focus will be principally on conditions and a few small planning matters. So I'm not sure we need. Yeah, I think we can break it there if that would assist.
All right. So submitters who are present, why don't you have a think about that? So that would occur after lunch. So an option is for us to hear from submitters after lunch before we have the planning evidence. The other option is to have the planning evidence and then hear from submitters, which will mean you'll be a little bit later than would otherwise be the case. So, all right, well, let's have the last witness before lunch, and I'm going to suggest we just take a half-hour break for lunch. That should be sufficient.
Thank you, sir. And over to Mr. Ehlers, and I think that swale issue having been addressed, I will just ask him if he has any small points to address, but perhaps moving very quickly to questions.
Okay, thank you. On the swales, so the concept is that the northern part of the road will have a 15-metre wide reserve with a 6-metre wide carriageway, which allows for two 4.5-metre wide berms. And the southern part of the road will be a 13.5-metre wide road reserve with one 4.5-metre berm and one 3-metre berm. Now, the 4.5-metre wide berms would consist of a 0.9-metre wide grass strip on the inside against the properties, and then a 1.5-metre wide footpath, which leaves 2.1 meters. Now, the 2.1 meters is wide enough to provide off-street car parking, and it's also wide enough to use as a swale. So the idea is to alternate car parking spaces and swales along the length of the road. The nice thing about this subdivision is that it's really low density. It's 800 square metre lots, which is huge these days. And it means we've got road frontages exceeding 20 metres on all the lots, and in some cases, just over 30 metres road frontage per lot. So there is lots of space to fit in off-street parking and the swales. Where the swales go, there will be space where we've shown the scruffy dome in the cross-section to also, along the length of the road, to provide planter boxes for trees there. So it could be a really nice urban environment. So that's on the swales. I have a few other things to cover off. So if there's anything you don't want me to cover off, please tell me. But rainwater tanks was suggested. It seems as if the purpose of that is as a water demand mechanism. Now, it would be lovely if all properties were required to provide rainwater tanks. But for some reason, it's not in the planning rules, it's not in the code of practice. So I was wondering whether that is something where there may be an advice note on a consent notice or something like that to encourage homeowners to install those. But at this point, it's simply not a council requirement to have it. And there are lots of other water demand management mechanisms. One of them is to install water meters, which is done in all of Bayview, and that's something I would support. I would actually support it citywide, but it's not a requirement at the moment. And then there's water restrictions and so on. So there's all sorts of ways to manage water demand. Maybe just on the tsunami, I had a look at the Hawke's Bay Regional Council's hazard portal to see what they have to say about tsunami risk, and it turns out that there is a tsunami map on the hazard portal, which is for a 1 in 2,500 year return period at 2022 mean high water springs levels. And I've got that map available if you wanted to have a look at that. But what it boils down to is that the tsunami line goes about halfway up Franklin Road, does not reach the state highway. One could go straight up the hill, or you could do a left, turn into Hill Road. I would just make that available to you. So that's from Hawke's Bay Regional Council. on flooding and coastal inundation. It's been a big week. The Napier City Council has released a new flood extents map. This property isn't part of, is not on that map at all. There are large parts of Napier which all of a sudden people find that they actually live on land that is subject to flooding. This property is well clear of that. Those maps do not include the information that was in the coastal inundation report that was released last year in December. When one looks at the coastal inundation water levels, in my evidence I've outlined if we had a 1 in 10 year peak rain event at the same time as we have a 1 in 100 year peak inundation event, the primary stormwater system would still operate within the parameters that are required. That's a worst case. Also, during Cyclone Gabriel, water, the western part of Rogers Road, there were houses there that flooded. This property wasn't affected at all. Just on datum levels, while I'm talking about flooding, you will see in the numbers that are being bandied around that there are levels around RL7 and there are levels around RL17. Those are just the two different datums. They're about 10.2 meters apart. So 17 and the 7 about the same. Then on financial contributions. Now, in my evidence, I've shown figures from the operative district plan. In the proposed district plan, the financial contributions were just carried through. The approach to the financial contributions, and I'm talking from a perspective of, I used to work for Napier City Council and I was involved with when all of this was set up back in the about 1998, 2000, thereabouts. So the financial contributions consist of on-site local, which there's only 1 or 2 examples of those in Napier's financial contribution system. Then there are off-site local. So those are effects that are directly attributable to a development. So things like that, for this case, would include lining the oil pipeline and doing some modifications to the Paitini sewer pump station. Those are off-site local effects. And those numbers are usually calculated specifically for each application. And the final category is off-site non-local. Now, the off-site non-local contributions are to pay to provide funding for network-wide upgrades. For example, on water supply to provide more bores and reservoirs and trunk mains, so wastewater for trunk mains. So we've proposed on wastewater to include the off-site non-local wastewater contribution that applies to all properties in Napier to deal with the downstream effects far away from the development where everything else gets mixed in. So that is the thinking there. So on the other rural area that this development is in, normally what would apply would be libraries, roading and transport, sports grounds, and that's normally it. So we've thrown the sewer off-site non-local contribution in there as well to provide for those, downstream upgrades which this development would contribute to. And those are the only points I wanted to cover.
All right, thank you. I'll see if we have questions.
Thank you very much, Mr. Ellis. I do have a question in regards to, not sure if that's close. Thank you. I do have a question in regard to the financial contributions. It was posed by my colleague earlier in the legal submissions, and I appreciate your response then that you've essentially applied from Appendix 31A of the district plan, the rural zoning, and picked some downstream categories to also apply. Have you done an analysis if you were to pick the infill urban zone, what the financial contributions would look like for the site then, as opposed to starting with the rural zoning?
Info urban.
Yes, and happy for you to address that in reply, but that is the category in Appendix 31 of the operative district plan.
Yeah, I've got it in front of me, thank you. Okay, so infill urban also would require a reserves contribution and a stormwater contribution and a wastewater contribution and a water supply contribution. So the one contribution I don't have in here at the moment is for reserves.
Thank you. Do you have a view on that?
The reserves contribution is there to fund the provision of open space reserves.
Through you, Mr.
Now, just because I'm thinking about it, and if we looked at the whole of Bayview, the whole of Bayview sits in other rural, and the character of Bayview is a rural residential type area. Just looking at something that's comparable would be Jervoistown and Meani. They are also in other rural. None of those areas are required to contribute towards reserves. Now, if this development and the character of this development is similar to Bayview, Jervoistown and Meani, I would say no, it should not be contributing towards provision of reserves because none of those other areas are.
And if it would assist, I can address this in my reply submissions as well, including the stormwater and reserve contributions that are being made in other ways by the application.
Thank you very much. I think that would be helpful, and in particular, if you could address with the context of some of the land being vested into reserves, I think that would be helpful. Thank you.
I'm sorry, there was one other thing I needed to cover. And that was on stormwater hydraulic neutrality. Hydraulic neutrality is required to avoid adverse effects on other property. In this case, the downstream property is the Pacific Ocean. So we don't need to be hydraulically neutral here. We need to be efficient.
Thank you very much for clarification on the swale arrangement. I'm looking a bit more closely at those plans now. There's nothing in the design that you have that you could see causing any issue once you go for your regional consent? That you've designed that with that in mind, that eventual process in mind, and that includes the nature of the outfall pipe, which you've got a cross-section there showing that poking out through the beach. There's no, that's something that the regional council will accept?
That is something the regional council would say. We are exceeding regional council's requirements here. So for residential developments, normally all that is done is that you put crates over the sumps, silt traps in the sumps, and you are done. Providing the swales exceeds what regional council would require. Regarding the outfall, we are limiting or making sure that the outfall sits above mean high water springs. Because as soon as we go below mean high water springs, we need a special consent for that. So by staying above mean high water springs, I think it is we're staying outside the coastal marine area, I think it's called. And I've done these outfalls before, and they're pretty straightforward. The most challenging thing will be to design it to make sure that we don't get gravel entering, or too much gravel entering the outfall structure. There are outfalls all the way along the Napier's coastline, so there are a lot of examples to look at to see what works and what does not. And I expect that's something that we would be working with the council's team on to make sure that we pick the best examples.
New was condition 74, now 82. Consent notice condition that A requires each lot to provide a geotechnical report prepared by a chartered professional engineer. Why is that necessary for each lot to go through that process? The geotech report provided with the application recommends that they're built to shallow investigations to NZS 3604, and it's unclear to me why every lot would then need to get its own individual geotechnical assessment.
Typically what happens at subdivision stage is that the geotechnical work is done at a subdivision level. So there's enough done to be able to show that each lot will be able to form a building platform. It's just the site specifics on exactly where people want to put their house on the lots. Like some of these lots, you know, they are pretty big. So depending on where they want to put their house, one would then do that site-specific work on that platform, and NZS 3604 has standard parameters for those investigations. So that's all that's about.
Mr. Ellis, thanks very much for your evidence. Very thorough. No questions of clarification for me, but just an observation in terms of your comment on hydraulic neutrality. That very much aligns with my own understanding that hydraulic neutrality and even attenuation of post-development peak flows are relevant in terms of downstream flooding effects, both in terms of flooding and in-stream velocities, etc., which is simply not an issue here because, as you say, it discharges to the ocean. So I think we're on one page with that. And Mr. Dobu, what I think we'd like to see in reply is that on the issue of financial contributions, a document that sets out the applicant's suggested financial contributions with the underpinning rationale, and then for you to discuss it with the council officers, and for the council to give its suggested financial contributions with underpinning rationale if there's disagreement, and then we can, if we're minded to grant consent, we'll make a decision on what is most appropriate based on that information that would come in reply. So I anticipate council will cooperate in that regard.
Thank you, sir, that we can certainly do that. And I don't want to take you away from your lunch, but Mr. Brown could just very briefly address the question about the landscape plan now, if that would assist well.
Sure, why not? It's fine.
Thank you very much. I've been provided in the break, since I stepped out back, the detailed landscaping plan for the street. Along the street, I consider that's going to be helpful from a traffic point of view. It will help to manage speeds. I think it's a good outcome. I expect the standard processes of ensuring routes don't break the surface of the road up will be done. I don't know anything about that. At the intersection where my greatest concern would be, the most significant planting is right on the corner of Lot 1, and that's set some distance back from the intersection itself, and I have no concerns about that. So there's nothing that has come out and made me concerned about anything in that landscaping. Thank you.
Thank you very much.
All right, thank you. So with that, we'll adjourn for lunch and we'll reconvene at 1:10. And so submitters who are here, just have a think if you're happy to go then or if you'd rather that we hear from Mr. Vanel, the planner, first. So if you could form a view on that and just let our hearing administrators know, and then we'll make a call on that after lunch. Thank you. just to accommodate people's time constraints. And so our hearing administrators are going to jump up if I've got this wrong. But we're going to hear now from our first four submitters, Dennis Pilkington, Patricia Wilson, Rebecca Hollyman and Diane Donahue. Then we're going to hear from Mr Vanel. Then there's two council technical advisors who have time constraints. We'll hear from them. Then we'll hear from our remaining two submitters, Alan Peterson and KiwiRail. Then we'll hear from the rest of the Section 42A team. And then we'll have applicants reply. So this is a very unusual process, but we're trying to accommodate people's time constraints and acknowledge that we've run over time this morning. So hearing administrators, did I get that right? Excellent. So, Dennis Pilkington, is it?
It is.
Yes, good afternoon and welcome. So we've read your original submission. You don't need to read it out loud to us, but of course now you're very welcome to present your key points to us, and then we'll see if we have questions for you.
Thank you. I confirm that Dennis Pilkington is my name. I live at 77 Rogers Road. I've been here for a couple of hours and I'd have to say I really couldn't hear anything, so please keep that in mind if I appear to be disregarding anything that's already been said this morning. I am opposing this subdivision proposal on the grounds that it blocks off existing pedestrian access from Rogers Road down onto the beachfront. I appreciate that the existing access is in fact over private property, but I can confirm that it is a very well-worn and well-used track that runs from Rogers Road onto the beachfront. A lot of people enjoy using it. Beachfront suburbs like Bayview always tend to be popular because people like living near the sea and they like having access to the beach. Unfortunately, in the case of Bayview, access to the beach is a bit limited because from the south end of Ferguson Street right through to the north end of Rogers Road, which is a distance of about 3 kilometres, the beach is all bordered by private property, so there's only a couple of side roads you can get down to the beach. So on this basis, I'm certainly not keen on seeing any developments that further restrict the public access to the beach. My understanding is that the original subdivision proposal did include pedestrian access from Rogers Road, and but for some reason in the current proposal that access way has been blocked off. From the developer's point of view, I can't see that there's any advantage in that because unfortunately I don't have a pointer, but if you look up on the screen up there on the right-hand side at the bottom, you'll see the words Rogers Road, and you can see at that point that Rogers Road and the new subdivision street run side by side, either side of the railway line. So there's ready access across there without interfering with any proposed sections or what have you. So I can't see that there's any disadvantage to the developer or to the new residents of the subdivision in having pedestrian access there. But the concern seems to be that the access across the railway line might in some way be a safety issue, but I probably don't need to remind you that the railway line has been closed for a very long time following Cyclone Gabriel, and it seems very unlikely that it's ever going to reopen again. Even the Prime Minister has commented on that. So if the railway line ever opens again, it's probably unlikely to be in my lifetime. But if and when it does happen, the volume of rail traffic is likely to be very, very low. So it seems that there's going to be very little danger to pedestrians going across there trying to dodge around possibly 1 or 2 trains a day. And if we do want to get across the railway line, why can't we use similar pedestrian crossings to the one down in Ferguson Street or a couple round by the port? They are in action now. They're a fairly simple thing, and my suggestion is that that's what we really need up in this area. I'm disappointed that my written submission appears to have been dismissed by the developers' consultants, and I think there may have been some comment about that this morning. But I think the consultants need to be reminded that recreational walking is popular in Napier, and really, if we're looking at any further developments in Napier, we really want to be looking at proposals that make it easier for recreational walkers, and not proposals that are going to make it more difficult. So until all that lot can be sorted out, I remain opposed to this subdivision proposal, and I'm hoping that the question of pedestrian access might eventually get sorted out to everybody's advantage. Thank you.
Thank you very much. I'll just see if we have any questions for you. Can you hear us at the moment?
I can hear at the moment. Thank you. Yes.
Great. Richard, any questions?
We were advised, and we've seen a pedestrian link. It's not as direct to the foreshore, of course, but there's a link shown in Mr. Brown's evidence from the end of Rogers Road through to Francis Street. Would that be something that is of use to you? Obviously, it's a longer walk to the beach.
Yeah, by about 800 metres in that direction, and of course I can go down to the beach at the other end of the street through Gill Road, and that's about 1 kilometre. So certainly the access is there, but my original point was, of course, that you've got that sort of 3 kilometre stretch of private property along the beachfront, and there's only 2 or 3 sort of access ways to it.
Thank you, Dennis. I think your submission is very clear, and appreciate the points you've made. Thank you.
Thank you.
And same here, Mr. Pilkington. Crystal clear what you're asking us to consider, so no further questions. Now, Patricia Wilson.
I'm going to read from my application concerning the resource consent that I put together with the help of my daughter on the 6th of September last year. Some of these things will have been addressed today, but I've still got great concerns. I'm the owner of 1 Lacane Road, Bayview, and I object to the application as the proposed development of 59 residential lots would significantly compromise the existing coastal rural amenity of my home and the wider area that I currently enjoy and value. The addition of 59 homes accessed from a new road opposite my home would introduce significant traffic noise and general activity that would directly compromise the existing quiet rural amenity of my property. In a wider sense, the residential development enabled by the subdivision would destroy the open rural character of the area, and 59 homes across the site would result in a suburban character that was completely contrary to the rural zoning of the land. Traffic exiting from the development during night hours would likely shine headlights into my home, compromising the enjoyment of my home. While this seems like a minor matter, it would be completely inconsistent with the existing rural character that I enjoy. Traffic exiting the development would be accelerating up to speed with greater noise. This would be very inconsistent with the existing quiet rural environment that I enjoy. I disagree with the conclusions of the assessment of environmental effects in relation to both the scale of the effects and consistency with the objective and policies of the district plan. That assessment accepts that the subdivision will result in a site character change, but seems to try justifying this on the basis that the wider rural landscape beyond the site is maintained. The change of site character that the assessment of environmental effects accepts would arise from the subdivision would have adverse effects on the surrounding area and cannot be considered consistent with the policy direction to avoid, remedy or mitigate adverse effects on the character and amenity values of the rural environment. This rural zoning of the land is a long-standing and accepted part of the structure of Bayview that has helped to define the limits of built development across the area. The ribbons of residential development that project into the rural area are historic patterns of development that have for decades sat comfortably with the surrounding rural land uses. The distinct character of the coastal communities north of Napier are based on this historic form and limitation of further development. The application proposes 59 new homes into this limited environment, and this significant scale of development will have unavoidable impact on the character and appearance of the rural and coastal environments, and that I feel strongly about. Surely this must be recognised as having more than a minor effect on the existing environment and cannot be seen to be consistent with the clear direction of the objectives and policies of the operative district plan and proposed district plan. The development is at odds with the messaging that we have received from Council in relation to the mapped coastal hazard zones, coastal erosion risk, and investment and consenting of building improvements within the coastal environment. The shingle ridge of this section of the coast potentially benefits from the migration of beach re-nourishment gravels deposited on the West Shore beach area. The coastal inundation mapping for Napier and Hastings predicts the exposure of the West Shore residential area to coastal inundation through the effects of vertical downward land movement and sea level rise within the next 100 years. Coastal erosion mapping suggests large losses of land across the West Shore area. If the West Shore area is subject to such significant coastal effects, resulting in managed retreat being required from the area, this would likely result in the end of the beach gravel re-nourishment scheme. With that gravel no longer entering the coastal system, I am concerned that erosion effects may be accelerated on the northern beaches, resulting in greater erosion affecting the development. It would be disappointing for residents to lose their homes and disappointing for ratepayers, taxpayers to fund managed retreat from a development that could have been sensibly prevented in 2024. I understand too that there was this discussion today regarding this. I note that the traffic impact assessment identifies the trimming of my tree as necessary to obtain suitable forward visibility for vehicles turning into the new development. Trimming of the tree took place earlier this year, and we are aware that we need to do further things to work with the movement of traffic. This large power pole would need to be accounted for as a permanent barrier to visibility. Should the development be approved, I will likely need to construct a replacement boundary fence around to screen my house from traffic exiting the development. As I understand at this point, there is only one entry and exit, which is to be right at where my house is. I would seek to correctly define my front boundary at that time. This may result in a fence that is further forward than the existing fence. I don't know if this would impact on the visibility display, but this would be assessed now if it is critical to the scheme. The traffic impact assessment report relating to 3.3 speed environment indicates a tube count survey on Franklin Road, and I did listen to the gentleman this morning who was speaking about his recent visit to assess the traffic along Lacane Road and Franklin Road and onto State Highway 1. However, as we know that with times this can be changed with any people coming and going from early in the morning for workers, children being taken to and from school, and then again once this development starts there will be a huge impact to get this development underway, and there will be no time frame for how long that will take place. While vehicles slow for the corner, most residents or visitors familiar with the curve do not slow to a crawling speed. In fact, on several occasions when it's been random, people now, because the railway isn't open, just drive through and don't take any care at all and come round. And I submitted a picture at the time of where they're cutting the corner right on the edge. Should the development be approved, I fear the traffic would inevitably try to pass vehicles paused or queuing and to make a right-hand turn to enter the development. Greater road work would be required to formalise the intersection, either providing for or preventing vehicles passing queued vehicles on the left inside of the Franklin Road to Lacane Road curve. As it is now, vehicles are continually getting closer and closer to the inside of the curve, and I submitted pictures for this. And I would also too like to end by saying thank you for listening to me, and as I put this together in September, and I know there is further work being done on all of this. However, I do think that the proposal to build 59 homes is going to have a huge impact on just my environment, but the coast itself and the Bayview area. Thank you.
Thank you. Don't go away yet. We might have a question or two for you. Any questions?
No questions, but we were conscious of the issue that you raised about the speeds around the corner.
Yes.
And we did talk to the applicant's traffic engineer about that this morning, and just whether curbing could be introduced around that to slow vehicles, or at least make them take a wider turn in that area. So,
And also too, there are young people that do use the area for recreational areas on their motorbikes, and
Right.
whether some of them are of age to be doing that. And I don't have an issue with that as long as they're safe and they use the little reserve, which is right opposite my place. And I think it's lovely that people can feel free there, because many tourists come into the area as well. However, if there is going to be a big roundabout, or however they're going to put this access into the site to build these 59 homes, it has to be mindful of the fact that it's going to change the whole of that area, which is used by a lot of walkers. And as there are no footpaths along Lacane Road and around that corner, and even for cyclists that are now using it with the cycleways in and out of Napier, and it's become a very popular spot, you need to accept the fact that then there's a safety issue even with people coming along that area and are coming along there with further development, and that would be a huge safety issue as well.
thank you.
No, thank you very much for your submission, very clear.
Thank you.
All right, our next submitter is Rebecca Hollingman. Yep. Yep, have we got her online? Okay. So just while we're trying to get some technology issues sorted out, Diane Donoghue, are you happy to come up now?
Kia ora everybody, my name is Diane Donoghue. I live at 52 Rogers Road. My main issue is the environmental side of things with the little blue penguin that was in my proposal. I'm going to go blank because it's a bit nerve-wracking. I've gone blank. I just had a few questions. I just wanted to ask, I did read on Karen Amy Sevright's, I'm not sure if I said her name right, in a rural issue report about doing a 7-metre planting area in front of the residential homes that are going to be built. Just acknowledging that the area is a remote coastal, unique, New Zealand, it's a unique New Zealand coastline, and that is why they're attracted to the area, is because it's isolated, less predators, no human footprint, basically, apart from walkers, not an impact like it's going to have with the development. So my issue is, what I wanted to know was whether there's been a follow-up with, we had an address like there was 32 Rogers Road, whether that was followed through. Did she go over and speak to the neighbours or not? Was that done? I don't know. Or would that be followed through or not?
That's not our role to answer questions like that. So,
can I not ask questions?
Well, you can ask questions, but it's not our role to answer them. See,
who will answer that for me then?
Consider the submissions and the evidence presented. I'm not sure who would answer that question.
Is that not Karen Amy?
Pardon?
She put that proposal through on the report.
Who, sorry, say that again?
Her name's Karen Amy Sevright.
Yeah, so we heard from her earlier in the day. She's a witness for the applicant. So
I just wanted to ask questions about that because I just didn't agree with some of the things she said in her.
Yeah, so what you probably need to do, rather than ask questions, is just tell us which parts of that, her evidence you disagreed with, and then we can take note of that.
Well, just when, let me just,
Yep.
I'm going to be a little bit sort of here, there and everywhere, but she said because of the sloping beach, maybe they didn't nest there, but I have seen them myself, so I don't think that is an issue. And she said there was no driftwood that they need for nesting, but we always have driftwood on our beach. Of all the beaches along that coastline, Rogers Road is where you always get driftwood. So I don't know if she has done a proper research on the area or just a day or whatever, but I've cited them. My neighbour that used to live there has cited them because they nested there every year. So I just don't want the environment change for them because they do come back every year to nest and their young do as well. And she said because of the dumping waves, well, the ocean isn't always like that. Like today, it's flat. Ocean changes all the time. So I don't agree with that either. And saying that they can nest in the gardens as well. Well, I know that there's probably going to be nesting boxes put in place, but you're going to have, with all the new residents that are going to be living there, there's going to be animals, so that's predators. You can't contain, she said you can have to contain your cats and dogs within your property, but that's not going to happen because we already have wild cats and whatever out on the railway line. You see them all the time, or cats just roaming. So that is a big issue for me. I don't see how you're going to contain extra predators. and just the erosion side of things as well. Is that going to cause an impact? Because there's been nothing, or am I asking questions that I'm not? Yeah, so I just think the human footprint is just going to be massive, and it will just change that whole area. Let me just say. And there are a lot of other bird species in that area too. I've seen kingfisher, keriru, tui, fantail, wax eyes, all that, closer to the railway line, not on the beach, but where I live. So that would, I mean, birds can't speak for themselves, you know, like, so we've got to speak for them. I'm trying to do a good job of it, but I don't know if I am. But anyway, what other sorry. Just the impact also on extra people, vehicles, quad bikes, that's going to be an impact. You know, that we're going to have a whole new community on that beachfront. So I think that's going to cause a huge issue. It's not going to be remote anymore. Yeah, I'm just going to leave it at that because I can't think of anything else to say.
So that's all right. I'll see if we have questions for you.
No, observations. Perhaps encourage look at the AV management plans.
Is it an issue with the, just after cyclone, we had the cyclone, I mean, everyone was worried about the, you know, tsunami coming through with, well, to watch the beach, you know, but it came the other way, you know, so that is a big issue, isn't it, that we do have tsunami warnings, you know, we could have a big earthquake, I mean, natural global warming. There's real issues with erosion all along the coastline, and especially at North Shore. I mean, that's just changed dramatically in like a year. I hadn't been out there for a year, and it's just it's probably eroded probably a good metre or so. The same as at Tongoyo. Same thing has changed out there as well. So is that an issue, you know, that all along the coastline it's all changing? So is that going to make a change in the development happening outside Rogers Road? No one's going to answer that.
It's not our job to answer the questions. We evaluate the evidence put before us.
Well, that's all I wanted to say.
So
anyway.
yeah, so what you're doing today, this afternoon, is telling us what your concerns are, which is good. That's what we need to hear, and then we take that into account when we consider all of the evidence that's been put before us.
Yeah.
But it's not like
I thought it was like that. Yeah. I just thought I just had some unanswered questions.
Yeah. Okay.
So who do you go forward to, you know, to ask the unanswered questions? Because a couple of the things, there was also the thing about the dwelling on Rogers Road, 8 houses, a 2-storey with no sea views, but that's untrue because we're one of the 2-storey houses, and that's in the proposal that I read as well.
Mm-hmm.
So I don't know whether some of it's true and some of it's not, so that's where I'm a little bit confused.
Sure.
Whether they've followed up on all the information properly. But
All right, I'll just see if we have any other questions for you. Any questions in here?
Thank you
I'm
very
gonna
much. No, I do have a question.
Oh.
Thank you very much for your submission, and I appreciate your candour. One of the questions that I have is I appreciate that you have an on-site experience of the nesting penguins, and I note in your submission that you say that there is residents, I think at 32 Rogers Road, who have them nesting under their garage each year.
under their house,
Under
yeah.
their house. House. And so my question for you is your observation that they are reasonably adaptive? The management plan for the avian management plan that we've been provided has some mitigation to deal with the nesting boxes and provide additional areas for nesting. And I just wanted your comment on if the nesting under houses, are they quite adaptive to change in habitat?
Well,
you've
or
noticed?
are they used to what? I know that over on the port they've got the nesting boxes, and then down in Wellington when they had the cycle path put through, so maybe they.
On this site,
Oh.
what have you seen?
I've only seen them on the beach, but my neighbour that lived down there told me that they nested every year underneath the house, same spot, and that they came every year.
Okay, perfect. That's helpful. Thank you.
Oh, thank you.
Don't go away, I've just got a question for you. Yep, that's all right. So in terms of the little blue penguins that you say you've personally observed on the beach, other than what people have told you, what you've personally seen, where have you seen them?
That's down towards, it's in the high seas, so they come to rest, and that was through the day. And that was, I sighted them twice, and that was down towards, along Rogers Road, going towards the Lacane Road. But before the area where they all park, that, if you're familiar with that, at the end, so along that area.
Okay.
But wasn't there another, someone else put a submission through saying that they nest at her doorstep, by her steps, down Rogers Road, but I don't know who that.
Okay.
Mrs. A. Green.
So when was the last time you personally saw a little blue penguin down there?
That would probably be, it's probably 5 years ago.
Okay.
But I mean, they come at dusk, don't they? They come in the dark, you're not going to see them. It was just because it was high seas that I had seen them. And then I noticed them over at the port as well. So, and then we were talking about it, and then that's when my neighbour, my kids went to school with her kids, and that's what they said there.
Right.
They had them nest under their house every year, and if they were ever to move, to say something about it, so that's what I'm doing.
Yep. All right, then, thank you very much for coming in.
Okay, thank you.
Thank you. Yeah. Have we got Rebecca Hollyman online?
Hello, yes, can you hear me now?
Yes.
Yes, we can hear you loud and clear. Can you hear us?
Yes, thank you.
All right.
Hi, everyone.
Yes, good afternoon and welcome. So we've had a look at your written submission. You don't need to read that out loud to us because we've read it, but you're very welcome to speak to us and tell us what your issues are.
Okay, thank you. So I live at 68 Rogers Road with my family, and I just wanted to start by saying that firstly, we weren't even told about this application by the Napier City Council or anyone. The only way we found out was through an unknown neighbour. So I'm just wondering firstly if there's any other community members who don't actually even know about this yet. So I just wanted to bring up that point and then go into just a little bit of what I wanted to speak about. So we bought our house in Rogers Road a few years back, and we weighed up the pros and cons when we bought it. So one big pro against all of the cons of living further away from a support network and paying more money for our home and buying a house with work to be done was the view, and not being blocked in by other neighbourhood houses. So if this build goes ahead, we'll lose all of that, our view, lifestyle choice, and likely value on our house, which, yeah, my husband and I both work full-time, have our kids in care, and this lifestyle choice we've made to live out there, it just feels like it's going to be ripped away from us. We were reassured before we bought the home that the property between, or the section between Rogers Road and the beach couldn't actually have houses built on it, which is why we went ahead. Our neighbours were in the same position, our next door neighbours who we know really well. They were reassured that, and that was why they bought the property. So that's just a little bit of a personal reason and a heartfelt reason. The other reasons I can't go into depth about because, I'm not an expert in the fields of such things as the Clifton Tatongo Coastal Hazard Strategy. That was the Joint Committee strategy, which is still being handed over to the Hawke's Bay Regional Council. Napier City Council obviously have been on that Joint Committee. And I just wonder about, in this Coastal Hazard Strategy, it does say that it is an eroding beach. And I'm wondering why we would build houses in an area that should be in managed retreat, from my understanding and my simple understanding of it. It just feels like someone's going to foot that bill later down the track. I don't know when. But I don't have any solutions about what to do for everyone involved. But I think it's a short-sighted idea, and I'm opposed to the whole build. And I can't really think of anything else. Obviously, there's the stuff in my submission as well. Yeah, I'll keep it short.
Okay, thank you very much. We'll see if we have questions. Any questions?
Thank you very much, Annette speaking. Just a question regarding the eroding status of the beach. I'm not sure, do you have a reference for us on that? I have looked through Clifton to Tongoio strategy and I'm not able to identify it, which I think is the reference you've made in your submission. So I wouldn't mind if you did have an opportunity.
Can I send that through?
Yeah, through to our hearings administrator, that would be great. Thank you.
Okay. What's the, can I have that address, or is it an email?
Yeah, we'll take that offline.
Will someone be able to?
Yeah, we'll take that
Yeah.
offline. Thank you.
Okay, yep. Thanks.
And Richard?
Good afternoon. I noticed in your submission you were talking about traffic effects. None of the traffic from the subdivision would go onto Rogers Road, but is your submission about just hearing the traffic, or was it actually about traffic movements nearby?
I'm hearing the traffic. You know, at the moment we can hear the beach, the ocean, and when a sound wall or fence or whatever it is. Sorry, I can't spend, it's like a full-time job to be able to read all this information in this whole entire thing. But from my understanding is if we're going to be putting some sort of a sound barrier up and we're going to be adding traffic noise, then that's also going to take away from that quality, that kind of lifestyle that we've paid more for to be by the beach. So yeah, the noise pollution of the traffic, who knows? I don't know what kind of people would end up moving into 59 different houses, how many people, how many neighbours, how many honkings of horns and things like that. It just changes the whole environment.
Okay, thank you.
Thank you very much for your submission and for answering our questions this afternoon, but there's nothing further from me, so thank you, Ms. Holliman.
All right, thanks. Thanks very much.
Thank you.
Bye.
Right, so now we're going to jump back to hearing from the applicant's planning witness.
Thank you, Mr. Chair. I don't propose to go through my summary as it's all been pre-read and there's nothing further that I want to add or change. I've got a couple of matters of clarification and correction that I'd just like to quickly work through so that the references in my evidence are correct.
Yep.
The first one relates to, you probably would have noticed as you read through the evidence, a typo in terms of policy 33.9, 4.9 was in the evidence as 33.4.8. And
sorry, can you just give us a paragraph?
Yep, I can give you the 4 paragraphs that's in. It's paragraph 24, 131, 132, and 143.
Yeah.
With the changes to conditions, the numbers unfortunately have changed also, so they differ from what is in my evidence in chief. Just so you've got the right references if you're referring back, paragraph 48, that said condition 72, it's now 80. In paragraph 53, subpart A was condition 73, it's now 81. Subpart B was condition 34, it's now 32. Subpart C was condition 65, it's now 74. Condition 70, subpart D, condition 72 is now 80. And in subpart E, condition 75 is now 84. And finally, in paragraph 88, in reference to the KiwiRail reverse sensitivity conditions, they were included in my evidence as conditions 76 and 77. They're now 85 and 86. In terms of my evidence, I conclude that the proposal satisfies section 104D1A in terms of the first limb of the 104 gateway test, that the adverse effects of the proposed development will be minor, and that with the implementation of conditions of consent, including those that you've heard from experts today, they will be appropriately avoided, remedied and mitigated. Although not reliant on this in terms of my section 104D assessment, my assessment of the statutory documents is that the proposal is not contrary to the provisions of the relevant statutory documents, being the operative and proposed documents. Notwithstanding that the proposal is inconsistent with policy 34.4.9 of the operative district plan. While I acknowledge and accept that this policy is directive and seeks to avoid residential development in rural zone outside of residential greenfield growth areas that's identified in the Appendix 35 that Mr. Duisberg mentioned this morning, in my view, the proposal gives effect to the objective and policies when read together to enable residential development where the adverse effects on rural character are avoided, remedied and mitigated, and in my view not contrary to the objectives and associated policies. In terms of a query in relation to the conditions in relation to those that have been discussed with Mana Ahuriri, I can cover that now if that's of assistance.
Yep.
So I was involved in Hui and a number of further discussions with Manu Ahuriri following the lodgement of their submission. And included in my evidence those conditions that we proffered in relation to matters that they had raised of significance to them. Those, and you will have seen, you received a letter from Mana Ahuriri on the 29th, I think it was. That was the same day as our evidence exchange and the completion of our conditions. Following that, I sent both my evidence, the AV Fauna Management Plan, which was in draft, and the conditions of consent through to Manu Ahuriri, seeking to confirm if they had any further issues to raise as a result of that material. We haven't had a response to that. But if it would assist the panel that we follow up and get a confirmation, we can certainly do that, include that in our reply.
Yep, that'll be good.
Just in terms of the conditions, in preparing these, I thought it would be helpful for the panel to try and identify those conditions that were added to following the issue of my conditions attached to my evidence in chief, the updates and additions and alterations made by council So those are in red and green. And then our responses to those changes, which are in light blue. And I've also endeavoured to respond to all of the comments that the council made in relation to those conditions down the comment column as well. And you've heard from a number of experts this morning in terms of reasons for those responses. Just in terms of condition 74, which relates to the landscape management plan and questions from the panel this morning, I agree it would be helpful to reference the landscape plan to that condition. I think it would also be helpful to reference the survey plan that is located in Appendix 4 to Ms. Ryder's landscape assessment effects. The reason for that is that sets out graphically the yard setbacks, the building platforms, the height differentials between a 5 metre and 8 metre in a fairly easy way to follow if you're not familiar with the application. And although it's included in condition 1, I just think it would be helpful to pull that out and reference it so it's clear what those items in that condition are referring to. Also, in terms of certification, I agree we should include certification of the council. And speaking to Ms. Ryder following her evidence today, we think it would be helpful for that context that she took you through to be on the landscape plan and for the certification to be that the final landscape plan is within that context and to also include the specifications around the species and planting and sizes so that that's all very clear, measurable and can be easily certified. Other than that, I'm happy to take any questions.
Yeah, look, thank you for that. What I'm going to do is exercise Chairman's prerogative here, and that I had a number of questions based on the version of the conditions that I'd seen prior to today, and I imagine my colleagues may well have had numerous questions as well. Just because we've received a new suite of conditions, and I don't want to criticise because that's very helpful what you've done, what I'm going to say that the panel's going to do, we will review those revised conditions in our own time, align them with any queries we had on the previous set of conditions. We will then issue a minute with a series of queries, which then we would expect you, Mr. Doesberg, and yourself to then respond to and reply. I think that's a more efficient process now than us trying to figure out
cross-references
and things. And it may be that some of our queries have been answered by the work that you've done. So I haven't discussed that with my colleagues, so I apologise for that, but that's what we'll do with regard to conditions. What we'll do now is ask any questions that we have that arise from the substantive part of your evidence rather than the conditions.
Yep, thank you.
So any questions?
I think it's to reserve.
Do you want Richard to go?
Yes, please.
Richard, any questions from the bulk of the evidence as opposed to conditions?
My substantive ones were in relation to conditions, but I did have a query in the body of your evidence. You did say at 95 or referred to employment and social facilities in the area as sort of underlying the desirability of the location. I'm not as familiar with the areas you probably are. What are you referring to there?
So I guess there's employment in terms of the orchards and associated rural production that's in the area. In terms of social facilities, look, I accept it's not a town centre. It's not a traditional suburban context. It's a coastal suburban context. But there is a Foursquare, there's a kindergarten, there's a post office, there's a police station, there's a fire station. So there are a number of services that are available to residents locally.
And just in terms of your, the objective policy assessment, we've got that one that you referred to 33.4. And I think a lot of it's around terminology, I appreciate, but you've looked at 33.48, and I think you get to the point that it's perhaps inconsistent.
Yes.
But even on that policy, you would not say, you're not saying it's contrary to that. Obviously, you've done a weighing up exercise
Yes.
overall,
Yes.
and you reach a not contrary to the objectives
Yes.
and policies of the plan.
Yeah.
But that you don't get to that threshold
No.
particular policy.
Correct.
And the most you would say is that it's inconsistent with.
Yes. So in my view, it's clearly inconsistent with that policy. I think given it's not often you get a policy that is very directive and an objective which is more enabling. And so for that reason, I've looked wider than just the objectives and policies. And I think in terms of this objectives and set of policies, the reasons for the objectives and policies that are included in the plan are helpful. And so in my assessment, I've drawn on that. And when you look at those, they're about four things really: protection of land for productive rural uses, that the infrastructure capacity is sufficient to sustain the residential use or the rural use, that issues of reverse sensitivity are addressed, and the one that's probably important to this policy is in relation to ad hoc development, not compromising future development patterns. And I read in that the reason for that policy in terms of avoiding any development outside those greenfield areas. My understanding is those greenfield areas were introduced as a result of the plan change following the regional council's focus on greenfield development in rural areas. And it's clear that for those identified sites, they're the ones where their rural use is still there. And therefore, I think there's a particular focus on ensuring that there's not incremental ad hoc subdivision of those sites and that they're considered as a whole. I think in this case, given the land holding, the context of where it is, and the manner in which the subdivision design has been generated, I don't think it results in ad hoc development. So therefore, that's the reason I don't think it's contrary to the objectives and policies when read together.
Okay, thank you.
Thank you very much, Mr. Vanel. Just one question from me in regards to, I guess, a question in regards to your interpretation of policy 14 and where that differs from the officer.
Sorry, which one's that? Policy 14 sorry, the New Zealand Coastal Policy Statement. Yes.
So the policy obviously relates to the promotion and restoration of the natural character of the coastline environment as a whole. Your assessment is the restoration of the coastal edge in terms of regenerative planting is enough to, in your assessment, to make it consistent with. That's different from the interpretation we have from officers, so I'm interested in your commentary on that.
Yes, and so I guess the starting point is that I don't think the policy is directive in terms of how that's achieved. It does set out some parameters in terms of enabling, protecting, maintaining or enhancing the coastal environment. In terms of this subdivision, I think there's a number of factors which lead me to the conclusion that it's consistent with. One is the subdivision layout itself and the setback of dwellings from the coast, so that the dwellings are set back some 24 metres from the edge of the property. The measures to seek to avoid the domestication of the front yards of those properties that are coastal. So in particular, the controls around fencing, the placement of structures in that front yard. And then the coastal planting, which, in my view, does improve and enhance the current situation. And then finally, there's the access to the coast. So access along the coast is not precluded. And access from the proposed street through the subdivision, access to the coast is provided at 2 points along that street as well. I conclude that that's an enhancement and an improvement because under the current zoning, if a rural use was undertaken on the site, there would be unlikely to be any coastal planting or enhancement. And for a rural activity, the boundaries would likely be fenced. If it's used for permitted activities, it could be pasture. It could be crops, or it could be planting. So that could be to the property boundary.
Thank you. So just to clarify, are you proposing the permitted baseline be applied in regards to that?
No, I'm not applying the permitted baseline. I'm just making the observation that under the existing zone, there are permitted activities that can occur on the site, which don't enhance the coastal character of this part of the coast.
Thank you. No.
So in due course, you'll get a minute from us, and we'll talk about timing towards the end when we get to the end of the hearing with a whole lot of queries about conditions. But at this stage, just one question arising from the assessment itself. That's at your paragraph 25. And it's just your comment there in the fifth line, whereby the proposal will enhance the natural character of the coastal environment. I just wasn't sure if that aligned with Ms Ryder's evidence. At her paragraph 55, she said natural character effects will be low, reducing the degree of natural character to a low degree in the short term, which to me, her expert opinion doesn't seem to lend itself to an enhancement of natural character. Rather, she's saying the impacts on what little natural character is at the site, recognising it's highly modified and probably quite low on the scale of natural character. The effects of the development on that will be itself be low, but she didn't seem to think that would be an enhancement. Do you have a response to that?
So I acknowledge that she did say low. I think she said low and then over the short term, but improving over the longer term once the landscaping establishes and other planting matures. But I do accept it's not a. It is not. Will not result in a highly pristine coastal environment, given what's currently there and what is there to the north and the south. It will be an improvement.
Yeah. But in terms of natural character effects, you'd defer to Ms Ryder's assessment?
I defer to Ms Ryder's assessment, yes.
And no further questions of clarification. To anyone who's watching, don't get alarmed if we don't have questions. It just means that we've read the evidence and we've understood it and there's no issues that we need to clarify or query further. The lack of questions doesn't necessarily denote that we accept everything that's been said to us or agree with it. It just means that we understand it and we don't need to clarify it. Right.
Thank you.
So, Stosby, we're jumping around now, but I think where we're up to now is that we're going to hear from two of the council's technical experts because they have time constraints. Is that correct? Yep.
tēnā koutou, and thank you for shuffling around to accommodate myself and my time constraints. I won't talk through my report that's been provided, however, I'll talk to a couple of the key points which have been discussed by many today.
Sorry, do you just want to let us know who you are and what topic and what your subject area is?
I'll start there.
Yeah.
Thank you. Simon Bradshaw. I'm an engineer with Council in their infrastructure development team. I have provided my evidence on the general civil infrastructure apart from transport, which is covered by others. I'll start off by talking to potable water, and we've had some discussions around that today. And yeah, it's just to give some further context to what I've provided in that report. Bayview has got some constraints in the existing network out there. We have 2 reservoirs that are up at the other end of Franklin Road that are currently not meeting the level of service for the existing development that is there without considering any further growth. We also have a constrained 2 rising mains that deliver water to those reservoirs, which in peak daily demand struggle to keep the level of that reservoir at where we want it. So in turn there is some pressure constraints down in the network when it comes to the users at their place in summertime for our peak demand. Talking through to wastewater now, and it's been highlighted the toxicity issues there as a result of a long network to where it needs to get to for treatment. There's also capacity constraints in that network too, which was highlighted in an earlier application for the same site, that the pump station that it initially gets disposed of from the site at 68 Franklin into the Botany Domain pump station is under capacity to take what was the previous application for 61 lots. There was a option to include storage, however that just further facilitates those septicity challenges, so it was not considered appropriate to continue with that. However, that capacity from that pump station and downstream still exists, or those capacity constraints, I should say. Stormwater was another item that's been discussed, and I think I've brought up in my evidence that there's been a simplistic assessment that's been done. I acknowledge that in the applicant's evidence they talk to potentially doing a hydraulic and hydrological model later down the track, which I would support. But just talking to that simplistic assessment, and it's noted that the outlet has 4 times the required primary capacity, but that's using a partially full approach of a Manning's formula, which doesn't consider if there was a tailwater effect when there is a coastal inundation or a storm happening at the same time that there is inundation up the beach, there will actually be a tailwater affecting that capacity. So that's, I've raised that as a condition in my approach that needs to be considered when the outlet's designed, which I'm sure the applicant will take on board. But ultimately it was that simplistic assessment for me, just necessitating a need for us to be conservative, hence why my condition also talks to lifting building platforms up above the roads, 500 mil I believe, just to be safe in the sense that we know if we don't have that level of certainty that we've got some conservatism built into the consent. Treatment was also discussed. There is some provision in our engineering code of practice for subdivision under low impact design for consideration of treatment. And ultimately, I think what we need to do is just ensure we have the allocation of space to be able to, to enable that treatment when it comes to it, acknowledging that it will be with others ultimately to make the decision on what that looks like. Attenuation was the other point that was raised, and that was looking to, or hydraulic neutrality as it was worded, that was looking to, at the moment the assessment uses a average runoff coefficient in its rational formula, and it doesn't actually have a specific impervious allowance to that. And so ensuring that we maintain capacity through the primary network would be to attenuate on site. The alternative would be that we provide some impervious limits that can then reflect that or ensure that that primary network is got sufficient capacity. So that's the alternative to attenuation. And finally, on financial contributions, ultimately the site hasn't been planned for growth, so we haven't in turn done the essential services development plan to support that. I think other rural is generally considered for sites that are servicing themselves rather than being serviced, particularly from a Three Waters element. I noted that there was an item raised before about urban infill and whether that might be more appropriate, as it does include some of those other considerations for Three Waters and that servicing, which I note would be more appropriate than the current other rural. Yeah, and so I guess it's just coming back to how that was agreed, but I note that there's also some direction around that going away and being brought back in a capacity for people to look at. So I'll leave it now for questions.
Thank you. Any?
Thank you very much, Mr. Bradshaw. Just a couple of questions. In your evidence, I think you note, and I just want to get it clear in my head, that the rainfall intensity table is not in accordance with the code of practice. Are you able to give me some more clarity on that?
Yes, when the assessment was done, it was done some years ago, and it used the rainfall intensity at that time. However, we've moved on a couple of years, and NIWA updates their rainfall intensities relatively regularly, and so the newer one that will be looked into now will be a different intensity to what was used in the applicant's assessment.
Thank you. So I guess my question is, have you had an opportunity to review the most recent rainfall intensity data, and do you think it would materially change the modelling?
It will increase the runoff, yes, because the rainfall intensity, particularly for the 10% duration, is higher. However, in the larger events, in some cases, it has actually come down. So for the overland flow capacity, there could actually be a slight positive effect, but that's talking to it in general when I look at the differences.
Thank you. Through you, Mr. Chair, my second question is in regards to the commentary around stormwater treatment, in particular the low impact design space allowance. Are you satisfied that there is sufficient space built into the design of the subdivision, considering the amount of passive area?
I haven't had a good look at that. I note that earlier on there was comment around there being sufficient boom area, and there's already existing swales on one side, which will go to supporting some of that treatment. However, it will be long and linear in its nature, and lots of the time when we're talking about high levels of treatment, we want to go through a wetland or something, which doesn't work very well if it's long and linear. But there are other approaches. There's many approaches to treatment. So there is some space, but I guess my preference would be that we know what space we need to get the sufficient treatment.
Thank you. I think my other questions relate to the conditions which we have direction on and financial contributions. So thank you very much.
Excellent. So just in terms of the issue of attenuation, we had a discussion about that earlier when the applicant was presenting their case. So just to confirm, your concern about it, the need or otherwise for attenuation is in terms of the stormwater network capacity, is it?
It's correct, yes.
Okay.
And the alternative being if we restrict the impervious coverage, knowing that we'll have impervious coverage of the roads, which will be known, and footpaths, and then we can restrict the impervious coverage on the sites themselves to then all be within the capacity that is in that primary reticulation network.
Sure, but if the reticulation is sized appropriately, there'd be no need for that, would there?
There will be a need for an impervious coverage, because if we build the sites over a certain impervious coverage, then the runoff is going to exceed what our
Sure.
network is going to provide, yeah.
Sure. So there'd be a limit set on impervious coverage within each lot. The stormwater network would be designed to deal with that runoff from that, and provided that's all done properly at detailed design stage, that should be fine, shouldn't it?
Correct. It's just common that we would put in an impervious coverage condition into the consent, or it's already built into the plan. However, I'm not sure how that works, given that the plan is currently zone rural, which I believe is a 10% coverage, which I don't think we want to maintain if this was to go ahead as it's proposed.
So looking at this type of development, if you put to one side the underlying rural zoning, what would be a typical limit on impervious coverage in a subdivision of this nature with 800 metre square sections?
Given the surrounding area, I would say 50%.
So in terms of the treatment of stormwater or otherwise, what's the underlying concern, given it discharges to the ocean? There's no freshwater ecosystem issues of concern. All of Napier's, or a lot of Napier's stormwater from your own Napier City's own outfalls goes straight into the ocean. Does it have any treatment?
There is work in train to get treatment. There are some treatment areas that are provided, and there's some big steps that we're taking to improve that. One of them being the regional Ahuriri Park, but which is a great project, but slightly off topic. However, we still want to protect our coastlines and not be sending out, litter or large debris that could flow through. The potential for heavy metals that might come off tyres, brake pads, other items from spillages from cars, with oil leaks or the like, and therefore treating that, which normally would happen, through that low impact design before we end up discharging it out to the coast.
Yeah, so issues from roads in terms of brake pad linings and oil, etc., that's normally restricted to highly trafficked roads rather than lowly trafficked rural roads or roads servicing subdivisions of this nature. So would the primary concern be litter then, from what you've said?
Yeah, and I think suspended sediments is another one that can come off and through into the roads.
Just an overall question, in terms of the work that you've done in analysing the applicant's documentation, do you see any fatal flaws in terms of servicing requirements for this proposal that can't be resolved either through detailed design work or conditions?
The potable water item is the one that but that could be resolved through the need for some on-site storage to support those challenging times where water is restricted through summer, and its pressure restraints, and then obviously the firefighting capacity as well that will come as a result of those constraints.
Right.
But yeah, ultimately I think that can be engineered with a solution. Yes.
Okay, now that's helpful, and the key concern there in terms of the fatal flaw would just be the potable water issue that you mentioned. Yep.
Correct.
Okay. All right, no, that's all. Thank you very much.
Just to follow up on that, and don't want to get into the detail of the conditions, but obviously there's an area of contention in the set that we've got before us on that requirement for tanks. You've recommended tanks with a minimum storage of 10,000 litres. There's also an advice note, proposed advice note for firefighting level of service that there is enough capacity within the development. Would those tanks that you require under that condition also provide the firefighting capacity? Or would it just be additional to whatever can be taken from the network?
To talk to the firefighting capacity first, I would have to look into that further. My gut feel would be that that's not enough at 10,000 litres. But there would have to be an assessment done in terms of determine what we could get from the network, and then what in turn needs to be provided as residual on site for firefighting purposes. The 10,000 was taken as necessary for a day's supply for somebody or a family.
1 day.
Sorry, more than 1 day. Considering
Yeah, that's a lot of water in one day.
yeah, it was definitely more than 1 day. So it was, I think, 2.5 days when I did it.
It's still a lot of water.
Yeah. Yeah.
What's the average usage in napier per person, litres per day?
5. We're one of the highest in the country. We're just over 500 litres per person per day.
So, okay.
Yeah, I think it was. Yeah.
So if you have 4 people in a house, that's 1,000 litres per day. So a 10,000 litre storage tank gives you 10 days supply. Seems quite a lot.
If you have 4 people in the day at 500, yeah, you're right. It's 2,000.
That's 5 days supply, yeah.
5 days supply. So thank you for correcting me there.
No.
Appreciate that.
Okay.
But
Well, obviously, we look forward to hearing from Mr. Ellis as part of the reply on these issues, not to address now, but obviously there's some matters there that we certainly appreciate the applicant's response to, particularly the potable stormwater issue that has been identified as the issue of most concern. Yep. All right, that's good. Thank you.
Thank you.
Now, who's the other expert who's got a timing constraint? Oh, yeah. So, good afternoon, Mr. Markham. Can you hear us?
Yep, afternoon, Mr. Chair. Can hear loud and clear.
Excellent, and we can hear you. So, look, thank you very much for information you've provided, including the summary statement that you circulated recently. So, we've read that material, but you're very welcome to speak to it and highlight any issues that you'd like to bring to our attention.
Yeah, I'll be very brief. I think I was listening this morning to the opening and also had listened to Ms. Siverite this morning as well, presenting her evidence. I think there's only one area of not necessarily disagreement, but further information, just trying to get understanding of, and that's the coastal fringe setback between lots 19 and 48. And how that works in terms of penguin management and offsetting effects of the subdivision on penguin population. I think all the other matters that I've raised in my summary of evidence could potentially be bridged in detailed conditions that contain standards for all of the matters that I've raised.
All right, and no, thank you for that. So what we're going to receive in due course is a reply from the applicant where they will address matters raised during the hearing. So are you happy to work with the applicant's avian expert to resolve that outstanding matter that you've just mentioned?
Yes, yep, more than happy to work with Ms. Siverite on that matter.
Do you see that as resolvable?
Yes, I do. Just sort of on the understanding of distance inland that little blue penguins do go, that have been recorded and data collected from community groups around New Zealand, specifically in Wellington, Christchurch, and Nelson. So we have quite clear data about the length of inland travel that they do go, and so that's a great starting point for that discussion.
All right, now that's very helpful. So we'll see if we have any questions for you, but that's nice that you can do that further work for us.
No, but just to be clear on the outcome that you're seeking, at point D of your summary we received this morning. So it's really, it's the detail of the landscape plan for that foreshore planting, the restoration planting up to the red line. So it was just, did you have a difficulty understanding that from the landscape plan that we have in hand?
Yes, I've had difficulty measuring or understanding the scale of that plan to actually ascertain from the RL of the mean high water inland to where that restoration planting does go on lots 19 and 48.
Yes.
So just working with Ms. Siverite to actually understand that, to see if the current proposed restoration planting in that area reaches what's required, or does it need to be moved further closer to the red line to get to that maximum?
Yes. Okay.
I'm not saying take it to that red line. I'm just saying it may need to travel towards that red line a little bit further.
Yes. Okay. We've asked for that detail as well, but for different reasons. But I think our earlier request may assist with that. We've also sought a cross-section plan through that area that I think may also be of assistance to your consideration of that matter as well. Yep.
Thank you.
No, that's okay.
Good. Annette, any questions?
Thank you very much for your evidence. I was interested, I think, in point 6B, you mentioned developing predator control zones, and I just wonder if you could give me a little bit more information around your recommendation there.
Okay, so predator control zones. So that is virtually just getting an understanding of the area of predator control, whether it's just the coastal fringe foraging area and restoration planting, or does it continue further into the development? So that's sort of what I'm referring to in terms of zoning. And then within that zone, what is the density and layout of all of the traps and bait stations and things like that, and how does that work within the development with people that have domestic animals, and then the duration of when that predator control is going to be carried out for. And I've recommended that duration is set to the duration of the subdivision consent, as that's the effect that we are looking at.
Great, thank you.
Anything else?
No.
So just in terms of that issue, paragraph 6B of your summary statement, so I can't remember if the avian management plan does this already, but do you think then it would be useful to have as part of the avian management plan a map that shows where the predator control zones are and what predator control, what's the word I'm looking for, traps or whatever would be placed and how frequently they'll be monitored, etc.? Is that the kind of detail you're thinking of?
Yeah, I think so. I think the condition can provide pretty robust standards and areas and things like that. So when the avifauna management plan comes in for recertification, it's quite clear to the level of detail that's required. So I think that that's okay. Yeah. This morning I also heard the question raised about how does all of this work together in terms of pest control, potential further offsets, the coastal restoration area and things like that. So the intent would be that the avifauna management plan would integrate all of that on site and it for all to be done. And I heard Ms. Siverite allude to that this morning.
Right. Okay. All right, well, no further questions, but we look forward to the further work that you're going to do to assist us.
Thank you.
Thank you. So now I think We are now bouncing back to hear our last two submitters, correct? Correct. This is the most jumpy around hearing I've done for a long time. So.
Fun though, isn't it?
Fun? Yeah,
Keep you on your toes.
yeah. All right, so Mr. Peterson, do you want to come forward? Yes, just sit there. Now, just before you commence, we'd like to thank very much for the, I think it was 20-odd page document that you've prepared,
Yes.
which we've read and I personally found very interesting. We don't need you to read that out loud to us.
No.
We've carefully read it, and I'm sure my colleagues, as I have done, we've highlighted quite a few things in there that we'll refer to in part of our deliberations.
Right.
But no, you're very welcome to speak to that and to highlight your key points for us.
Thank you. I actually prefer standing up.
If you like.
And this is a much more larger venue than the old office in the council many years ago. That's now gone. Could you bring up the plan that's on the screen, please? The old plan. So I'm Alan Peterson. I've lived in Napier for about 24 years. I came down here to sort out Mur Place. I'm still here. I support the application, and I've made my submissions as someone who was a coordinator for the developer, but then was required no longer. So they're my own submissions. Why? Because I want to see the applicant and the application succeed. I have succeeded before only for outside factors to dramatically intervene. I succeeded to get Mur Place sections completed with some very difficult problems, and that was the reason the developer at the time got me down here. I succeeded to get the council's Variation 3 coastal hazard zone reduced at an appeal to the Environment Court in 2006. It took me 4 years to put that application together for the previous owner. There were 7 coastal hazard zone or coastal hazard experts involved. We had 2, plus 1 from the USA, who was considered to be one of the top coastal experts in the world. So we ended up with a 24-metre setback for the coastal hazard zone. Now, that's one of the reasons it's not a major concern at this hearing, because it's been sorted by the Environment Court based on the evidence that they got. There is now a setback, and you'll notice the offset at Gill Road, where all of a sudden the coastal hazard zone narrows down considerably. And if you go to Mur Place and you look along the frontage of the houses, they go right up to that coastal hazard zone. The other thing is there were restrictive covenants on that site that I put in place that don't allow fences to go any further beyond the houses. The other thing was that the coastline there was heavily modified by the developer before I got there, and that's why there's no scarp there. So that was at the time of that development was essentially the model for the current site. So when you look at the current proposal, it's kind of a repeat of what was done at Mur Place. So once we got the coastal hazard zone resolved, we were able to get the Mur Place development over the line. And what happened with that coastal hazard zone determination by the court, it actually allowed the owners at the time, Four Wheel Developments, to apply for a resource consent for a fully serviced or unserviced site, and the subdivision of 61 sections, which you can see on the screen. Now, one of the submitters is, I can understand why people on Rogers Road are concerned about losing the right to cross the railway line from Rogers Road. I can understand completely where they're coming from. The Kiwi Rail, or the previous entity, actually accepted that at the time. They made it very clear that they would not accept it this time round. And so the developer, and I've discussed this with Steve, they are quite happy for that to be reinstated, and it could be reinstated if the Bayview, the Rogers Road residents got together and went to the Kiwi Rail to see if they could get a temporary crossing at that point. So when the railway eventually operates, which it never will, they would then have to take that entry away, or that crossing away. That is something that the residents could sort out for themselves. And after the Environment Court decision on the coastal hazard line, we also had a Section 85 application based on that, and I've got that in my evidence. And that was advised by a chap called Mark Cooper, who's now just a retired High Court judge. However, the court decided that the council can essentially do what it likes in terms of rezoning. So when I first came down here, the zone for that land was deferred residential in the Bayview section plan. And that's what the owner at the time was relying on, because they did that by an application for a variation to the Bayview section plan. By the way, the first section plan that Napier City Council did. And so he relied on that for some time. When the district plan proposal in year 2000 was notified, we found overnight that that zone, without any pre-knowledge as a developer, had been reduced to main rural. And in my appendices, I've actually recently found the documents that were confidential to the council that explains how the council viewed the site. One, it had a very wide coastal hazard zone on it that almost went to the railway line, which meant you couldn't develop it. The council at the time was also paranoid about coastal hazard zones, and they relied on Dr. Gibb, who was discredited at the Environment Court case for being too precautionary on where the coastal hazard line should go. By the way, he did 4 at Mer Place, and they were all different, all wider. So it was critical to get that sorted out so that the subject site could be developed. Now, the court in its Section 85 didn't say that that being unsuccessful would prevent the owner, even with a main rural zone, actually applying for a resource consent for a development. So another 2 years of my input, we actually got that plan that you see on the screen or on your screens. I got that through for the developer. And so that was in 2008. It was by a Commissioner Gardner. And so I basically view this application as a re-application of what we had before. And it'll be very interesting to me, and I'm sure to others, to see how 3 independent commissioners will view it now. So I believe that the current proposal is an improvement, mostly an improvement on the previous application, and it's still in the same zone. It still basically has the same district plan to go by. And so I was the project manager that succeeded in getting an application for 61 sections on the seaward side of the site, and also for 12 sections on the other side of the railway line. Excuse me, that's my phone. Just kill it. So I've succeeded in all that, and then we got hit by the 2008 credit crunch, which meant the developer at the time could not finance the project any further. That meant that it was the actual liquidators of the mortgagor that sold the property, and very thankfully a local family bought it, and that's how Steve Brownlee got hold of the site. So that was the end of my involvement, and I can tell you that 15% of nothing is nothing. Oh, just by the way, I actually have a file from the council on that, Mr. Garland's the application we made for resource consent. That's the council's file. There is 1,000 pages in that. I suspect this one might be about 2,000 pages. And of course, the commissioner at the time granted the application subject to conditions. And this was made even though the site was zoned main rural. And one of the reasons is he took account of the fact that it was surrounded by residential development. Interesting enough, one of the comments I've made is because it's main rural, and I put my experience in, and I used to be a dairy farmer. I grew up on a farm. I was a horticulturalist, and I was a floriculturalist, and I did that for many years. I set up one of the largest greenhouse operations in New Zealand at the time with some other people. And so I put that in because I know from half of my life where you can grow stuff and where you can't. Now, in terms of the Brownlee family, they have been at Bayview for just after the war, and they used to be potato growers. They've become very successful orchardists. And by the way, Steve is very modest about it, but he's the largest orange grower in New Zealand. And that supports his business, which is homegrown juice. So they've owned it since 2011, and they never have once thought about they could grow any crop on that land. The only experience I've had is that one of the people from Gill Road, a lovely Maori man, he liked his pork and he had some pigs on the site. Just not very many, but there were complaints from the neighbours about the pigs. So he had to get rid of his pigs, and they probably ended up in a hungy. That's the only agricultural, rural production use of that site. And the other thing I would add is probably if you go right from the south end of Napier's boundary to the north end at the Esk River, you would find no examples of productive activities such as agriculture on the coastal gravel barrier. By the way, that reminds me, there was a couple of references this morning about dunes. There is no dunes on the coastal gravel barrier. That's what it is. It's gravel. So you go to Tauranga, there's heaps of dunes. That's partly the reason why the houses are set back so far from the beach, because of the moving sand dunes. This is not soil that is dune-like. It is mainly gravel. And I can tell you that we put a bore down to test the soils, and it's still there. And they drove a casing in, and with the driver, the post driver that we used to drive that 150 mil pipe in, you could not see it move. The ground is that tight. But the other thing is that it's got a very high level of permeability for the soakage of water. So going back to what the council has said before, do you know that the whole coastal strip of Bayview has been taken over by Napier City Council since 1989, and most of the wastewater systems along that coastline are non-complying. I don't know the exact figures, but I suspect it's under 10%. Why can that be in place for so long? Because there's so much ability of 7 metres above sea level of the gravel soils that can handle that amount of waste going in. So it's about time the council actually put in place a wastewater connection to their system. They've known about this for many, many years, and they only did the inland part of Bayview, which was lower. but they have neglected to do the job. And I can tell you that according to some of the contacts I've got in regional council, they're getting pretty grumpy about it. So when you look at the contamination of stormwater, it's only a fraction of what's going in there now. Now, the other thing is a chap called, a stormwater engineer called Takis Koutsos. He was an engineer for quite a while with the regional council. He was an expert in New Zealand on stormwater. So we made a big, kind of like a funnel. We employed him to look at the stormwater issues on the site. And we had a big funnel, and we put that into the ground, and we had a big water truck, and I was there. I was the guy that held the hose. We could not fill up that funnel because the water was going down so fast into the gravels that it didn't overflow the funnel. That whole gravel barrier has got an enormous potential for wastewater. I asked someone, why do we need to put a stormwater pipe system in? Oh, because it's in the code of practice. In actual fact, the stormwater could all go into sumps, into the gravel, and it would also help treat the wastewater. It doesn't have to go directly by pipes out to sea. Now, 6 years later, I'm here because this is a reapplication with 3 commissioners, which is great, to be determined whether it can be approved again. And I think the applicants have done an extraordinary job. They have essentially had experts to redo what I managed before, only at a higher level. And I was asked by Steve to be a coordinator of the 14 expert consultants that we had. And once the application had been delivered to council, I went and did some other work. So not much has really changed from when we first got that through. There is still a main rural zone. The land is just more weedy. And by the way, that reminds me that I, at the time, probably about 2003, completely flattened the site of any vegetation. I had a bulldozer, a bush bulldozer, which I drive myself, because one guy came along with his tractor and said he could clear it with his rubber-tyred tractor. He had 7 punctures in one day, prickly pear. So anyone that goes in there should have tracked vehicles. So I completely cleared the site, but I did not touch the coastal edge. And so all the vegetation you see there now is weeds that have grown since I did that work. And by the way, there doesn't look like anything that's very productive unless you wanted to make wine out of Right. Now, the other thing is that the applicant agreed that we needed a coastal hazard assessment, even though we had a coastal hazard line in place. It would be interesting to know what had happened since 2006 to now. And so Jim Darm is a geomorphologist. Tonkin and Taylor are essentially coastal engineers. There is quite a difference. So that is why Jim has come up, and his assessment is that that coastline that we're looking at hasn't eroded for the last 50 years. And so that's in his report. So that was a huge vindication of the coastal hazard zone done by the court. And by the way, I think it's the best report out of the 7 or 8 coastal hazard scientists I've known since I've been down here on various work, including a NIWA scientist, 2 NIWA scientists, and others. The people at Bayview, I advise them to look at the coastal hazard report by Jim Darm very carefully. They will realise that there is no risk for the next 100 years for that coastline to erode. and that they shouldn't accept their insurers saying that they need to increase the premiums because it's at risk. It is not. So has the district plan changed since the last application? Not by much. I don't think there's very many issues that actually impact on Bayview. But the council's working on it with the proposed district plan. And in the proposed district plan, I found out 2 days before the ending of submissions that they weren't just changing the name from main rural to main production zone, they were making a lot of changes. I had been previously advised that all they were doing was changing the name. So I did my submissions in 2 days and got them in on time. So the idea that you now call it rural production zone is, in my view, a planning aberration. It does not make sense. And I think that's the problem with the evidence by the council's planner, who's actually doing a comprehensive job, but all of her recommendations are based on it being main rural zone. It's surrounded by residential development. I took Mike and Mark down Rogers Road. They'd never visited the site. As we were driving down, I said, "Oh, what sort of environment is this?" They immediately said, both together, "This is a rural environment." Sorry, I got that wrong. This is a residential environment. So I think that tells a story. And inexplicably, the council want to retain it in the proposed district plan as a main production zone. And I've suggested that it's relevant that the you commissioners actually look at the submissions that we've made to that. You don't obviously want to make a decision about that, but the submissions that we put in are relevant to this application. It just seems, since the previous applications that I was involved in, that the bureaucracy of the RMA has become increasingly complex with more and more experts required. And I do realise that a coastal environment does require a higher level of expertise. And the other thing that we need to remember about the soils is it's classified by the applicant's expert as LUC 7. I've got 2 reports that I've put in my appendices from the previous application where that's agreed by another soil expert. So you probably know what LUC 7 means, but there's only LUC 8 above that, and that's essentially land that's useful for no production whatsoever. So in my view, it's not the planner who is representing the council who is the issue here. I think it's the issue is actually fairly on the Napier City Council itself for treating Bayview like an outlier of their city. And by the way, it takes the same time to get from Bayview as it does to get to Taradale. And so they seem to have a very, how can I put it, unrealistic view of how far it takes to go to different areas in Napier. It's one of the, I think it's the second smallest territorial authority in New Zealand. And I've met people in Napier who think, when I say I'm going to Hastings, they go, "Oh, you're going all the way to Hastings? Come on." Imagine trying to travel that distance in Auckland or Hamilton or Wellington or Christchurch. So it's been an absolute pleasure to assist the applicant. It's also been a pleasure to work with all the legal counsel and experts involved in all my involvements, and I wish them well. Finally, that's not quite finally, but just what I'm saying here, I pay tribute to all those who have worked on the Moore Place and Franklin Road projects, some retired and some no longer with us. And I pay tribute to the other side of the fence, which is the people in council who do their best in their jobs. I'm impressed with the way you've conducted the hearing, sir. But I do have a few comments from today. Yes, about blue penguins. I live on Napier Hill and I overlook the port, and I've been a submitter against noise and light impacts on our house and the residents, and so I keep them on their toes in terms of noise. And, you know, one of the recent developments with Port Wharf 6, they've got penguins down there. Now, I've been at my house, which has lots of port noise and lots of light all through the night. And one day I was doing some work outside and a seagull landed on my shoulder and put a beak in my ear. So we have seagulls come into that environment. When you look down on the port, you can see that a lot of seagulls actually live on the roofs of the buildings down there. There's penguins now at their little reserve area they've got. And so I've got some suggestions about penguins. Why don't we do that at the council's own reserve, for example? And by the way, in the 30 years I've been down here, the council has never, ever come up with any improvements of their reserve. And by the way, the little place you park at the end of Franklin Road on the beach is unofficial, Phil, and it actually projects beyond the scarp line, and it's actually on their reserve, so that it's not an official car park. And I think the council, as part of it, the applicant's development, could actually make that a much nicer space. I think flax is another wonderful plant for a coastal environment. You know, they bring in tuis, and it's just an incredible plant. And the other one's lancewood. I'm just about there. Acoustics, I'm interested because I actually like the sound of trains. You know they're coming, you know they go, and that's it. And they're grunty, just what I like. So I don't mind the sound of trains. And anyway, at Bayview, I think it'll be a rare occasion when you see the next train. By the way, a brother of the previous owner, to take it seriously, was killed by a train on the crossing at Gill Road. So railways that have few trains are actually more dangerous than railways that have lots of trains. One of the things about tsunami, the thing that's I've heard from coastal experts is that because of the extent of Mahia Peninsula and at the South Cape Kidnappers, that a tsunami that's most damaging to Napier would be one where you have a event almost straight out in line with those two arms. If it comes from the north or the south, the tsunami waves has to come around the corner, which reduces its velocity. And I've thought about it, and if there is a tsunami, it would overtop the coastal gravel barrier and then flood the inland areas. But the most dangerous aspect of tsunamis that we've seen overseas is when the water rushes out again. Strangely, in Hastings, the water would remain behind the raised gravel barrier and would take its time to get back out. And if I was on Moore Place or Franklin Road when it's developed, I'd just get up to the top story of my house. I think you'd be pretty safe. And by the way, the new flood map that's just come out, there is nothing in that well, that flood map does not go onto the coastal gravel barrier. And there's a wee spot, and if you've been out there, you've been to the Snapper Park, Top 10, and the cafe there. They got a little bit of flooding in that deeper area that's been excavated, and there was a bit of a puddle there. And that site where it's been dug out was actually a ballast pit for the construction of the railway. And the floor of it is 7 metres below the coastal gravel barrier. Just on traffic, Philip and I helped him with that, and he put traffic monitors on the road, which I monitored, looked after for him, and to do the traffic counts. So he's got a really good idea of that. Tanks on site, I'm a bit perplexed by some of the comments by the council's engineer. The effect on the water supply, I've never heard that before. It's only just come up. Surely that can be fixed by the council for Bayview. And there's also wastewater constraints, and that's a very common problem in New Zealand at the moment, because there's lots of developments, you probably know, around New Zealand that cannot proceed because they can't connect to a council system. I have a very, very expert friend and colleague, and we have designed an on-site system that will allow developers to proceed with developments, because it will treat the wastewater to a standard which exceeds current requirements, and manage nitrogen. Switch it on, switch it off. And so we only did that earlier this year. And actually, at one point, Napier City Council looked at setting up a wastewater plant out at Bayview. And, you know, I think that's something that should be re-looked at. And the other thing is that we hear from some of the council and regional council that the site was never considered as part of the growth area of Napier. But the ability of that site to have 60 odd houses on it has been known since 2008. And I'm disappointed to hear that people on Rogers Road have not been told that there had been a development there that had been approved, and they go and buy properties, and then all of a sudden they find out that there's been a development. That development has been known about since the railway sold it in 1989. That's me.
I'd just like to add a piece.
Oh, Christine, you can't.
No, I am. That's why this man would not accept an invitation to join the city council, because he's not a liar.
Okay, okay. Council, okay, she's my partner.
Yeah, understood.
She has to put up with me. Right, so questions, please.
Yeah, that's thank you. There's a very fulsome outline of the 20-page submission that you put together for our benefit, so thank you for that. Not sure if we have any questions for you, but I'll check. Any questions?
No.
Happy to.
We don't know much about the previous consent, but just very briefly, what's the improvement that has occurred in your view, the main improvement? Was it the same general layout, the previous?
Very similar. Well, it's a very tightly constrained site, and the width of the site is actually the biggest challenge, and so that's why, you know, we negotiated a 4-metre setback from the railway line instead of a 6-metre one. All right? That's why we've looked at a narrower road than what the code says for part of the site. You're trying to constrain between the coastal hazard line and the boundary of the railway. You're trying to make the most of that space. This doesn't answer your question, but I don't believe that an 800 square metre site or section is what you would call too, how can I put it? It's too high a density for a site like that.
Thank you.
And no further questions from me. Like I said at the start of your presentation, read your written material with interest, but I understood what you were saying, and there's nothing I need to clarify from you, so thank you very much.
Okay, thank you very much.
Thank you. Now, do we have Kiwi Rail available, or are they gone away somewhere?
I'm here.
There we go.
Excellent, Mark. Good afternoon. Thank you for your patience. I'm sure you've been sitting there for a while. You're our last submitter for the day, so we look forward to hearing from you. Anything you've pre-circulated, we've read, but you're very welcome to highlight any key issues that you have for us.
Thank you. I haven't actually pre-circulated anything, but the points I've got to make are very, very brief.
Sure.
Good afternoon. My name's Michelle Grinlinton Hancock, and I'm the manager of the RMA team at KiwiRail. And thank you for accommodating my appearance in line. I can tell you it's a beautiful sunny day in Wellington. With regard to this application, the applicant has been in correspondence with KiwiRail and has proffered conditions to meet the concerns raised in our submission. I've reviewed those conditions and confirmed with the applicant that they meet KiwiRail's needs. And I also know that the draft conditions provided by email from the hearings admin team contain those same conditions as agreed with the applicant. I can also confirm that the KiwiRail level crossing team has reviewed the LCSIA and no changes have been recommended or requested. And it is noted that the only comment that was made in relation to it was that the criteria 1 recommendation, to retain the stop sign controls seems reasonable based on the LCSIA findings. So a number of submitters have raised pedestrian access to the beach from Rogers Road being impeded by the development, with one noting that they have gates onto the railway line use that for access for walking or on quad bikes. I would note that the rail corridor is actually private land, not that it is often treated as such. There is one legal level crossing, and that is the one at Franklin Road. The other 17, which can be seen on the KiwiRail public GIS, are not legally established crossings, and the owners of the properties on Rogers Road actually have no legal right to use them. And with regard to those crossings, I've checked with the level crossing team, and although those crossings have been given an identifier in our system, they're not legally established, and should any one of those property owners come to us and ask for a deed of grant, then they wouldn't be given one, because in order to get a deed of grant, a person or a company needs to have legal ownership or occupation of land either side of the rail corridor in order to be given a deed of grant. Now, I acknowledge that the rail in this area in terms of trains is not running right now due to the 8 odd kilometres of track that was washed away in Esk Valley. However, the rail corridor needs to be treated as though it's still part of an operating corridor, as although there's no trains running currently, there may well be in the future, and the rail that remains is subject to inspection, maintenance and make safe works, and rail-enabled vehicles are used to do these inspections and repairs. So although there's no trains running per se, rail-enabled vehicles are still traversing the line currently. And I did note Mr. Peterson's comment about whether or not the rail would run again in the future or not. You will all probably be aware that KiwiRail has, as earlier this week, been given a new Minister of Rail, being Minister Winston Peters. So what that means for the future of the Palmerston North to Gisborne line, or the PNGL as we know it, remains to be seen. That's all I had to say, and I'm happy to answer any questions.
No, that's very clear, thank you. Richard, questions?
No, my only question was answered in that last statement. I wondered what the situation was, and I guess we all are. Thank you.
You're welcome.
Yeah, no, I agree. My substantive question's been answered by your comments. Thank you.
No, your presentation to us is crystal clear. Were you reading something out then, or was that all just ad lib?
No, I was reading something out and I'm happy to provide it to you.
Excellent. That was going to be my question. So thank you very much. If you could send that into our hearing administrator, we would appreciate that. Thank you.
You're welcome.
Thank
I'll
you.
do that for you.
All right. So now we're going to, at this stage of the hearing, we hear from the remaining 42A reporting team. So how many and who's speaking next?
One moment, please, Chair.
Yeah.
Do you want to speak to your colleagues? Do you want to vote?
Yeah. Well, it would take longer than that.
Megan McBain, landscape architect, with peer review from Rick Rose. Landscape and visual assessment.
5 minutes to get them together. Would you like Ms McBain to speak?
Well, just who do you intend to have speak to us? That's what I wanted to know. So,
Nobody other than myself
All right.
remains, I think. Let me just check my list. Right, go back to... Yes, no, nobody other than Ms Bain if you'd like to ask her any questions other than it be me.
all right. So who's the gentleman sitting to your right? No, your other right.
My right. That's Dave Curson, Napier City Council's Land Transport Manager. Please confirm that he doesn't have anything extra he'd like to say.
Okay. All right. So what we're going to do now then, since we have two people from the reporting team to speak to us, we'll take a 15-minute break. Then we'll hear from yourself and your landscape architect colleague. And then in terms of a reply, now, Mr. Dosberg, have you given any thought to whether you'd wish to do anything by way of verbal reply today, or would you prefer to do a full written reply in due course, or a mix?
I normally like a mix, but I feel like the issues that have arisen today are largely of detail and of information you need, and I'm conscious that in relation to conditions,
Yes.
the way it's unfolded, we regret that we haven't done it in a way that we could get your feedback today. So my proposal is, and also in the interest of time, to, if there's anything I need to address from the 42A officer, do it in 2 to 5 minutes orally, and then the rest in written.
Yeah, don't be concerned about the time. We're happy to, it's only 3:15 and we normally work till much later than that, so don't worry about that. That's fine. If you want to do a brief verbal reply, that's fine, but then of course a full written reply in due course. And obviously there's some work to be done between the applicant's experts and the council experts, certainly in terms of the avian bird management plan and other issues, and then you've got a bit of homework to do as well. And of course you get to see our next minute that we'll produce with our questions on the conditions. So I think that's a wise choice, brief verbal reply and a full written reply in due course. And maybe over the 15-minute break, I mean, it's hard for you to do this because you don't know how many questions we're going to pose to you about the conditions, but just a rough indication of timing of when the reply might be. Obviously, it won't be before Christmas. We appreciate that. Oh, no, it might be. Oh, good luck. But yeah, if you give some thought to that about when we might get the full written reply, we obviously taken into account the RMA close down period over the Christmas New Year break. All right, so we now will adjourn for 15 minutes, which means we'll come back at 3:35 where we hear from the remaining 42 reporting officers. Everyone, we're going to reconvene the hearing. It's spot on 3:35, and at this stage we're hearing from the remainder of the Section 42A reporting team, starting with Ms McBain.
Kia ora. My name is Megan McBain. I'm a registered landscape architect and partner at Wayfinder Landscape Planning and Strategy. As you're aware, I've authored the peer review of the Landscape Effects Assessment, or LEA, by Rebecca Ryder of Boffin-Miskell. And I have also provided supplementary landscape architectural addendum for this assessment. Much of this summary is focused on clearing up any ambiguity that there may be between the LEA and my peer review, considering that the assessment findings both conclude that the level of effects will be low and can be considered as less than minor. My initial peer review concluded that the LEA was undertaken with an appropriate methodology. It considered both the proposal and site context in sufficient detail and provided an assessment of effects. I concurred that the overall landscape effects for the proposed subdivision with the recommended landscape conditions as mitigation would be low, which could be considered as less than minor. I also agreed with the design recommendations, including materials, colour, hard surfacing, lighting, utilities, which warrants the addition of consents to be included should their consent be granted. The reliance of 3 to 5 years before the effects are reduced to low, and I would emphasise the recommendations of 7.1.1 to 7.1.4 as conditions of consent. This review mentioned that 2 criteria or information requirements were limited in their assessment, including landscape character and statutory analysis. However, while the landscape character was not always clear and analysis of the statutory provisions was brief, it was apparent that this assessment was sufficient enough to qualify the report's conclusions. I was then requested to undertake my own assessment on what was referred to as gaps that were identified in the LEA report, review the scale of analysis and methodology statement included as an appendix. I'd like to clarify that I found no gaps in the LEA report, but noted that the description of the elements, composition and activities that contribute to landscape character could have been more definitive between rural and coastal. However, within the landscape and visual evidence of Rebecca Ryder, dated 29th November, the landscape character has been addressed separately in the response to submissions regarding the loss of rural character and the loss of coastal character. And I am in agreement with the LEA rationale and conclusions. From a landscape and visual perspective, I consider this to be a well-considered proposal. I'm happy to answer any questions that you may have.
Yeah, thank you very much for that. Is there anything that you've heard today by way of questions and answers or from Ms Ryder herself that's led you to change any of those opinions at all?
No, it has not. No, I can concur with what she's reiterated today as what's in her evidence.
Right, thank you. I'll see if we have questions for you.
No, just we had a question about the detail in the landscape plan. Is that material that you would find of assistance, or did you sufficiently understand the overall scheme and its intent from what was provided?
The level of detail that's provided in the landscape plan is generally consistent with what's provided. I can understand, and I believe it warrants having more detailed landscape plan as that goes forward, in particular in regard to spacings. And so, you know, the request for that more detailed landscape planning and getting that signed off, as you will, through council, I would agree to that. Yeah.
Any?
No, thank you. I found your supplementary evidence fulsome. Thank you.
Thank you.
No further questions from me, but I'll just note your concluding comment that you consider this to be a well-considered proposal. From a landscape perspective, I assume that is. All right, thank you very much.
Welcome.
Kia ora, good afternoon. Through you, Chair, my name is Alison Francis. I'm the reporting planner for Napier City Council, and I've just got a few comments to make, as I've noted throughout today, taking us right back to the opening statements from the applicant's counsel, Mr. Dosberg. I note and appreciate the assessment of the objectives and policies, and I appreciate his comments about the Supreme Court directive at the moment, but I also confirm that both the applicant's team and ourselves at Napier City Council agree that policy 33.4.9 of the Operative District Plan cannot be met. Just a few points around the notes on the NPS urban development. It pushes councils to take the steps such as a future development strategy, rezoning, and then looking at development. And Mr. Dosberg noted that it doesn't have to follow those steps. I agree with that, but I'd like to point out, and we all know, that Napier City Council is currently going through those steps at the moment. They have a draft future development strategy out, and they're currently in hearings for their proposed district plan. And I have said this a number of times in the Section 42 report, that I would consider that to be a more appropriate way to achieve the density desired on this site. Objective 6 of the NPSUD says local authority decisions on urban development that affect urban environments are integrated with infrastructure planning and funding decisions and are strategic over the medium term and long term. And I think, again, that's where that pathway would be really appropriate. I wondered too, and I would like to make the point that the NPSUD considers urban development to be accessible. There are going to be various ways of looking at that, but I'm not sure that I would consider a subdivision with one road in and one road out next to a level crossing and away from any public transport to be accessible in terms of the NPSUD. And not to say that the road network doesn't work, it does, and I accept that. I thank the applicant's team for providing a marked up set of conditions, and I acknowledge that draft conditions were not circulated at the time of my Section 42A report. Focusing specifically on condition 84.2, which is the request that's come through from the Mana Ahuriri submission around managing cats on the property. My comment is in the draft set of conditions where I say that I feel like this will be very difficult to enforce. Applicant has come back and said this can be enforced by council. I don't work for the council's compliance team. I can imagine, however, that would be very difficult. Perhaps if this type of condition were to remain, it needs to be even more onerous and restrict pets altogether. Maybe an easy way to solve that problem. One other thing, just Mr. Dosberg commented on, and I know we're not referring to a permitted baseline for any assessment, but it has been talked about the various uses that could occur on this site in a rural sense, and that's accepted. However, I would say that, when we think about that, there could be a number of buildings built, like a big farm shed, that could block views. However, at present, under the Operative District Plan, the site coverage is limited to 10% or 2,500 squares of the net site area, whichever is lesser. So it is a large site, and you could have some really big buildings on there, but it is quite restricted at the moment under the Operative District Plan performance standards. Moving now to landscape and visual effects. I wish to acknowledge the evidence put forward by Ms. Ryder and Ms. McBain, and I accept and respect their positions as experts in landscape visual assessment. On that note, and given that no new evidence has been submitted, I wish to change my assessment of the landscape visual effects to minor. Moving away from landscape and visual effects, I am still uncertain of the effects of the overall built environment, as we still do not have agreed limits for performance standards, such as building coverage especially. Looking at the consent conditions that have been provided, we have height limits. We don't have anything specifically about yard setbacks or, like I said, percentage of building coverage, and that's something that I'd be happy to work further with the applicant on, and it's not really something that I'd thought about much until today. Just thinking about what the applicant has said, they've talked about, they understand that the underlying operative rural zoning and then the proposed rural productive zoning doesn't support the function of the type of development they're seeking to achieve. So they're proposing to adopt the performance standards of the current neighbouring zone, being the rural settlement zone. The limitations there is that the front yards for lots are 6 metre setback, and they require a 60% front yard landscaped permeable surface, but also they have a site coverage that cannot exceed 30%. If we're thinking about what the proposed district plan is telling us, the neighbouring lot residential areas will all be zoned rural lifestyle zone, which is significantly more restrictive than the settlement zone, having a minimum net site area for one dwelling at 2,500 squares, a front yard setback of 7.5 metres, side and rear yards of 6 metres, and building coverage of 10%. Where that really just gets me to is I feel like we haven't got enough information about how the future development will be managed, and there is a reliance on the surrounding residential zones, and the occurrence of the proposed district plan happening at the same time kind of muddies the waters a wee bit about what would be the appropriate zone to piggyback on were there to be specific performance standards provided for this development. And we would need a conditional consent notice to this effect, which I'm very happy to work through with the applicant on. With regards to ecology, following on from the expert witness statement from Mr Markham of Tonkin and Taylor and the applicant's expert witness, I'm satisfied that through agreed consent conditions, the effects on ecology, flora and fauna are minor, and all effects can be mitigated and managed through consent conditions. I change my assessment to minor effects. With regards to tsunami hazard, I concur with the experts, and for no other reason than they are the experts. The risk is low, and there are high points for escape in close proximity. However, should a tsunami occur, there is still a risk to those in the area that could be catastrophic, and increasing the number of residential dwellings by this extent only adds to that risk. I consider the risk to residents of tsunami hazard as minor. Next, I would, only there. With regards to the submitter, Ms Wilson, who lives at number 1 Lacane Road, I still believe that the effects on Ms Wilson with regards to her rural residential amenity are minor. I concur with the submitter, Ms Donoghue from 52 Rogers Road, about managing cats. I've already referred to that. I think that's going to be a very difficult thing to achieve. Getting there. With regards to cultural values, I think was the only other outstanding matter that I felt before this hearing was more than minor. I am satisfied that the submitter and the applicant have, that the applicant has worked with Mana Ahuriri, and that they have been in contact with them, and they've considered their submission and the proposed conditions as part of the set of conditions that have been offered. I'm satisfied that my assessment of effects for cultural effects is now minor. My assessment under section 104 has not changed, and I do not consider that the proposal is consistent with the following statutory documents: NPSUD, NZ Coastal Policy Statement, the Regional Policy Statement, the Napier City Council Operative District Plan, or the Napier City Council Proposed District Plan. I note specifically the following policies that require the avoidance of the following. In the New Zealand Coastal Policy Statement, Policy 25F, it requires the risk of tsunami. The proposal is not consistent with that, as the risk of the tsunami cannot be avoided or mitigated. In the Napier City Council Operative District Plan, further, and it's discussed previously, the proposal is not consistent with Policy 33.4.9, as the proposed subdivision is not within an identified residential greenfield growth area, and therefore the policy is clear: residential and rural residential subdivision and development is to be avoided. Further, the current policy work being undertaken by Napier City Council with regards to their proposed district plan and the future development strategy process provides a more appropriate pathway for this development, as it would allow a comprehensive review of the demand of housing in this area, and would also allow Napier City Council's engineers to appropriately plan for the future infrastructure requirements. While in terms of the gateway tests, and my assessment of effects has changed, and my assessment of effects under Section 95 is now minor, in considering the comments by the chair earlier in the day to have regard to the relevant objectives and policies, I consider that the application remains to be not consistent with any of the listed statutory documents. Therefore, my overall recommendation has not changed, and I continue to recommend that this consent is refused. Happy to take questions.
Thank you for that, Richard.
Just the issue that you raised about the standards to apply, because it does get kind of complicated. We've got a zone that has certain yard standards that I think your report has set out. It notes that it infringes those yards. It's not really put to us by how much, except presumably it would, through the consent notice, would then be enabled to go to a certain dimension, whether it's 1 metre or 3 metres or something. And then it ties those, as you say, to the rural settlement zone, which, from the nature of that, may be relevant or not, but as you say, doesn't include a building coverage standard, I think you said. Is that correct?
That's right. That would be the one thing that is omitted, and I think we probably need, especially when listening to Simon Bradshaw's evidence around stormwater, and he has suggested 50%, so potentially that's what it is, but before now we haven't had that percentage coverage.
So it strikes me, and our comments on conditions are to come, but it strikes me that it would be perhaps preferable to set those standards through the consent notice rather than a reference to another zone that doesn't apply to the site, and make it clear what it is we're being asked to consent to in terms of the current zone provisions. I understand it's a blanket approval that's being sought because there's no building platforms proposed, and I just raised that issue as I think where those conditions need to firm up as part of that. But I've heard your other comments. Thank you. So do I understand your position at the 104 point around 33.4.9 is that it's inconsistent and in 104 terms doesn't have sufficient regard to the operative plan? That's why you reach a position that it's contrary to it, or inconsistent, or doesn't have...
My position is because it's quite directive and says to avoid subdivision in the rural zone, and it does not meet that, so it is inconsistent with that policy.
Right. And that makes it inconsistent overall?
With the operative district plan? Yes. There are other policies that are also inconsistent, but that one to me, and when we talk about directive, that to me is the strongest measure that indicates that this level of development is not appropriate for this site.
Understood. Thank you.
Didn't quite follow what my colleague was saying to you about consent notices and stuff, but it appears to me that if we were to consider that on the merits and in terms of the expert evidence before us, that we should, notwithstanding the underlying zoning, grant the application. It would seem to me desirable to specify in conditions, and maybe this is what you were referring to, all of the matters that would normally be covered by the underlying zoning, such as front yards, side yards, site coverage, all that kind of stuff. It would be desirable to express that overtly in conditions of consent. Is that essentially what?
Yes, I agree. I would see that as being a consent notice, which...
what do you mean by consent notice? Why wouldn't it just be normal conditions?
Because when someone buys a lot, they don't have a design of a house, so they don't know what they're going to be building. They need to have those parameters or performance standards set. You would assume, if once they're buying it, that all of the subdivision conditions have been met, and essentially they are buying the title and everything that the subdivision requires them to do has been finished, and so the consent notice then gives them those performance standards and also helps to give direction to the council officers as to what to expect when a building consent comes in, basically.
So in any consent that we might grant, how would the condition look to nail all of that down?
So the ones I've seen previously is as simple as listing some performance standards that say that these are the performance standards for these lots, and it would have your yards and your height and your building percentage,
Yeah.
and it would also say that these override whatever the underlying zoning is, unless the underlying zoning is more permissive, which could occur
Right.
through the proposed district plan process.
Yeah. So that would just be expressed in a condition of consent. And then how does this consent notice align with that?
So that just falls down onto the title. So when the title is issued, it's just part of that.
So
So
would-
that allows the person who buys the lot to know what they're allowed to design to, what their
Yeah.
limits are.
So would there be a condition that would say consent notices shall or must be issued for each lot that impose the above standards? So it's
Yeah, I would see it just going in as part of condition 83, which has listed all of the different consent notices that are specific to do with the development. It's got a little bit of that in there already. Point J gives the following heights, and we just slip in some other yard and percentage building coverage there.
Yeah, rightio. Okay. All right, so and you're happy to work with the applicant on that, and I think that would be helpful because part of our consideration of whether or not we would grant consent, obviously we need to look at the conditions and the extent to which they might avoid, remedy or mitigate issues of concern, and having that fleshed out more fully in the condition would be helpful. Now, two questions that I asked during the hearing. One was in terms of financial conditions. I was requesting that as part of the applicant's reply, the respective positions of the applicant and the council are fully documented with reasons about what the financial contributions should be. So is council willing to work with the applicant in that regard?
Yes.
Yep. I'm not directing you to agree. If you do, that's wonderful, but if you don't, we just need to understand the reasons for the disagreement. And the other question I had, which has been raised in the evidence, I think of Mr. Stephen Brownlee, was that the site is rated as if it's a residential property. And I asked you to explain the rationale for that, because that seems quite odd. What's the rationale for that?
Yes, I have spoken to Beth Harker, Rates Team Leader, and she has confirmed that it is rural. It is a little confusing because the council's GIS mapping system does say residential, but I understand that directly above that it uses this number 3, and that 3 refers to rural, and it's because the site is over 5 hectares it gets that rural zoning, or not that rural assignment. And the rating system does not rely on the district plan zonings at all.
Okay. So is the short answer, although the rates bill looks quite large, it's not rated as a residential section?
That is correct. The property value is quite high.
Yeah. Yeah, that's interesting, isn't it? The next question would be, which of course you can't answer, is why is the property value so high? Probably because it has residential potential. Who knows? Okay. Now, just for the record, there was a late submission lodged by Ms Wilson, and I think in your 42A report you brought that to attention. We have no issue accepting that late submission, so that's just for the record. And in fact, we've heard from Mrs Wilson today, so it'd be a bit mean of us to not accept that late submission. And now I understand, Ms Dosberg, I've been advised that in terms of the statutory processing timeframes for the application, we're right on the margin. And so to accommodate our desire to issue a minute with lists of questions about the conditions, and then for you to do a full written response, that there would need to be an extension granted to under section 37 to the time frame, which is I understand, and I hope the applicant would be willing to accommodate that.
We consent, yes, sir.
You consent, that's wonderful, thank you. Now, this issue of cats, I'm a bit bemused by the amount of attention this has gained. There's a lot of houses around the area. I imagine a lot of those owners already have cats. We heard from one submitter today, she sees a lot of cats crossing the railway line and wandering around the place. the applicant's ecological expert said that there'll be a predator control program in place, and there's going to be further work done on that to flesh out the detail of that in terms of predator control zones and where traps might be set and how frequently they would be monitored. And we've also had evidence, I think, that notwithstanding some of the submitter evidence, some of which is direct observation and some hearsay, that little blue penguins might frequent the area. It does seem to me that there's been an undue concern placed on cats, just given the existing environment there and what might already be around. Why has that become such an issue, do you think?
Through you, Mr. Chair, because I think that is an unenforceable condition, and there's really, I just don't see why we would have that in there. The reason it's in there, and the applicant will respond, is because it was requested by Mana Ahuriri, and I understand their desire to want to meet all of Mana Ahuriri's conditions. And I think it's really fair. Cats are a pest, but you cannot enforce that.
No.
And I don't want to be party to putting together a set of conditions with something that is unenforceable and puts undue responsibility on the council.
Yeah, no, I understand that. So, Mr. Dobesberg, in your reply, maybe you could consider an alternative approach to this issue of cats whereby the further detail that's to be developed on predator control could explicitly address cats, so that if any feral cats or domestic cats stray into an area where we don't want them to be, the predator control program could address that rather than potentially imposing an unenforceable condition on property owners to control their cats. And I know the cats I've ever owned are pretty hard to retain within your section. And in fact, my section up on Napier Hill, all the neighbours' cats seem to love it. So I don't think cats can be easily controlled. So maybe just consider some alternatives to that.
Including a blanket ban?
Yes, that's one of the options, a blanket ban. Is that enforceable? I don't know. But yeah, give that some thought and come back to us in reply with some options. Yeah, I just checked with my, just in terms of timing, we will endeavour to get to you next week, which of course is the last working week of the year, our minute with our questions on conditions. Let's assume that we can do that. You'll then obviously need to take some time to work on your written reply. Do you have any, and there's no skin off our nose when you get your reply back in. You've accepted, you've granted a waiver on the Section 37 timeframe issue. So, but do you have a feel for when we might get the written reply? If we assume we can get our questions on the conditions to you next week.
I don't have a feel. Other than that, I was planning to take a holiday over summer. But
so were we. I think.
I figured you would be. Look. In terms of the homework that the applicant team has to do, there is a relatively extensive list. I don't think any of it's particularly hard, but there are parts that do require engagement, ideally, I think, with the council, particularly on FCs, and ideally to try and rationalise a set of conditions that hopefully has only a few points of difference. Assuming most folks are coming back into work the week of the 13th, which I think there might be one working day under the RMA the week before, but I think we'd be realistically targeting towards the end of January.
Yeah.
But can I suggest that I check in with the expert team for the applicant, particularly those that have homework to do, and we can perhaps respond once we have your minute and give you an indication as to time frame of response.
Yep. Yeah, that's absolutely fine. And the only reason I ask is because, as well as your work program, we have work programs too, and we have other hearing commitments, etc. So it'd be just nice to know when we might anticipate receiving that. The end of January would be fine if that's a rough time frame to work towards. Yeah, I'll just check with my colleagues. Is there anything else that you wish to raise at this stage in terms of the reply?
No, quite comfortable, thank you.
No. All right, so anything that you wish to add by way of conclusion, Mr. Dobesberg, at this stage?
Yes, just a few brief comments, I think. Firstly, I would like to acknowledge the approach by Ms. Francis in her Section 42A response. It is it is easy to retrench to the written material and just kind of stick to the position you've adopted, but I respect that she has considered the evidence provided by the applicant and the information provided by the council's own experts, and has acknowledged that in terms of adverse effects, at least from my notes, that landscape and character effects, she agrees with the landscape architects, and that those effects are minor or less than. I also acknowledge her concession that matters ecology are also minor and can be appropriately managed by conditions, albeit with a little bit of homework to be done on the AMP. Also, I acknowledge her concession that tsunami risk is also a minor adverse effect of this proposal. The concession was also made regarding cultural effects, which is appropriate and is once again acknowledged. From the 42A report, the effect that is left outstanding, I believe, that was identified as being more than minor is stormwater effects, and I think we did have a fair concession from the council's engineering team that one, there are no engineering constraints that are showstoppers, apart from potentially solving a potable water issue, which we can work together to do, and that from what I could tell, the engineering stormwater issue was really just making sure we either put a impervious area limit on the development or just put in bigger pipes. As you acknowledged, it's discharging to a rather big pond. We don't need to worry about flooding downstream properties. So with that in mind, my understanding of the evidence before you, at least between the council and the applicant's team, is that there are no effects here that are more than minor. We are working at that very low level of effect in terms of the effects of this proposal on the environment. We're through a gateway, at least on the council and the applicant side of things. Obviously, you'll need to consider what the submitters have said to you. Where that really leaves us is with the objectives and policies. And I do have to say, in terms of those that are left outstanding and those that were identified as being a hook, that Ms. Francis maintains her recommendation that this application should be declined, I don't think they support that conclusion. Policy 25F of the NZCPS is about avoiding or mitigating tsunami effects. Those are down to a minor threshold by Ms. Francis's own opinion, so those effects have been mitigated. You've got to remember, we talk about, in the modern era now, we talk about material harm as being the threshold for lowering effects too. We're not talking about eliminating all risk and all effects, and the RMA has never and is still not a no effects or a no risk statute. So my submission to you is that that policy is satisfied. In terms of the NPSUD, I accept that it directs and seeks to encourage a planned and integrated response, but it certainly doesn't mandate that applications like this that come through in this way must go through that process, and nor is there anything in the RMA that requires that. So to the extent that Ms. Francis's evidence to you is that the NPSUD is a more appropriate process, and there being a more appropriate process, somehow consent should be declined, I disagree, and I can cover the legal basis for that more in my written submissions in reply. That really leaves us with policy 33.4.9 of the ODP as being the hook, and I've addressed you on that in detail already, and I will, address it again in reply, but my submission to you remains that cannot be interpreted as being a de facto prohibit policy. Policies don't have that effect, certainly not in the modern era post-East-West Link. When it's properly engaged with in context with all of the other objectives and policies in this plan, I think it is incorrect to say that the ODP says you can only build rural residential or residential houses within the urban environment in greenfield growth areas, in those 6 or 8 areas that we've coloured a slightly different colour in Appendix 35 of the ODP. So that single policy certainly does not demand that this proposal is declined. Stepping back and acknowledging the questions and the concerns that were raised by submitters, many of them are understandable. These people have become accustomed to an environment that has a vacant site in front of them that they can use freely to access the beach. The applicant, while it does need to make the submission that its site is private property and there is no expectation to being able to cross it, the barrier is Kiwi Rail, who has its fair operational and safety concerns of people using the railway line. If that could be resolved and access could be given over Kiwi Rail's site to the road, and if it was vested as a public road rather than the suggestion that it be a private road of some kind, that access would be maintained, but that's out of our hands. And that's, in my submission, not something that would warrant decline of this consent. As to the concerns about little blue penguins that were raised by submitters, once again, it's understandable and it's laudable that the local community cares so much about the wildlife that it has in its backyard. But that evidence was largely anecdotal or hearsay, as you put it, and the applicant team has assessed that matter and has devised a conservative method for investigating and responding to any effects on that wildlife, and that's through the AMP. And as to its conservatism, I think you quite rightly explored in your questions, it manages issues like lighting, which, at least from my understanding of the evidence as it came out to you, is just a conservative approach. It's not actually grounded in the evidence that if we are lighting at night, we're going to be harming more penguins or other birds in this area. Then that really leaves the concerns raised by Ms. Wilson about her loss of rural character and rural amenity. And what I would say about that is I think you need to look at her property and what it is objectively. I appreciate that she may have a sense that she lives in a rural environment, particularly on the road she drives into to get to her house, with the Simply Squeezed Juice Factory and then coming past the vineyards, and that's a rural environment, but that part's not being changed by this proposal. What is proposed is to subdivide and develop this site that is sat vacant, that really is just for prickly pears and other exotic plants, into sites of the same size that Ms. Wilson enjoys, of around 800 square metres. My submission is that objectively her perception of loss of rural character and rural amenity won't come through in the real world. Then as to transport and noise effects on her, I think those have been explored thoroughly with the engineer, and there is a commitment, I think, that if there are safety and speed improvements that can be made when the work is being done on the road network by the applicant, that those will be investigated at the same time. Naturally, the applicant doesn't control the entire road network, but it's happy to do its bit and to work with the council to improve things where they can be done. Stepping back from all of that, my submission remains as it was to you at the start of the day. This is a well-designed, carefully considered proposal. It's been investigated thoroughly. I did enjoy the acknowledgement that it is very rare that a coastal scientist's work is agreed to by TNT as thoroughly as it has been in this case. They are known to look at things very closely, and I think that's a very good sign. This project, in my submission, quite obviously warrants consent. That's why it's had it in the past, and I will cover these matters again in our reply. But I guess all there is to say at the end is to thank you, commissioners, for the way you've run the hearing and the way you've conducted yourselves and asking the questions. Thank you. To the council, thank you as well, and to the submitters, who one remains, Mr. Peterson, and the others, thank them, and close by saying the applicant maintains that consent should be granted on conditions that will be filed with you hopefully by the end of January.
Yes, thank you very much for that. I hope you had your phone on record while you were saying all of that. Look forward to seeing all of that captured in your written reply, because we weren't taking any notes. So that brings us to the end of today. We won't adjourn the hearing until we receive the written reply. At that stage, we'll consider whether or not we require any further information. If we do, we'll issue a further minute to that effect. If we don't, which is probably more likely the case, we'll close the hearing at that stage. So thank you all very much for your input. and enjoy the rest of the day. Thank you.